All right, good morning, everyone. We are now up and running with Zoom and our live feed to viewing audience. We have a trial calendar to go through this morning. The jury that we go forward with will be selected on Thursday down in, I believe, 1D, but everyone who needs to be here on Thursday will come to 8D first. So we'll go through the calendar, see who's ready. If someone's not, why is that? And whether any of the cases have resolved. Our first position is Michael Reynolds. Mr. Reynolds here? He is. Mr. Cladis, good morning. Mr. Reynolds, have you and Mr. Cladis discussed Mr. Cladis's employment situation? So you understand that although I specially set this case and fully intended to go forward with the trial on Thursday, it wouldn't make a whole lot of sense to do that given Mr. Cladis's upcoming transition. So we're going to need to get you a new lawyer. I don't know if Mr. Cladis has an update on when he might have a replacement, but my experience recently is that will not happen quickly, unfortunately, for everyone involved in this very old case that we do need to try. So you're going to need to continue to come to court when you get a court notice. Mr. Cladis will remain your lawyer until he switches jobs, and then I trust his office will have someone who will stand in his place. That person understandably will need to learn a little bit about your case. I will not expect that lawyer to be ready to go on day one, but day soon after that, that lawyer is going to need to be ready to go. And I'll meet with him or her and help that person prioritize cases. But yours is old and it needs to be tried. Okay. Mr. Cladis, anything on behalf of Mr. Reynolds? Okay. Is there anyone here from the state who can talk about the Michael Reynolds case who wants to add anything? Let's just leave that one on all day. Thank you.
Good morning, Your Honor. ADA Charles on behalf of ADA Shapiro. And just to confirm that we will be ready when reached as soon as Mr. Reynolds gets representation. Okay.
And I trust someone has worked closely with the family of the deceased so they understand why this delay occurred.
Yes, Your Honor. That's my understanding.
Great. Okay. Mr. Reynolds, you are free to go. Position 2 is Angelo Holtz. My understanding is that Ms. Feely and Ms. Primovic was speaking on your behalf, very vigorously so, announced that you were ready with a capital R and an exclamation point after it.
She said what? I'm ready.
Still ready?
Yes.
Okay, good. That will be likely what we go out with on Thursday. Who is handling it for the state today?
ADA Charles, Your Honor. Good morning.
Mr. Whitenauer stood up behind your back too.
Good morning, Judge. So for purposes of 413 motion, it's my understanding that Your Honor wanted to do that this afternoon.
Today at some point, we'll get through the calendar. I don't want to keep folks here who don't need to be here, but today will be, Mr. Holt is here, I trust. We'll find out from our deputies in a minute, but he should be here. And so at some point today, we'll have the discussion about 413.
Yes, Judge. And I wanted to inquire of the court if, as in past cases, if Your Honor would be inclined to hear from the state of profit on that 413.
So yes, but it may well be as a result of that, we agree, or I conclude that the 3 witnesses / alleged victims will need to say some things under oath outside the presence of the jury so that we establish before the jury might hear something that the state could, by a preponderance, prove up the allegations. I think for Mr. Holt's purposes and the state's, we'll just need to understand the landscape and what the state believes the record will be, what the record will be when it's made. So I don't think you don't need to have the 3 alleged victims here today, but we'll need to talk about their availability and those kinds of things.
Understood. Thank you, Judge. And then secondly, I wanted to inquire if the court I understand that earlier during our informal calendar conference, Your Honor indicated that you were inclined to do jury selection on Thursday and then start with the presentation of evidence on Friday. I wanted to inquire of the court if you might entertain beginning presentation of the evidence on Tuesday. As this case is technically assigned to ADA Brown, I'm making that request on his behalf, and I wanted to see what Your Honor's thoughts were.
Okay. How long do you think the state's presentation will be? Assume for a minute that all the 413 comes in. So the longest possible presentation, it might accordion inward, but how long would that be?
Your Honor, I think 4 to 5 days, Judge, and I will tell the court and the defense counsel now that one of those 413 cases, the state's not going to be moving forward on. So it would only be 2, assuming a favorable ruling from the court, that we would be presenting to the jury.
Okay. So we'll sort out today what Friday might look like. It really depends on how long the trial is going to go, and I'll need to look at my schedule. Ms. Feely, do you think that the defense presentation beyond cross-examining state's witnesses, et cetera, would extend much beyond whatever the state's estimate is?
I think 4 to 5 days sounds accurate.
Okay. All right. So TBD. I won't wait till Friday to tell folks, but let's put that on the list of things to discuss when we do the 413. Ms. Charles stood up somewhat energetically about being ready to go. Will she be handling the 413 today, or will you, or do you guys need to go outside and duke it out?
We've already thought, Judge.
Okay.
And it's the plan that I'll be presenting proper on 413.
Okay.
My understanding, I hope that Mr. Brown and Ms. Charles will be handling the trial.
Okay. And Mr. Brown is due back in these great United States today. Okay.
All goes.
Does he know yet that he'll have a busy next year? Okay. Good.
Very aware.
All right. Thank you.
Thank you, Judge.
Quintavious Jackson has 2 cases. They are both yours.
We will probably plead for the court this morning to consider if I could have a word with Mr. Jackson before we go forward.
Sure, probably as in pretty darn likely, or, okay. Mr. Hiles, you agree?
Yes, I agree. And he does have those unindicted cases. There was not an issue of getting in front of the grand jury or accusing it. I chose not to because what was promised to me by APD has not come to my possession yet. And I'm not going to indict those cases until I have that.
Okay.
But I will be putting on the record to go over the plea that the unindicted charges will be encompassed and run concurrent with this offer. So we'll put that offer.
Okay. You don't have to go into all the specifics, and obviously Mr. Jackson needs to talk a little bit more with Mr. Cladis, but if the offer was going to get Mr. Jackson out of jail, does APD failure to get you what you had asked for mean that that won't happen until they do, or what has been negotiated?
So the offer won't get him out of jail. It will be the determination of the board of pardons and paroles as to
Okay, got it. That's all I'm getting at. So this little hiccup isn't going to disadvantage Mr. Jackson. You'll commit to what the resolution of the unindicted cases would be should Mr. Jackson want to resolve those after they are indicted, and that won't change his situation.
Yeah.
Is how I'm understanding it.
And I told APD, I said, look, I know y'all want these cases. I want them too, but you got a 2-week window. If you don't have it to me, then they're gone forever. So.
Okay. Look at you talking tough to APD. All right. So Mr. Cladis, when we're done calling the calendar, I'll make sure you can speak with Mr. Jackson. Thank you. Positions 5 through 7 are Mr. Hardiman. Hey, you're here.
I'm here.
That's a good, is that a good sign?
Yes, ma'am.
Okay. I hope so.
If we could come back to this one, I just need to speak to him. We're working towards a global resolution on all of these, in that case.
He has, I think you said, one unindicted case that is less serious than these
Yes.
by far. Okay. All right. Adonis Hurd. Hello, Mr. Harvey.
Good morning, Judge.
Good morning. How are you?
Good. was re-indicted. I don't know, do you know?
I do know that, and I was told, remembering that this has happened to you in the past, my first question was, does the defense know that this was coming? And I was told, yes. When I saw the proposed re-indictment, it didn't have the magic file number on it yet. It looked like it was a favorable change as opposed to, in terms of the seriousness of the charges, whereas you had once shared with me surprise when treason was added to a shoplifting case and you had no notice of that. This seems to be moving in the other direction.
Well, it is moving in the other direction. I don't know whether we had notice of it. I didn't. It just appeared, but be that as it may. I don't know where that puts us with regard to this calendar.
Well, I'm going to hear from Mr. Whitenauer because there is an open, active indictment that folks ought to be ready on, or we need to discuss why they aren't ready. If the state is moving forward, not on the 20 SC indictment, but this new one, then maybe we could have an arraignment and start that process. It won't reset us entirely. It's the same universe of evidence, and the issue about the railing being structurally deficient, all the things you've been researching. It just is a very different landscape for Mr. Hurd, given the penalty range.
It is, and I don't mind a rearrangement. But I also heard the announcements on one of the earlier cases, so I know Your Honor is going out. And that presents to me an issue with regard to, we've had a motion for bond modification and a request for a bond. The landscape is considerably changed because of the nature of the charges. Also, I know that there are civil suits by both of the parties against MARTA. There are destructive testing. There is destructive testing ongoing, I guess, this week. And if we don't try this case, I'd like to be heard on the issue of bond, and then a reset with regard to sometime after destructive testing has been done.
So destructive testing, tell me what you mean by that.
Beats me, that's civil stuff.
Yeah,
right?
As in they will be consuming some part of the railing to determine its tensile strength or whatnot.
And yes, that's
Okay.
what I understand. There's been preliminary examinations. We've provided the state with a preliminary report from one of the experts, but I understand that this week, I guess they're going to do some destructive testing.
Okay, well, let me hear from Mr. Whitenauer. First, do we have a new case number?
Judge, when I last checked, we did not, and we're checking now this morning. And I can tell you, it's not looking like a new indictment number has been assigned. Once one is assigned by the clerk's office, Judge, we would be moving to null pros the case on this calendar, moving forward on the new re-indictment. However, should this case be reached on this calendar, the state will be ready as the court calls it.
Okay. So maybe what we ought to do is when we have an indictment number, have in the very near future an arraignment. I think he needs to be arraigned on the new charges, but that could be a bond hearing as well, at which time we could discuss. I think I need an update because I did set a bond and it was called like Peanut Trail or Walnut Trail. There's some nut tree involved with an address. And I was told it was worth
Pecan Woods.
All right, there we go. And it wasn't worth what we thought it was worth.
That's right. But now we've got a different pending charge.
We do. No, that's why we ought to have with Mr. Hurd here, with the state knowing we're going to talk about bond, have that discussion.
Last time we were here, we all said, oh, we'll get right to that. And that was in February.
Well, so I've heard a bunch of different things. One was it's okay to slow this down coming from the defense because we're bringing in experts and we need time to work through the strength of the fence and whatnot. So I think there have been voices coming from different directions. What I see as the right next step would be to get Mr. Hurd in here for an arraignment, should the clerk's office ever get us a new indictment number. And at that arraignment, the state needs to be ready to discuss bond, because I know you're ready to discuss bond.
I am. I've got people here. I've got documents. How soon can we do that?
I'll get with Ms. Nelson after we work through this calendar to see what's happening the rest of the week. And we know how to find you.
Yeah. Okay, Judge.
All
Thank you. So we are off this trial calendar, I'm assuming.
Correct.
Okay, thank you. That's all. I don't think I have
You have,
don't think I have anything else.
don't have nothing else on this calendar.
I almost said that. You know, I almost said that, right? But I caught myself,
Did.
and that ain't right.
The filter is still sort of there. Good. Good seeing you.
Okay, see you, Judge. We have that other little matter coming up here kind of soon.
We do. Looking forward to that too. Positions 9 and 10 are co-defendants. Mr. Cano, I think I see back there. And then do we have Mr. Johnson? He was here? He's out in the hallway. Where's your lawyer? Is he iPhone?
No, Tom Ford, Mr. Cano.
There he is. Look at that mustache. All right. Let me. Okay.
Preston Halliburton.
You are. I thought you weren't going to be here. It's great that you're here.
I've got to go to another plea, but Renee's out here working on it. I just wanted to make sure everything.
Okay. I appreciate you helping with that transition. Ms. Nelson had alerted me that Ms. Rockwell might be here in your stead. And as long as Mr. Johnson is okay with that, I'm neutral.
I'm very grateful. I just want to clear it with you first. And if I could be excused to get to my other court.
Well, almost. Ms. Charles, this is your case?
Yes, Your Honor.
Is this a plea
Yes, Your Honor.
with both defendants?
Yes, Your Honor.
Okay, excellent.
Thank you.
All right. So what is Ms. Rockwell trying to sort out if it's a plea?
She was doing the paperwork.
Okay, just paperwork. All right. Mr. Ford, we will make a schedule in just a moment because our final position on this calendar, Mr. Copeland, has been null pros. So let's recap. We need to do the 413 hearing. We'll do that after we take pleas. We need to see if Mr. Jackson is going to be a plea. Mr. Cladis needs to speak with him. Ms. Wood needs to speak with Mr. Hardiman, could be some pleas. And then we've got, is it Cano? Did I say that right? Cano. I figured I'd get it wrong again. Mr. Cano and Mr. Johnson. I'll be ready to go whenever someone's ready to go. So I don't know if Ms. Charles, was it your plan to have Mr. Cano and Mr. Johnson plead at the same time for efficiency's sake because it's a similar resolution?
Yes, Your Honor.
Okay, then what we'll do, Mr. Ford, is as soon as Ms. Rockwell and her client, Mr. Johnson, are ready to go, then we'll take the Cano and Johnson plea, get you guys on your way. That'll give Ms. Wood and Mr. Cladis a chance to speak with their clients, and we'll go from there. Okay?
You know, may I suggest, I'm en route to Cherokee County. Can I have Mr. Cano just contact me whenever everyone's ready and I'll zoom back on?
Do you know how to reach Mr. Ford? He does. Yes, as long as you are reachable, Mr. Ford. My guess is it'll just be in a few minutes because Mr.
I'll just stay on the phone and keep driving. That's fine.
Okay. Sounds good.
Yes, sir. Thank you.
All right. Can they go see their clients? Great.
Anybody you need to see?
I just saw Mr. Holt yesterday, so I think he's good. Mr. Holt.
Is Mr. Jackson the last defendant in those cases?
Oh, yes.
Okay, Mr. Hiles knows.
Oh.
All right.
Little pain to not have that with you anymore.
We're trying to get rid of our 2018 indictments before we get to 2023. Are you Mr. Hand?
Yes, I probably should introduce myself.
How are you doing?
Good morning, Judge. I'm Pierce Hand. I'll be taking over.
Pierce Hand
88
fourth.
Charles. Yeah,
Good
yeah.
to meet you.
There are three of us out there. Well,
Well,
Only
hopefully
one
there are
left,
four
actually.
at some point.
there are one left besides myself. So only two.
Is it
unfortunately.
3 and 4 or 2 and 4?
2 and 4.
2 and 4.
Yeah,
All right.
yeah.
We've got some big shoes to fill.
I do. I intend to fill them though. So
Good. Well, we look forward to it. You're coming from non-complex,
I am
1 or 2?
one.
Is that DeFore
That
or
is
Borski?
four.
So Brooks and then Borski.
Yes, Your Honor.
Were you with Judge Brooks or you've only been in there since Judge Borski's been in there?
I was. I started with Judge Brooks.
Okay.
And moved to Borski afterwards.
And you were at AVLF originally,
I was. Yep.
doing what, which of their programs?
So they're safe and stable homes program. So landlord tenant court. So actually, my first bout with a lot of the magistrate judges were through AVLF, all of those landlord tenant cases.
Great.
And before that, private practice at Brian Cave, Leighton Payson.
When is it official here? October 1, September? Ms. Charles is
September
sketchy
5th.
about it.
September 5th is
Oh.
what we've been told.
Okay.
We just follow order, so.
No, I understand how that works. So that's Labor Day. So day after Labor Day, you're
That's it.
full-time here, in theory.
In theory.
Okay.
That's fine.
I was hoping to get a chance to chat with you and just learn about your expectations that you have for the courtroom and so forth at some point. So
We should do that.
hopefully we're able to do that.
Well, I'm sure Ms. Charles had told you all the bad things about it. I'll tell you the few good
No,
things.
she's only had great things.
Uh-huh.
That's made me very suspicious. but
Exactly.
she only
No,
had
come
great
here
things.
quick while I'm getting out of here.
Right, it's great. Come
Jump
on.
on this sinking ship.
But I am looking forward to it. I appreciate it.
Great.
If you're not, you're in the middle of your whole trial thing.
Yeah.
Ms. Charles, does Ms. Rockwell know that we're waiting on her? Just in case she's engaged in other business?
I'm concerned, I missed that.
Oh, I just wanted to know if Ms. Rockwell knew that we're waiting on her. Doesn't mean she needs to hurry up. It just means that if she's now off on some other tangent, time to reel her in.
She might need a few more minutes, right? But she's,
Are there issues?
we were just talking about the sentencing. So one of the issues with this case is the
Restitution, it's either like $1 million or like $50.
Correct. And so we was trying to figure out how to put that on the sentence sheet. So we're just declaration first, first issue.
Okay. Judge Downs sentenced so many people to forever on probation. She give these people these 10, 15-year probated sentences. So can we get them this 09 case? Come on. I don't think it would get reassigned for probation revocation. It would get reassigned if he filed like a motion for new trial or something like that. Yeah. So Ms. Wood, this other plea hasn't started yet. So if Hardiman's ready, I'm ready. And so
He needs to be brought out. He was farming, so.
oh, let's bring him out. Seems a little late in the game.
I agree, Judge.
Hardiman? Mr. Hardiman, come on up here to the podium, please. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. So let's go on the record in Mr. Hardiman's 3 cases. He's positions 5 through 7 on this trial calendar. Mr. Hardiman, I was under the impression, I think it's a mistaken impression now, that you were on the verge of resolving your cases. You've got a couple that are real serious, armed robbery and carjacking. Those both carry potential life sentences. Then you've got an aggravated assault case. So if you add all those up, that's 2 life sentences plus 20 years. And it sounds like you have an unindicted case for something that happened in the jail. That's not with me. It will end up here. But we need to figure out what to do. You've been sitting in jail for way too long. And it is time, you're on a trial calendar. So we're having this little conversation just so I can figure out what your plan is. The state is ready to go forward. They're ready, I think, to go, was it position 7, Ms. Charles? The more recent carjacking armed robbery allegation. They're ready to go. Going to trial is a right that you have, absolute right. You could make the state prosecute you on all 3 cases. It begins to become a little bit of a self-defeating process. If you're found guilty on the first, and I don't know what the outcome would be, but if it's 15 years to serve or whatnot, I guess you could continue to fight the others. But I was under the impression that Ms. Wood had negotiated for you a situation that was different than going to trial, and maybe you're found guilty, maybe you're not. Maybe the state 3 times in a row wouldn't find you guilty, wouldn't get the jury to find you guilty, but that Ms. Wood had negotiated something that resolved all your cases. She just came out looking kind of frustrated, saying, Mr. Hardiman wants to fire me. So I need you to tell me what's going on. If you're going to hire your own lawyer, you can fire away. But if you're not going to hire your own lawyer, you don't get to decide who your lawyer is.
I understand that, Your Honor. The only thing I'm saying is I haven't seen anything that's relating to my case. So it's like, to me, it's like how I'm going to plea out to something that I know nothing about, Your Honor. Well, last time Ms. Woods came to see me, she showed me things that was supposed to be related to my case, but they had no relation to my case at all, Your Honor. These are false accusations and false information.
Okay. So is it your preference that you go to trial?
No, sir. I don't even know. Like it's just it's difficult for me right now because I've never been in this type of situation, Your Honor.
Well, you say never. You have 3 different cases, so something's happened at least 3 times. It's not that it's one case. They're separated in time in terms of indictment, et cetera. And so you do have different situations. So something's happened to you more than once. But I guess the part I'm not understanding is you have 2 options. Because the state's not dismissing your cases. So they're there. You can work them out or you can go to trial. And if you choose to go to trial, which you have an absolute right to do, the state gets to decide which one it wants to try first. It usually picks the one that it feels most confident about. And they picked. They're ready to go forward on one of the carjacking, armed robbery, aggravated assault gun cases. So you either need to say, all right, let's do that. Or I don't particularly want to go to trial and I want Ms. Wood to work my case out as best she can, knowing that she's not a magician. She can't go to the DA's office and say, Mr. Hardiman wants a gold star and probation. She could say that, but I'm guessing that's not what the state would end up offering. So what do you have in mind?
I mean, I don't mind resolving my cases, but it's just like the matters that I'm trying to resolve them in, Your Honor, like I'm trying to ask for a program of probated sentence or something, Your Honor, because these accusations are actually false. Only reason I will plea out to these cases is because I'm trying to get back home to my family, to my kids, Your Honor.
Okay, but if they're false, why would you plead to? Why wouldn't you want to go to trial then and have? I mean, the state has the burden. They'd have to prove these things that you say are false. If they're false, they couldn't even do that. But
by the looks of it, Your Honor, it looked like I have no win at all.
Okay,
I'm lost.
Ms. Charles, what's the current offer from the state to resolve Mr. Hardiman's? I think it would be all 4 cases, but the serious ones are the indicted ones, not the unindicted one.
Yes, Your Honor. For all 4 cases, the state's offering 30 years to 20.
Okay, and the 20 were any of the counts to which Mr. Hardiman would be pleading armed robbery or carjacking?
Yes, Your Honor.
Okay, all right. So those are big numbers, Mr. Hardiman. I better understand now why you feel like you're kind of stuck. Those are big numbers. And they look particularly big if you're thinking the state should be offering you a program so you could go home. That's a big gulf. You want to get out now, and the state is saying 20 years, and those would be 20 years without parole. You've already done a chunk of that time, but not all of it. So that would be more time that you'd need to work through. I just need to figure out what we do next. It's not right for you to be stuck at Rice Street. Either you work the cases out, and Ms. Wood has been able to extract from the state the best deal she can, or we need to have a trial. There's not a third option.
So what's the minimum? Like, is it any way that I can get a split sentence? Because 30 to 20, that's something that I'm not even ready for, Your Honor.
Okay. Don't know how someone would get ready for that. Those are, like I said, big numbers. That happens to be a split sentence. A split sentence means you get some probation and some jail. That just happens to be a lot of jail and then 10 years of probation. Based on your charges, the lowest you could be sentenced to would be 10 years to serve. Armed robbery has a mandatory minimum of 10 years to serve. And so if this were a non-negotiated plea where Ms. Wood was able to ask for the lowest possible sentence, and the state would not be bound by that, they could ask for something more than 30 to do 20. The lowest Ms. Wood could go would be to ask for 10 years to serve. And I have to run everything concurrently. That's the floor. That's not where everyone is right now, but I'm guessing, I know nothing about your cases. I don't know if they're strong, weak, lots of evidence, alibis, no alibis, confessions, fingerprints, DNA, or no any of that. But given that the state is offering double the mandatory minimum, that says to me they think they've got some evidence out there. And I suspect your lawyer, who is very experienced at what she does, has looked at that evidence and has concluded that a trial would be complicated for you because of what the state would be able to present to a jury. And I hear you that you say they're false allegations, and that may be your dying belief that they're false allegations. But if the state has people who are going to come in and say, that's the guy who put a gun to my head and took my car, and I'm making this all up, but if 3 people are going to come in and say that, the jury could end up believing them. And you may know right here, that's not what happened. But for some reason, those folks are saying that. And if that's what the jury believes, then the jury may well come back and say guilty. And then you're working through a different situation. But I'm confident I'm not telling you something now that I'm confident that I'm not telling you anything right now that you and Ms. Wood haven't talked about. So I need you to be clear with me what it is you want to do.
Could I have just one more word with Ms. Woods?
You could have a bunch of words with Ms. Woods because some people just walked in that I need to talk with. So why don't you guys talk a little bit more, and then we'll see what's going to happen, whether we ought to try to get you this jury on Thursday for the third case, or if we're doing something else today. Okay?
Yes, sir.
All right.
Thank you, Judge.
Thank you, Ms. Wood. Hello, Mr. Wade.
Good morning, Judge.
Good morning.
Quick,
We need to chat?
yes, sir.
Okay, let's go into the jury room. Sarge, if you'd let me know once Ms. Rockwell is ready, then I'll know she's ready. But I need to talk with these folks about their issue. And then we'll take care of Mr. Johnson and Mr. Cano.
Yeah, I have text. Gonna get cool. I know what that feel like. So they did have the other people. Yes, and the female is downstairs. Okay. Yeah, how many pleas? Think about 3. They say, you know. I like to hear that. See? Oh, thank you. I'm struggling with this. What, the transition? Yes. What do you want to do? You want the great ethics? I say that name. Yeah. We'll see. I mean, it's issue and it's pretty. Thank you. I like the color. I want to see how it looks. I want to get a little bit of color. Oh, okay. Yeah, but it's gonna take a minute. Cause it's really just on the edges. Yeah. I don't know, we'll see what happens. Well, we got into the computer. Yeah, next. Where's somebody, Murphy today? Not Murphy. Oh. Well, I went back in time. Yeah, Gordon. Yeah, they got him in grand jury with these people. So that's what they get it. Since I have a training that's different 2 bodies. How we do it. Yeah. That's what people too. I don't know what he's gonna take me. And you know what, the guy told me, you know, we bring something in, we get but it got complete with mandate and you gotta stay. The person brought the person in, that is not the person quit, wants to get to the gym. You know, that's what I'm hearing about that jail. It's just, it's a whole thing. It's so crazy. See, when I was there, it wasn't like that. It was the mindset. You know, people knew what they did and they up against what they up against. These and they just say what they said. That's the mindset they got me in. They don't even care. You're going, taking on functions. Let's do that finish. Once you get I mean, because it's not a career to me, it's just a job. See, to us, it's a career, like in this state. You know, we had our 20-something. Well, they need to be fine. 8 tests for 80. That's the delivery. No. Where you gonna get the people to work with? Okay. Here, and as the. But I think what I also. Oh, yeah. When I first got into this line of field, I was going to jail in Washington. And the first thing they asked on that people, did you take a bullet? Yeah. Yes, 19 reason, no. This little girl shot in the head. Any guns? Yeah, that's right. They don't have any.
So now the seniors that. In no way.
Sorry.
Mr. Wade? Are we, Ms. Wood, are we ready?
Judge, Ms. Charles is going to speak to your supervisor, but I did submit a waiver of indictment, but we're not ready yet.
Okay.
Good. How are you doing? No, I'm not fortunate enough for that.
By the way, no, he's all, I'm not the person who's all here, not over 7 bounds on that one.
Who would I talk to?
Gary, Don, or Dimitri.
No.
So,
I don't have any.
yeah, I mean, I'm not even gonna put a foot in that one.
Okay. Can you tell me? I'm still, you said there's a Jackson. You know that you.
Remember the name.
Shot the guy.
Yeah, I remember that. But
Or do you still have your hands on? You caught him as concerned. You were like, I'm gonna do the thing. Talk to the victim and make it involved.
yeah, I need to follow up on that. She said she's gonna email me about. But she hasn't done that, so I'll follow
Well,
up
I
with her
don't
again.
know. That's not true.
Okay.
He gave her a watch or something.
What?
A watch,
Okay.
like a very nice, expensive watch.
Sure.
And he took it back.
Okay.
But now understand that the watch got some damage, water damage or something. So he took it back. Gets big.
I already emailed Marilyn. Do I still work here?
Return damaged watch.
But it's actually kind of good because I don't think I told her about, like, I didn't know when we had to submit our date for trial and hold. So that's why I pulled it up immediately, like, let me just see who I need to switch with on this.
She has not said that to me or communicated that to me. She probably with her, but I think she used, I asked her, has there been any intimidating or inappropriate contact? And she responded, just yes. So can you email me back? And I was busy with.
I know you've got some real things going on.
Well, okay, so I'll have to call.
Well, that's why I wasn't planning on being here all day. I can be there. So how do we know which of these camera angles is live stream right now? You got your laptop just
I don't know how you guys that big of really over there and playing.
If you think that APS case lasted a long time, you are. You just watch this mess.
I wonder if we talk, if it switches to us.
Not all of them, but a lot of them.
Are you supposed to be doing your work right now and I just distracted you? Are you supposed to be doing work right now and I just distracted you?
I'm trying to get him to watch him for a bond.
Okay, well then by all means, let's read the call.
Number 28. The last one on the list, what this came? The last one on the list. Jimmy Winfrey, P. Roscoe.
I had some machine along
That's,
That one
yeah,
case
you
is
gotta
full
worry
time.
about your own
yeah.
cases. What the heck are y'all doing? Charging all these kids with these gang cameras that are by themselves in a car with drugs and a gun. They're by themselves. And Chris
Which
Chris
one?
is so scared. He's so funny. So they charge my guy and they charge him with the gun case. Every charge, there's a gang cap with that charge. Blah, 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 blah. So the bond is like this high. So I'm like, Chris, why don't you drop some of those gang charges? And I can make a reasonable bond because all he's doing is getting moved to Peach County to go for a revocation. And he's like, why don't you just get him to plead guilty to the, because you know, why don't we just, so he just shot back to me. Why don't we just, and I was laughing, I'm like, what? He goes, what he gave me, what I was giving him.
Yeah. Yeah.
I got to make this into consideration. It's not frustrating, so I'm sorry. We've done everything that we could possibly think of.
There is a trial right now.
But not ours.
It's Yolanda Mack and the project.
Oh, it's not you. Remember, it's a state court judge?
Yeah, but I do
Might take
agree with the interviews, the sex assault cases. Of course,
Okay, yeah, different
Gina Rogers, was that in the year? Until the divorce and all of a sudden they child. You remember that? And then he was out to be the judge. Yeah. He's Jimmy, that's when this can do. It really happened.
They're my age. These kids are my age.
Oh. It happened. He was all the youth. All of a sudden.
Yeah.
She got around. I'm going to see Kevin. Just tell him if you see him, I'm going to come in.
Defense counsel went into his interview with the detective with its representation that the child was obviously happens and is therefore making it. And when that failed, they went to stage 2, which was she's doing this because she got in trouble for fraud. And then they went to stage 3, no, she's.
Court will now come to order, remain seated.
All right. Are we ready to go forward with Mr. Johnson and Mr. Cano?
Yes, sir. Alert Mr. Ford, who was in another Zoom.
Then Mr. Cano's job is to get Mr. Ford back on. So, Mr. Johnson, you should come on up to the podium. Mr. Cladis, are we good to go with Mr. Jackson?
Your Honor, we have a plea agreement. Everybody wants to do it. There may be a question about first offender and how it can be used with these cases that have not been indicted yet, and whether we'll have to address this before, I think.
Okay. He's getting his lawyer on Zoom, and then he's going to come up as well.
Madam Prosecutor, do you take this?
Why are we doing that?
Of the terms of probation, and the difference between the numbers
Oh, to have time to pay. When are we going to learn about restitution?
The issue is another number is whether it hasn't come back to the judge.
Okay, we'll work through it. There he is. Mr. Ford, if you could turn your camera on, and then why don't we have Mr. Cano, yeah, why don't you stand? Well, he needs to be heard. Well, that'll work. Yeah, if you'll just stand right there. There's Mr. Ford.
You want him at the counsel table, defense table, Judge?
Doesn't matter which table, just in front of a camera. He's good where he is. All right. So we've got, I think everyone we need. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Okay, and you've got a microphone that's on near you. Excellent. So this is positions 9 and 10. It's 22 SC 180840. It's State versus Ricardo Cano and John Johnson. Mr. Cano is represented by Mr. Ford, who is appearing virtually. Mr. Cano, do you waive your right to have Mr. Ford physically by your side during this plea?
I do, Your Honor.
Great. If at any point you need to speak with him privately, let me know. You can step outside the courtroom, get him on your phone, and you guys can have a private consultation.
Yes, Your Honor. Thank you.
Mr. Johnson is represented by Mr. Halliburton and by Ms. Rockwell. Mr. Halliburton was here earlier today, reaffirmed that he has asked Ms. Rockwell to assist as co-counsel in the taking of this plea. And Mr. Halliburton told me, Mr. Johnson, that you are perfectly comfortable with having Ms. Rockwell as co-counsel handle the plea for you. Is that true?
Yes, Your Honor.
Great. In a moment,
I
Ms.
did file an entry also.
You did? Okay. Officially co-counsel. Ms. Rockwell is licensed to practice in the state of Georgia and has done so for many years. So you're in okay hands, Mr. Johnson. Ms. Charles is going to put both of you under oath, Johnson and Cano, in just a moment. Once you're under oath, you'll need to answer all of Ms. Charles's questions truthfully and completely. If either of you have questions of your own, let me know, let your lawyer know, and we'll work through those. Because you are taking pleas simultaneously, Ms. Charles will address you individually. So the question will be, how far did you go in school, Mr. Cano? And he'll answer. Mr. Johnson, you'll answer. She'll go in whatever order she goes, but please wait till you hear your name called and then answer, but it will be the same question twice. That way we can do this in one setting rather than two consecutively. Does that work for you, Ms. Charles?
Yes, Your Honor.
All right, when you're ready.
Thank you, Your Honor. Mr. Cano, may you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Mr. Johnson, you may raise your hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Mr. Cano, please state your true, correct, and legal name.
Ricardo Andres Cano,
You spell that, please.
RICARDO ANDRES CANO.
Thank you. Mr. Johnson, can you please state your true, correct, and legal name and spell?
John Lee Johnson Jr., JOHN LEE JOHNSON JR.
Mr. Cano, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I am not.
Mr. Johnson, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you, Mr. Cano, and how far have you gone to school?
I am 30 years old and I graduated high school.
Mr. Johnson, how old are you and how far have you gone in school?
I'm 46 years old and I went through once I graduated high school and a little bit of college.
Mr. Cano, can you read, write, and understand the English language?
I can.
Mr. Johnson, can you read, write, and understand the English?
Yes, ma'am.
Do you understand, Mr. Cano, that you are being charged in indictment 22 SC 180840 with 2 counts of aggravated battery and 1 count of aggravated assault? And Mr. Johnson?
I do.
Mr. Johnson, are you aware that you're being charged in indictment 22 SC 180840 with 2 counts of aggravated battery and 1 count of aggravated assault?
I do.
Do you understand that you have the right to plead either guilty or not guilty to these charges, Mr. Cano? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Mr. Johnson, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Mr. Cano, have you reviewed the waiver of rights form of your attorney?
I have.
Counsel for Mr. Cano, Mr. Ford, do you waive formal reading of the indictment?
I do.
Mr. Cano, have you had enough time to speak with your lawyer, Mr. Ford, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Are you satisfied with Mr. Ford's services?
I am.
Do you need more time to discuss the case with your attorney?
I do not.
And Mr. Ford, do you waive any and all defects in the indictment?
We do, counsel.
Mr. Johnson, have you had enough time to review the waiver of rights of your attorney?
I have.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Very satisfied.
Counsel for Mr. Johnson, do you waive formal reading of the indictment?
So waived. I was wondering, should we have the indictment, Judge, to sign, or are you gonna?
I've already signed it electronically,
Okay.
and I'll be confirming that that's okay with you and your
Okay.
client, et cetera, when we get to that point.
Okay.
And Ms. Rockwell, do you waive any and all defects in the indictment?
For purposes of the plea, we so waive.
Mr. Cano, have you been arrested on these charges?
Yes, I have.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Cano, or your attorney know of any outstanding warrants that are related to these charges?
We know of none.
Mr. Johnson, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, not that we know of.
Mr. Cano, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes, he has.
For the record, aggravated battery, minimum 1 to 20 years for each count, and aggravated assault, 1 to 20 years.
Yes, ma'am.
Mr. Johnson, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes, ma'am.
And for the record, both counts of aggravated battery, minimum 1 year, maximum 20 years, aggravated assault, 1 to 20 years.
I've had a hearing, I'm on right now. So Caesar's done.
Well, do you understand that this is a negotiated plea of guilty, which means that the state will recommend a term of probation to restitution. The term of probation will be subject to the finalization of the restitution amount. There'll be some special conditions to include anger management, community service. But the court does not have to accept this recommendation. The court can sentence you the maximum on each charge and run the sentences consecutively, which means one after the other.
Yes, ma'am.
Mr. Johnson, do you understand this is a negotiated plea of guilty, which means that the state will recommend similarly a term of probation with restitution, and a term of probation will be contingent on the number of restitution that is owed in this case once we finalize it, along with the special conditions of anger management, community service. However, the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge and run those sentences consecutively or one after the other.
Yes, ma'am.
Mr. Cano, do you understand that this plea may be used to enhance sentencing in any other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Mr. Johnson, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
So what you can do, I know we're almost done. I should have said this earlier. You can ask the question once and then ask Mr. Cano to answer and ask Mr. Johnson, because they're listening. So, hey, do you understand this could have influence things in federal court? Mr. Cano, yes, I do. Mr. Johnson, yes, I do.
Okay. Mr. Cano, are you a U.S. citizen?
No, ma'am.
Do you understand if you're not a U.S. citizen, a guilty plea will affect your immigration status and will likely result in deportation, just like a conviction at trial would. And that is true regardless of any advice your attorney or anyone else has given you.
I do.
Mr. Johnson, are you a U.S. citizen?
I am.
Mr. Cano, Mr. Johnson, Mr. Cano first. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be following a conviction from trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, possess, receive, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison? Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act, Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act, Mr. Johnson?
No, ma'am.
Mr. Cano?
No, ma'am.
Have you ever pleaded guilty or nolo contendere, or ever been convicted of a felony in the state of Georgia or any other jurisdiction? Mr. Cano?
No, ma'am.
Mr. Johnson?
No, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment, Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty, Mr. Cano?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you went to trial, you would have had the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not incriminate yourself? Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of his charges after a trial. Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today, Mr. Cano?
No, ma'am.
Mr. Johnson?
No, ma'am.
Is it your decision, Mr. Cano, to waive these rights and enter a plea of guilty because you are in fact guilty?
Yes.
Mr. Johnson?
Yes, ma'am.
How do you plead to the charges of 2 counts of aggravated battery, 1 count of aggravated assault in indictment 22 SC 180840? Mr. Cano?
I plead guilty.
Mr. Johnson?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of all of the charges against you? Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction, Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea, Mr. Cano?
Yes, ma'am.
Mr. Johnson?
Yes, ma'am.
Your Honor, the state is unaware of any criminal history for either Mr. Johnson or Mr. Cano. This would be their first conviction. And had this case gone to trial, the state would have expected to show that on 4/28, officers responded to the North River Tavern Bar in Sandy Springs here in Fulton County on a call that there was a brawl in the bar. The victim, Mr. Taylor Cataldo, was seen on video having an encounter with both Mr. Johnson and Mr. Cano. There was a verbal dispute. According to the victim, it involved Mr. Taylor's former girlfriend who had some sort of relationship with Mr. Cano. There was a confrontation about some allegations that happened while he had been in a relationship with his former girlfriend who also worked at the bar. There were several confrontations where the victim, Mr. Taylor, tried to move away. At one point, there was some pushing and shoving. The bouncers sort of separated them and everybody sort of settled down. However, the video picks up at the end of the evening, Mr. Taylor is seen leaving the bar. Mr. Johnson and Mr. Cano follow him outside. There is another exchange of words for another couple of minutes. Mr. Taylor is seen sort of approaching Mr. Johnson. At that point, Mr. Johnson rears back his hand, cocks his hand and punches Mr. Taylor once in the jaw. Mr. Taylor falls to the ground. At this point, Mr. Cano runs up to Mr. Taylor, tackles him, and then Mr. Johnson comes back in. And for another 30 or 40 seconds, they're both punching him while he's on the ground, and Mr. Cano puts his hands around him briefly. But at that point, the bouncers were able to come up and separate the fight. Mr. Taylor then went to the hospital, and it turns out that his left jaw had been fractured. Mr. Taylor had to have surgery to repair his left mandible in his jaw. And in this instance, given the cost of surgery, Mr. Taylor also applied for the Judge of Victims of Crime Fund. All of his medical bills currently stand at a little over $82,000. There was an invoice we received stating that the fund had sort of adjusted $67,000 of that $82,000. I received a letter from the Judge of crimes fund, indicating a portion of that needed to be paid back, whatever he recovered in restitution. However, we were not sure what that portion was because the way it was listed on the invoice, some of the money received from the fund says payment, some says adjustment, which according to the hospital, it's a write-off, and so they're not entitled to be paid back. So we're trying to work through that. I'm finally able to get the specific claims adjuster who handled his case, and so we're trying to clarify that. Once that is clarified, that will direct how long probation would be, because we didn't want to put probation too short or too long to accommodate both Mr. Cano and Mr. Johnson being jointly and severally liable for the amount of restitution in this case.
What are the parameters? In other words, if it turns out it's 82,000 in restitution, is it 40 years probation, or what's the outer limit that you've been discussing with the lawyers? Because I assume it would just go down from there in terms of numbers of years of probation, the lower the amount of restitution.
Right. So if we're going for the full 82,000, I was looking at least 10 years, but perhaps a behavioral incentive if they were able to bring something up front. Speaking to Mr. Johnson's previous attorney, he's very motivated to sort of put this behind, make good and step up and take accountability for what he's caused. And so we would help to put a behavioral incentive that probation wouldn't be as much as 10 years, but we want to give them opportunity to do that.
Okay. All right. Ms. Toussaint, do you have any felony criminal history for either of these gentlemen in Georgia?
No, Judge, no record found for either defendant.
You know who Bradley Crawford is? He's on the call. Or if he was with pretrial services. Don't know. Okay. Well, why don't we start with you, Ms. Rockwell?
Thank you, Judge. For the record, you have heard that Mr. Johnson is 46 years of age. He was born in Orlando, Florida, went to Oconee County High, where he graduated in 1995. He also was in the Marine Corps from 1995 to 1998. He has a service-connected injury and a service-connected disability. He and his team were in Albania, hovering over the U.S. Embassy. The helicopter was not going to land. They were going to do a ramp exit. He was the first one down the ramp. Did not know that the helicopter and the ramp were 30 feet from the drop. He was connected with a scout snipers platoon, and they were, he almost lost his leg because they were in the middle of nowhere, and he shattered his left ankle. He has, and if you notice the plea sheet I've entered, he hasn't had any mental health issues. I did want to make note of the fact that he had PTSD because of an injury and because of pain, not because of, life and everything surrounding it. I did want to put that in front of the court as far as his past history. He then went to UGA, and college just wasn't a good fit for him. He studied a bit there, but opened his own company, and he's very fit and able. He's got a tree service, and ended up starting his own company when he spent about a year in South Louisiana after a hurricane, and that's what he does now. It's typically local. We would want to make note to Your Honor that sometimes his business takes him out of state when there's a big catastrophe like a hurricane. So he understands that whatever travel arrangements need to be made, he will be making that with probation. He is not married. He does not have any children, and has just moved to Woodstock, Georgia, for the purpose of reporting probation. I have gone over with him.
That last part I don't understand. Probation is everywhere. Why move to Woodstock for probation reporting purposes?
Just for the purpose of probation, they will tell him at some point where to start reporting. It won't be in downtown Fulton now. He'll be
Oh,
reporting.
you are letting me know. I get it. For probation's purposes, he lives in Cherokee, whatever county Woodstock is in, not in Fulton County.
Right.
Okay. He didn't move to Woodstock so he could be closer to probation. He moved to where he wanted to move. That happens to be in Cherokee.
I might talk him into moving back to be with our fine POs down here, but at any rate, I have gone over with him, Judge, the good and the bad of first offender. And I'll just put on the record that if he does everything he's supposed to do, he's technically can answer any job application. He's never been convicted of a crime.
Right.
Because of the party to the crime and everything he's charged with, in my estimation, I think the state would agree that his exposure could be 60 years. So he is well informed of that, and I think he's a good candidate. 46, coming in and taking responsibility. I would hope, this is still a matter for further discussion, that the restitution, that the probated part of the restitution would not be the entire amount to take care of the fund. That's just my prayer, that we can come down to what is owed to the plaintiff, if you will, or the victim in that civil suit, and not make it part of probation. They obviously can sue him. My understanding there is a civil suit per Madam Prosecutor. But at any rate, he's coming in on jury trial date. We discussed, and we hope it's okay with Your Honor, that we do the plea, the court accepts the plea, and then we come back for sentencing. It's not for a pretrial investigation or anything like that. It's the restitution that's sort of, we're just all over the place on it. So we ask that you accept the plea.
So I understand it's variable what the restitution will be. We know the upper limit, 82,000, can't be more than that, jointly and severally liable, could be down to maybe in the 20s or something. Why not go forward with a sentence now that is somewhere between being very conservative, saying, well, I'll give you 10 years. And I hear you say Mr. Johnson is very motivated to take care of this. And maybe an aggressive would be, I think I could pay my half in 3 years and say 5 years probation. If it turns out that the restitution amount is very different from what people were thinking, we could always modify or amend the sentence to lower the period of probation. We wouldn't need to bring everyone back here. Wouldn't need to change any of the other conditions. I could affirm today, first offender or not, and people would leave with much more certainty. The only thing we'd be tweaking would be what is the length of the probation.
That's
and I remain open to that because I don't want this dollar amount to be a tripwire for trouble.
I understand. The only thing I would say to that, Judge, and I would love that,
Okay.
to wrap it up today so everybody leaves with some expectation. My understanding, the way I explained it to Mr. Johnson, is that because it's jointly and severally liability, if Mr. Johnson decided not to pay a dime, then it's all on Mr.
Cano. Yes.
Vice versa. If somebody gets hit by a bus walking out, then half of it doesn't disappear. So each person's going to owe the entire amount.
But there won't be double recovery. It won't be, I don't know why it was negotiated that way. I don't get in the middle of that. Another approach would be to say, Mr. Johnson has a $41,000 restitution liability today and X years to pay it off. When we get to the bottom of what is that actual amount, I modify the sentence to say, actually, it's not 41, it's 20 because the total restitution is 40. And maybe I move the probation, maybe I don't. I might put in a behavioral incentive date, but I'm going to listen to everyone. I get the sense I could say you're going to prison for 20 years. That's not going to happen. But that just, so I hear you on that. I just want to make sure if I fashion it in a certain way, it's not going to hamstring the state or one of the defendants in a way that they hadn't been contemplating when discussing this.
And I'm open to your own fashion. And that way, I think when I talked to Mr. Halliburton, he was just very, there was a lot of pushback in the sense of wanted just some more certainty, because it's a lot of money. And
Sure.
we have been asking for a lump sum upfront, you know. And
Okay.
so, but if your honor is okay to make the modification, you know, how about your.
All right, I'm just thinking it through. All right. Mr. Johnson, how did you know Mr. Cano, or was he a stranger to you that night?
I've seen him out and about in the same area, but they really, besides that, nothing.
Now that night, this April 28th, would you have been able to tell me his name? Like, hey, who's that guy you're hanging out with? No, you just recognized, at least you recognized him.
Just from being out every now and then, just kind of recognize him. Yes, sir.
Okay. And was the issue between you and Mr. Cataldo, or Mr. Cano and Mr. Cataldo initially, the initial?
Cataldo's the victim.
Yes.
It was between us originally inside.
Us meaning you and he, or the three of you?
No, the victim.
Okay.
The guy that I hit.
Okay, so it wasn't involving, I'll ask him in a minute, but it wasn't involving Mr. Cano. He, for whatever reason, joined you outside.
We were outside with a group of people that I knew other people that were there.
Knew by name.
Other people by name, not
Okay.
not necessarily him.
Okay, got it. Okay.
And just for the record, Judge, you can see, and I will say this, I didn't want it to be a deal breaker that we took an offered plea. We do have some disagreement in the facts. He is taking responsibility, Mr. Johnson is, but there was some disagreements in the facts but it's not anything.
Just heard your client say,
Right.
the guy I hit, so I'm not hearing an
Oh, no,
offered
no.
plea from your
He
client.
hit the fella,
Okay.
but in just what led up to this and that, there was
Okay.
some question and a bit of disagreement, not enough to go to trial over.
It doesn't sound like it would have justified it as in self-defense or anything like that. It could have been who said what, whose girlfriend was it, but in the end, it's not, I'm reaching for my gun, Mr. Cataldo, and that's why your client did what he did. That's not the situation. Okay, I understand. Mr. Johnson, I know your lawyers talked to you about this, but I need to as well. First offender is primarily an opportunity. It is something that someone who has not been convicted of a felony before can take. It means that even if I sentence you today and you walk out the door under sentence, you are not a convicted felon. You will remain not a convicted felon unless and until your probation in this case gets revoked because you do something real unwise, and it would not be you couldn't pay the restitution. It would be you get another fight and you break another jaw. Then not only do you have a new case, but we come back in here, I would take away your first offender status, and without a trial, because you've already said I did these things, I could resentence you, potentially up to 60 years. Now, you would have to really do something crazy with your new case for that to happen, but it wouldn't surprise me, and so it shouldn't surprise you, that if we're together again in a year and you were outside another bar and you broke a chair over someone's head, you got that new case, you're going away for 3-4 years on this case because you took first offender and everyone invested in you as this is not something that's ever going to happen again. That's the downside of first offender. If you're pretty confident that you're not going to get sideways with the law while you're under this sentence, then it's a great opportunity for work, for anything else, because you're not a convicted felon.
Yes, sir.
Do you feel like you understand the benefit of first offender?
I do. Yes,
The
sir.
risk of first offender?
I understand that too, Your Honor.
Do you want to pursue first offender status?
Yes, sir.
All right. Remember what we just talked about, because I'm going to ask you the same thing, Mr. Cano. All right. I don't have any other questions for Mr. Johnson. Mr. Ford, what do you want to tell me about your client, if anything?
Yeah, Mr. Cano is 30 years old. I've got to tell you, when he first hired me, he may have disclosed he was not a U.S. citizen. And I would have said you have to have immigration counsel before you go forward with this, because I'm not immigration counsel. And we have not discussed that if that was disclosed. I'm not conceding that it was, but if it was, we've not discussed his immigration status since then. And I am very concerned that this would result in deportation. He needs to have immigration counsel that he's spoken to, hired, who have advised him on the impact of this plea, respectfully, before he goes forward, unless he's done so.
Okay, well, let me talk to him about that. So, Mr. Cano, you mentioned that you're not a U.S. citizen. What is your immigration status here?
I'm a permanent resident.
Okay. And what is your home country?
Colombia.
Okay. Have you consulted with anyone other than Mr. Ford, who is correct? He's an expert of many things. He's not an immigration lawyer. Have you consulted with anyone about the possible impact of a first offender disposition in this case?
Well, I tried getting in touch with a few immigration attorneys, and they all said that until this case was resolved, there was nothing they could do for me on a pending felony case.
A pending what?
Like a felony case, a criminal case,
Okay.
without a resolution.
Okay. So the question is a little different, though, and I appreciate Mr. Ford's concern. It's not so much that you might hire them in the sense that you pay them for the time that you have this conversation, but an immigration law expert would be in a better position to give you his or her thoughts on what the impact of this plea would be. Ms. Charles said exactly what she should, which is you should assume the worst possible, that you would be deported because of this. Is that what happens? I don't know. Ms. Charles doesn't know. Mr. Ford doesn't know. We'd be speculating. And so we need to assume the worst so that you know, well, if I go forward, the worst thing that could happen would be I am removed from the United States. Your immigration law expert could give you the likelihood of that happening. And variables are, was it a conviction? First offender is not a conviction. And so that might improve your chances of staying here. Don't know, not giving you that advice. What was the nature of the offense? There are all sorts of variables that an immigration law could help you weigh to say, here are the chances this will go well, i.e. you maintain your permanent resident status, or it doesn't go so well and you would lose that status. I can't give you any advice on that, nor should I, even if I could. Mr. Ford is making very clear, as he should, not his area of expertise. So you need to decide whether you want to go forward knowing that you could be removed from this country as a result of this plea, or if you want to pause and engage an immigration law expert, not to represent you, not to replace Mr. Ford. He's the criminal law expert, but to give you that advice of, if you go forward, here are the 5 possible outcomes, or 10. And here's what's most likely, given first offender, aggravated battery, or whatever. That's your call. It's not Mr. Ford's. It's not mine. You may want to pursue this opportunity now, and then you'll go to an immigration lawyer saying, here's what's happened. I have entered a plea. I got first offender. What do I need to prepare myself for?
I would like to go forward with the plea that we're with the first offender plea. When I spoke to the immigration lawyer, he did tell me that once we had some kind of resolution, we never talked about the first offender, but he said that worst case scenario was if either I went to trial and I was found guilty, or I pleaded guilty and became under felony status. So he said those were the 2 worst things that could happen to me. Everything else after that could be resolved.
Okay. All right. So you've actually had some consultations with someone, and based on those consultations, you're comfortable proceeding with assuming it's first offender, going forward with first offender.
Yes, Your Honor.
Okay. Mr. Ford, yes, I was going to turn back to you.
I do not intend to inject a fly into your appointment. I do need Mr. Cano to understand that the first offender plea is not under any analysis protecting from deportation. And I would strongly advise him, if you are inclined to allow him to tender this plea at any date other than this moment, that subsequent to leaving the courthouse today, he will go put money into the hands of competent immigration counsel. And with me on the phone, we will articulate what his position is so that he is fully advised as to what the impact of this plea will be. I know he is desirous of resolving this today because he's on a trial calendar. He's got exposure of 60 years and a man with an $80,000 broken jaw. He has been primarily concerned about becoming a convicted felon and going to prison. That's probably why he's failed to mention to me in the exhaustive discussions we've had for the past 2 years his immigration status. I would urge Mr. Cano to recognize the value of not going forward today if you'd be inclined to allow a plea at any subsequent date. We can be ready in 3 days, 2 days.
Okay. So, Mr. Cano, assuming that I will leave open, we won't need to repeat this whole conversation. We've already made a record that you're waiving your rights, et cetera. But assuming that I'll leave open the opportunity to pursue a first offender disposition that would be structured pretty identically, and you'll be able to hear what happens with Mr. Johnson in a minute. will you take Mr. Ford up on his advice and recommendation and have a three-way conversation, you, Mr. Ford, and an immigration attorney of your choosing?
I do, Your Honor.
Okay, why don't we do that? So we're going to pause your proceedings. We've made a record of everything, and we'll reconvene after that's happened. But you stay right there because I want to pivot back to Mr. Johnson. So, Mr. Johnson, yes, sir, Mr. Ford.
One last point, Your Honor. And I would also encourage, Your Honor, in the context of evaluating the allocation of responsibility here and vis-a-vis what the restitution amount per defendant might be, if you are inclined, rather than going forward with a joint several for such a large number, if there's a percentage of responsibility allocated to each of the accused relative to their restitution responsibility, 85%, 15, 70%, 30, I think you understand what I'm suggesting. That would make for a cleaner sentence, respectfully. I'll stand mute.
Okay. All right. Mr. Johnson, anything more you wanted to add?
No, sir.
All right. I find there's a factual basis for your plea and that your plea is knowing and voluntary. Knowing means that you've understood all the things we talked about. And if you didn't, you nudged Ms. Rockwell or raised your hand, but I don't feel like there was anything you were confused about. But tell me any questions about anything we've covered.
No, Your Honor.
All right. Voluntary means that you're up here of your own free will, and that you've received good advice from two lawyers, but ultimately it's your decision to go forward with the plea, and that's what you want to do.
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, and all that means is that while you're on probation, if you have a technical violation with probation, maybe you miss a meeting or you and probation agree on a payment schedule and you fall a little bit behind because work isn't going well, or you have an unforeseen bill, you and probation work that out. We don't need to do that. You will come back in front of me if you get arrested for anything. DUI on up to you shoot someone in the head. That's coming back here, and we'll work through the consequences to your plea in this case, in that setting. I will sentence you as a first offender. I think it fits. You're not old, but you're not young, and this is your first offense. If you were 21, it'd be a different conversation. Or if you had had a whole bunch of arrests and they hadn't quite resulted in a felony, it might be a different calculus. But I will sentence you as a first offender. What I'm going to do for now, Mr. Johnson, is sentence you to 5 years to serve on each of the 3 counts. And I'll run those concurrently with each other, and I'll probate those 5 years. So it's a 5-year probated sentence. And I'm going to set restitution at $41,000. That amount may go down based on what you, your lawyers, and the prosecutor learn about reimbursement and this and that. That's the maximum amount. Do you feel like paying that off over the course of 5 years is reasonable? Because I'm happy to start with a higher number of years of probation. I don't mean to saddle you with debt that means you can't feed yourself, take care of other family members or whatever.
I think 5 years is fair, Your Honor.
Okay. And it's not meant to be unfair. I
agree with that.
Okay. All right. You and probation will sort out a payment schedule. It is not that you have to write a check for $20,000 week 1 and $20,000 week 2.
Right.
But you are able to pay it off early. If you literally win the lottery, and one thing you want to do is pay it off, you do not need to wait for all 5 years. I will encourage probation to consider you shifting over to non or unsupervised probation as soon as you've paid that off, an incentive to do that. You will need to take an anger management course, and you will be required to do 80 hours of community service, like the restitution. That doesn't need to be week 1, but that's a period of community service you'll want to take care of. The sooner you check those boxes, the sooner probation will say, you know what, we've got people on probation who are high maintenance. Mr. Johnson is not one of those. Let's make him non-reporting or an even better status for you. You are not jointly and severally liable. You're liable for that amount that I've set. That's what you need to pay. Whether Mr. Cano pays his off in one fell swoop does not affect your liability. The only thing that will change that $41,000 will be if we learn from the district attorney's office that that 82 was truly the outer limits and what is now owed is something less. And then I will amend your sentence to lower that restitution amount. If it drops down to a particularly small number, we can talk about whether I'm going to shrink the probation. I don't know that I will, because I think 5 years probation is a reasonable time for you to demonstrate to everyone that this was an aberration and you've earned your first offender, and for 5 years you stay out of harm's way. So I probably won't lower it, but I'm open to that discussion if we need to have it. Were there any other conditions? I guess no contact with Mr. Cataldo. I know he's largely a stranger to you, but in this day and age, it's pretty easy to find people. Don't find him. Don't find him to say, I'm sorry. Don't find him to say, I'm going to get the right side of your face. You leave him alone and he goes about his business. Okay?
Yes, sir.
All right. Ms. Charles, anything else about Mr. Johnson's case? Ms. Rockwell.
Maybe not go back to the spot, Judge, the incident location.
Yeah. Any reason you'd need to be in Sandy Springs?
Not happening. Just for work, but not going
Okay.
out.
What was the name of the bar?
North River Tavern.
Okay. North River Tavern. So stay away from the North River Tavern in Sandy Springs. If they've got trees that fall on them, someone else has to cut those trees, not you.
Yes, sir.
You go to South River Tavern, not North River Tavern. All right. That'll be your sentence. And your final disposition. We need to get your, Ms. Toussaint's here now. Ms. Toussaint is with probation. She will not be your probation officer. She's going to give you reporting instructions, which will be Cherokee County, because Mr. Johnson is now a resident of Woodstock.
Two things regarding probation, Judge. I know back in the day, they used to like to give you half the amount of time to pay your restitution. That gives probation the other half of the amount of time to run after you and catch you. So would you allow on the sentence that he still has the entire amount of time? I don't want him to wait till the last minute.
No, neither do I. But that's a great point. So Mr. Johnson has the entire 5 years to pay restitution.
And lastly, if Madam Probation, who may not have heard everything, he does have to travel out of state.
Right.
He will give her his schedule, his work orders, whatever. Just FYI, I don't want him not to be able to work.
No, I will add that it is a condition of Mr. Johnson's probation that out-of-state travel for work is permissible, provided that Mr. Johnson submits written verification of the need for out-of-state travel at least 48 hours in advance. Is 48 hours a reasonable time?
Yes, sir. Usually if a hurricane's on the way, we know within about that window time.
Okay.
frame. And I do have work still in Louisiana that we're doing, but 48 hours is plenty of time.
Okay, so that way, that just gives probation a chance to confirm. Maybe they want to call your employer to verify it. I don't know what they need to do to bless you traveling out of state. What they won't need to,
Each time he'll have to get a travel permit and it'll have to be approved by whoever his probation officer is.
great.
All that information is put on a form and it's now uploaded into the system.
Good. All the more reason to do that 48 hours in advance, because
I'm
you got to,
self-employed too, Your Honor. I don't know if there's anything like what I need to show the scheduled work that I have that I have scheduled out.
They'll go over all of that. They'll give
Okay.
proof that you're going there, specific reason, addresses, everything.
Thank you. You got it. All right.
Judge, you were talking about an incentive date. I mean, it is 3 years fair.
well, it was kicked around, but I think if we get a reduction in restitution, we can talk about an incentive date. For now, we'll let probation and Mr. Johnson manage that. Okay? All right. Mr. Johnson, you're going to just want to chat briefly with Ms. Toussaint before you go. Oh, last thing. Do you authorize me to electronically sign the indictment indicating your first offender guilty plea?
Yes, sir.
Ms. Rockwell
Yes, Judge.
and Ms. Charles. All right. Mr. Cano, you are not being left twisting in the wind. I envision your outcome being the same. I know Mr. Ford has already begun to lobby that, hey, you should owe less on restitution because you weren't the jawbreaker, et cetera. I appreciate that. That's not how we're going to slice it up, because I wasn't there and I don't want to get in the middle of, oh, you only did a little bit versus a lot. You were in for a dime, you're in for a dollar, whatever that phrase is. But you've got the more important issue to work through right now, which is to have that conversation with immigration counsel. So I will work with my litigation manager, who has stepped out of the courtroom, to figure out a date in the near future. It won't be this week. I got other things I'll be doing, but it'll be in a few weeks when you'll be back on a calendar. And by that date, you need to have had that conversation with Mr. Ford and an immigration attorney, just so you're going in with eyes wider open. You can always back out of this. You have not bound yourself to this outcome. It seems like a very reasonable outcome and one that gives you some flexibility. But if you learn from immigration counsel that really the only way that's going to work for you would be to go to trial and get acquitted, then that's what you're going to need to try to do. You got a good defense attorney, but that's where then he can step in, Mr. Ford, to say, no, I can do that. I'm not a magician. I don't know how trial will go for you. And then you're doing that hard job you'll need to do, which is to balance there are risks with the guilty plea, first offender status, but I am lessening those risks as a first offender. I go to trial, and acquittal is the bright green light, no immigration consequences. But a conviction at trial, that could be a big red light, and your immigration lawyer can help you with that. Okay?
Yes, Your Honor.
Mr. Ford, anything else on behalf of Mr. Cano?
No, Your Honor, thank you for your time this morning.
All right, so we will see the two of you, Ford and Cano, soon. And Ms. Charles or Mr. Hand will be handling that. And Ms. Charles, you'll let Ms. Rockwell, Mr. Halliburton, Ms. Nelson know if there is a shift in this restitution amount. Great, okay, great. Thank you so much.
Judge, may I be excused, and he's gonna get reporting.
Yeah, Ms. Tucson and he can chat. Mr. Grubman, you're back.
Yes, Your Honor, I have a issue I invited the prosecution up here. They know I'm up here and I want to address the issue for you. They're not here, but I believe they violated your order and I would like to address it before.
Okay, take a seat. We'll do that in a little bit. What are we ready for next? We've got Mr. Hardiman, we've got Mr. Jackson, and that's it. So what about Mr. Jackson? He's had family here. This is probably their 58th time in this courtroom. They're like family now.
As I said earlier, Your Honor, we have this issue with the unvetted cases that he has. He would like to exercise and be treated as a first offender. I think the court would have authority to consolidate the cases for that purpose. Sure. Does
the state oppose first offender?
No, I don't oppose. I said, as far as consolidation, I'll look at the case law. They're close enough, very similar, all executed the same way. I think it would be admissible against one another if it were to go to trial. So I think it would be legally allowable. I told Mr. Gladys, I'm going to leave it up to you.
What are the unindicted charges?
So the unindicted charges are going to be they're going to be participation in criminal street gang activity, entering autos, and theft by taking autos.
With any of the names I've grown familiar with and working through these cases, or is this Mr. Jackson flying solo?
No, it was with some of the members that you've grown familiar with, particularly Mr. Chambers.
Okay. And did Mr. Chambers already resolve?
Yeah, there's his issues. He does have some unindicted cases, but they were separated apart, and I don't think they weren't. Those particular ones that he was actually charged in is not going forward.
Okay.
With Mr. Jackson. There's another individual by the name of Xavier Smith with Mr. Chambers that they have stuff coming down.
Okay, but they'll be randomly assigned because I don't have any Chambers cases left. Okay, but I still have some Jackson cases left.
You do. He's got a lot of CP numbers for whatever reason. When all the warrant, it was a string that lasted from July and August of 2020. For whatever reason, all the warrants were taken out at the same time, but when they were sent over, the clerk's office looked at the dates of each warrant and then assigned different CP numbers based on the date of each warrant. They're all more or less consecutive CP numbers, but they broke them out, although they are one actual case.
Do you remember if Mr. Chambers got first offender, if he was eligible for it? Because the other deeper question is, should Mr. Jackson even get first offender? And we'll discuss that with him present. But if I'm not inclined to give him first offender, that removes the concern about how would we navigate the unindicted cases, as long as the state represents it won't be seeking additional time for the unindicted cases. And they've said that.
First off, I'm not sure if I don't think Mr. Chambers is eligible. I'll pull that up first though before I.
Well, I'm looking it up. Ms. Wood,
Yes, Judge.
what's cooking with Mr. Hardiman? You guys friends again?
I think so, Judge. We submitted the waiver of indictment, and Mr. Charles was graciously agreed to speak with her supervisor about maybe changing some of the charges so that we can enter a non-motion.
Okay. Is that something that might happen today?
I would ask, Judge, if the court would indulge me to allow Mr. Hardiman to stick around until the afternoon after, so that Ms. Charles will have time to speak with her supervisor.
Let's definitely do that.
Thank you, Judge.
So the 177222, Mr. Jackson's the only defendant. And of course, he's got 1,000 co-defendants on this other case.
He did not, Mr. Chambers did not take first offender on his case. On the two cases that pled here. 3 cases involving this indictment.
How about your client is the brother? How is your client related to Quentin Jackson? Brother. I'm getting the nods from the family. Okay. Quentin Jackson did not get first offender, but he may have had other things going on as well. He may not have been eligible for first offender. Looks like he had a case out of Coweta County, so that may have been why.
Yeah, so that's, and Tyrell Chambers was on probation as well.
Okay.
And so he's not eligible.
Okay. All right. So here's my thought, Mr. Plattis. You should go back and talk to your client again. If I decide that your client, Quintavious Jackson, should be treated as a first offender, I think we can engineer it so that the unindicted cases, when they are accused or indicted, whatever happens with them, can be consolidated for purposes of sentencing. I may not decide that he should be sentenced as a first offender, which would then moot that part of the concern. I would just want to get on the record what's been represented by Mr. Hiles now several times, which is first offender or not, the unindicted cases, when they are indicted, should Mr. Jackson want to resolve them by way of a plea, the state's recommendation would be concurrent with whatever today's sentence would be and not longer than. So not just concurrent, but the same amount of time or less. So it wouldn't change the ultimate outcome for Mr. Jackson. Does that make sense?
Yes, Your Honor.
Okay. So you want to talk with him one more time?
Yes, Your Honor.
All right, why don't you chat with him? I'm going to talk with the lawyers who walked in again. And then why don't we handle Mr. Jackson's pleas, if he wants to go forward. And then we'll pause until our afternoon calendar. And during that break, Ms. Charles can see what she can do with the Hardiman situation. I think that will have covered everything. Yes? All right.
Think you clown have a family member or friend out here?
Correct.
Thank
Thank
you.
you, I will go out there.
With the little boy.
Okay, thank you.
Not quite.
I felt that was.
He still might. Or it might be delayed a little bit.
And then the address.
Thank you. Okay.
Well, oh, because that's what's in the paper. It's not it's village.
It's not good.
She believe, but you can. Is it gonna do that or how? Is he here? I was here yesterday. I'm just.
She's not here Tuesday, unfortunately. So don't send this to you. No, because I'm like, this is a tape. I'm just a Cano. I'm just gonna put the plea. Because. Oh, there's a chance.
I haven't seen in a long time.
Oh, some shit, yeah. I still get
Message and say
the,
hello.
I still get the first appearance notices. When I was doing first appearance.
Again?
I said I still get the first appearance notices. From December when I was doing first appearance.
Look at that. Ask me about it again.
Mm-hmm.
Oh, yeah, oh, yeah. Good, she's great. All right, guys, let's get out of here.
So what, we still haven't, managed to make it clean that way. Inside.
We're now come to our remain seated.
Mr. Cladis, are you and Quintavious Jackson ready to go forward? Great. Can we bring him out, Deputy Remy?
I'm gonna sit up at the witness stand, yeah, if that's all right.
Wherever you can be near a microphone is great. So that's good if you don't want to be at council table. Oh, I'm sorry. Yes, 3 and 4.
Your Honor, before we start, I just, so I'm.
Do you want this on? I want to make sure we're on the, you want to be on the record for?
Sure, it's fine. I just wanted to ask, is the court, does the court want to hear as to first offender first? Or is the court?
No.
Okay.
Well, I want to hear all about this Mr. Jackson and his situation, and so we'll work through that. Ms. Rivers, are you ready?
Yes, Judge.
Great. So we are here on positions 3 and 4 for our trial calendar. It's Quintavious Jackson, 18 SC 162228 and 20 SC 177222. A lot of twos. Mr. Jackson, how you doing this morning?
Good, how are you?
I'm all right. It's been a minute. Mr. Cladis tells me that you are interested in entering a plea in these 2 cases, and maybe even some that aren't indicted yet. We're not able to handle those, but what I've heard from the prosecutor, and we'll get it on the record, that whatever sentence you get today for the 2 cases I just mentioned will be the same sentence for those new cases when they get indicted, if you want to resolve them. Or the sentence will be even lower for those new cases than what you get today. Does that make sense?
Yes, sir.
Is that your understanding?
Yes, sir.
Okay. So, Mr. Jackson, before we get into taking the plea, I know you and Mr. Cladis have had this conversation, but I want to get it on the record. Mr. Cladis is changing jobs in about a month, and will be doing something fairly different from what he's doing now. Right now, he is your lawyer, and his focus is on your interests and your interests only. But in about a month, he'll be thinking about things differently. Are you comfortable having Mr. Cladis continue to represent you today for the purposes of your plea in these 2 cases?
Yes, sir.
Mr. Cladis, do you feel like you and Mr. Jackson have had a good open discussion about I won't even call it a conflict yet, but the fact that you're changing jobs and will be ultimately potentially working for the district attorney, but that you and Mr. Jackson have discussed that he understands the concern you have, and that Mr. Jackson is comfortable moving forward with you as his lawyer for purposes of the plea?
Yes, Your Honor.
Okay. Anything more you want to get on the record?
No, Your Honor.
All right, then let's get started. In a moment, Mr. Hiles, who's the prosecutor, is going to put you under oath. When you're under oath, Mr. Jackson, you need to provide truthful and complete answers to all of Mr. Hiles's questions and mine. If you've got any questions at any point, please let Mr. Cladis or me know so we can answer them. Will you do that?
Yes, sir.
Great. Mr. Hiles?
Okay, Judge, before we start with the plea, I'd like to outline it for you so you could follow along.
Okay.
So count number 1 and count number 8 are going to be null pros. Count number 1 is the participation in criminal street gang activity that is based upon count number 8, which is the trafficking in heroin. So as part of negotiations, those 2 counts are going to be null pros. He is going to be pleading to counts 2 through 6, and then counts 9 through 13, and then 15 and 16. And the negotiated sentence is going to be a total 23 years to serve 3 years.
Excuse me, 22, you said?
22, okay, 22 years to serve 3 years.
Okay.
So the way that will be, it would be on the participation of street gang charges, that would read as 17 years to serve 3 years. And then
The guns are the 5 years consecutive?
that's correct.
Okay.
They have to be consecutive suspended.
Yep.
So, all right.
And just last on that, it's 22 to serve 3. That leaves 19 unaccounted for years. Is that to be probated? Is it some years probation, some years suspended? What are we doing with, what are you recommending happen with the 19?
The recommended here is it's 17 years to serve 3 years, with that 14 on probation.
And then 5 years suspended.
5 years consecutive suspended.
Okay.
And to make things easy, when I go through the statement of fact, so the 20 SC 177222 was actually when officers were going to serve the arrest warrants on that case. That was the case that led to the discovery of all of the drugs inside the house. Even though it's a later number, it was an earlier date. And so I will just go through in consecutive order during the statement of facts. So they'll fit right in together. Okay. Mr. Jackson, would you please raise your right hand to the best of your abilities? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you put your hands down. Please state your true, correct, and legal name.
Quintavious Jackson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
22, and I have my GED
Where did you get your GED?
in Fulton County, Rice Street.
So are you able to read, write, and understand the English language?
Yes.
Do you understand that in indictment number 18SC 162228 in counts 1 through 6, you were charged with participation in criminal street gang activity? In count 8, you're charged in trafficking in heroin. In count 9, you're charged with possession of marijuana with intent to distribute. Count 10, you're charged with possession of firearm during commission of a felony. Count 11, you were charged with possession of a firearm during the commission of a felony. Count 12, you were charged with possession of a firearm during the commission of a felony. In count 13, you were charged with possession of a firearm during the commission of a felony. And in counts 15 and 16, you were charged with possession and use of drug-related objects. Do you understand that?
Yes.
Do you understand that in count, an indictment number 20 SC 177222, you were charged with one felony count of theft by receiving stolen property and one misdemeanor count of theft by receiving stolen property?
Yes.
Okay. Have you gone over your waiver of rights that you were giving up in exchange for this plea with your attorney?
Yes.
Okay. Have you had enough time to speak with your attorney, Mr. Cladis, about all of the facts and circumstances known to you regarding the charges in these two indictments, including any potential defenses?
Yes.
You need more time to discuss this case with your attorney.
No.
Are you satisfied with his services?
Yes.
Mr. Cladis, do you waive formal reading of this indictment?
Yes.
Or both of these indictments?
Yes.
Mr. Cladis, for these two indictments, do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes.
Okay. Mr. Jackson, have you been advised of the minimum and maximum sentence for each count that you are pleading guilty to?
Yes.
Okay, I'm going to go over them with you again, okay? Just to have it on the record. Are you aware that in counts 2 through 6 that you are pleading to, participation in criminal street gang activity, that each of those counts carries with it a potential sentence range of 5 to 20 years of incarceration? Do you understand?
Yes.
Okay. And do you understand that count 9, possession of marijuana with intent to distribute, carries with it a potential sentence range of 1 to 10 years?
Yes.
Okay. Are you aware that counts 10, 11, 12, and 13, possession of a firearm during the commission of a felony, carries with it each a 5-year sentence that must be run consecutive to the underlying felony? Do you understand?
Yes.
And do you understand that counts 15 and 16, possession and use of drug-related objects, each carry with it a potential sentence range of up to 12 months incarceration and up to a $1,000 fine?
Yes.
Okay. In indictment number 20 SC 177222, do you understand that count 1, theft by receiving stolen property felony, carries with it a potential sentence range of 1 to 10 years?
Yes.
Okay. And do you understand that the count 2, theft by receiving stolen property misdemeanor, carries with it a potential sentence range of up to 12 months incarceration and up to a $1,000 fine? Do you understand?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that for both, for a total sentence, the state is recommending a sentence of 22 years to serve 3 years with 14 of those years being on probation, and then followed by another 5 years of a suspended sentence, which means you are under sentence, but you are not required to report to any probation. Do you understand that?
Yes.
Okay. And do you understand that as part of this recommendation, you are not to have any contact with any known gang members, and that you are not to possess any weapons or replicas thereof? Do you understand?
Yes.
Do you understand that the court does not have to accept the recommendations presented by your defense attorney and myself, but can sentence you to the maximum on each charge and run those charges consecutively or one after another? Do you understand that?
Yes.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in federal courts?
Yes.
And do you understand that if for whatever reason you're on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Mr. Jackson, are you a United States citizen?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to this felony, if you use, receive, possess, or transport a firearm, you'll be guilty of a separate offense that carries with it a potential sentence range of 1 to 5 years? Do you understand?
Yes.
And do you understand that if you use a firearm in a crime, you could be guilty to a sentence that carries with it 1 to 15 years or 15 years consecutive to the underlying felony? Do you understand?
Yes.
Because the judge is going to weigh whether or not would consider a first offender plea, I'm going to go ahead and go over the rights and what first offender means. Okay.
I'll cover that with him if we're going to do it.
Okay, that sounds good. Then I'll skip that for now. Mr. Jackson, do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Mr. Jackson, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
I can hear you. What's saying?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
All right. Mr. Jackson, an indictment number 18 SC 162228. How do you plead to counts 2 through 6, participation in criminal street gang activity?
Guilty.
How do you plead to count 9, possession of marijuana with intent to distribute?
Guilty.
How do you plead to counts 10 through 13, possession of a firearm during the commission of a felony?
Guilty.
How do you plead to count 15 and 16, possession and use of drug-related objects?
Guilty.
Mr. Jackson, an indictment number 20 SC 177222. How do you plead to count 1, theft by receiving stolen property, felony?
Guilty.
And how do you plead to count 2, theft by receiving stolen property, misdemeanor?
Guilty.
Do you understand that you have only 4 years from today's date for a felony charge and 12 months from today's date for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And do you understand that you have either till the end of this term of court or 30 days, whichever is longer, to file a motion to withdraw your guilty plea in this particular case?
Yes.
Or these 2 particular cases? Do you understand?
Yes.
Okay. All right. Your Honor, were this case to go to trial, the facts would show that on May 12th of 2018, officers responded to a stolen vehicle at 3183 Abbey Drive, where Mr. Robert Smith said that a car, 2017 Q50 Infiniti, with the tag number CEX 5384 that he had rented from the Hertz Corporation, had been stolen when he left it running and went inside. On May 15th of 2018, Officer B. Miller, as well as officer and another officer, located that particular Infiniti Q50 behind an abandoned house located at 4086 Fairburn Avenue, Atlanta, Georgia, Fulton County. When that vehicle was processed, Officers found Mr. Quintavious Jackson, as well as his co-defendant, Mr. Ricky Wolf, their fingerprints inside that particular car. Additionally, Mr. Quintavious Jackson's fingerprints were recovered from a temporary tag that had been stolen off of another car that was in the back, that was in the trunk of that Infiniti, which that particular tag is the stolen tag is the basis for the theft by receiving misdemeanor in the 20 SC indictment. When officers continued to search the area, they found a tag that belonged to a Jeep that had been stolen shortly days prior to be abandoned in the woods right next to the abandoned house. There was also another car that was parked in that lot that was reported stolen. However, after processing those cars and the other tags, they were not able to link those cars to anyone else. However, police did note that this was a area where stolen cars were often abandoned, and it was later discovered that it was many of the 27 Unos, which is the gang that the state alleges the defendant to be a part of, where they were abandoning vehicles that were stolen and or used in other audits.
27 Unos, like the card game UNOS?
And 27 in front of it.
Yes. Right. Okay.
Yeah, I'll keep going. So on June 7th of 2018, officers then sought to go execute, officers from the Fugitive Task Force, as well as the Marshals Unit, went to go execute the search warrant or the arrest warrants for Mr. Quintavious Jackson at 4048 Fairburn Avenue, which was very close, just blocks away from where the cars had been abandoned. As officers were surrounding or entering the house, officers knocked and announced they saw co-defendant and his brother Quentin Jackson attempting to flee, as well as officers found Quintavious Jackson and Vincent Way on the first floor of the house. Upon entering, it was obvious that there was marijuana, large bags of marijuana that were vacuum sealed, as well as some that were open with the same vacuum sealed packaging. There were visible guns and ammunition and scales as well. Based on what they viewed in the initial entry, officers went back and got an additional search warrant and searched the house. Downstairs in the room associated with Mr. Quintavious and Mr. Vincent Way, officers found a backpack that contained a scale with marijuana residue on it, 2 vehicle key remotes, a high-point handgun, a FN assault pistol, an AR-15 tactical assault rifle, as well as a Mossberg shotgun, and a 50-round drum for pistol, as well as 3 separate pistol magazines. Inside the kitchen, there was a vacuum sealer with bags that matched the bags where they had found other marijuana inside the bags. They recovered in the living room. They recovered 60 grams of marijuana in the vacuum sealed bag, 2 handmade gang posters that had the 27 Unos / Boys in Black logo on those handmade gang posters. They recovered 2 additional vehicle keys. Upstairs, officers recovered a Glock 19 9mm handgun, a scale, and 60 grams of heroin inside of a larger trunk. There was also separate small amounts of marijuana gathered in different areas of the house. Your Honor, after that, the scene was processed. Mr. Jackson admitted to living in the house, and all parties were arrested and charged accordingly. The reason for the dismissal of the heroin is at the time there was officers were making entry. There was several people not knowing who scurrying about the house, and access to that room and trunk where the marijuana or the heroin was found. It was unclear as to exactly who was there and who had placed it there. So,
What's your theory? Quintavious Jackson seems to be one of the younger folks involved, so maybe not his house, although it sounds like he was living there. I mean, who was in charge at the house? If you were having to try to convince a jury, the ringleader of the Fairburn Way group.
I think they were all living together. You know, he was living with his sister, Miss Tiana Jackson, we dismissed the charges against her. But I know those were also dismissed because at the time of this incident, she was, I believe, at an orthodontics appointment, was not present for that. I think some of the younger guys were actually running the show. I know in the other cases for which this offer stands, there's several other cases, the modus operandi of the entering autos and auto thefts are the same as that 20 SC, what they're known for. So I don't know if there was one particular person in charge. Don't want to say that, but they all admitted to actually living there. Their belongings were there, as well as identification papers. So
okay,
I would not venture to say one person was in charge. I don't know if it was a.
Got it.
But that would be the basis of the state's case. Now, I do have one other thing that I'd like to put on the record, that he's got from the July, August of 2020 timeframe, just before he was picked up. There are several open cases. There are a lot of CP numbers, but these warrants were all taken out at the same time when cell phone data and fingerprint data was collected. Those cases, what the state intends to indict as one indictment is going to be 21 CP 203356, 21 CP 203360, 21 CP 203361, 21 CP 203362, 21 CP 203363. That offer that I just communicated, I think the actual global sentence that I said to Mr. Cladis earlier would be, instead of 22 served 3, would be 20 served 3, but it would all run concurrent within the sentence.
What are the charges? And you don't need to go by each CP, but are they mostly stolen car or entering auto, or is there a shooting in there?
There's shootings in there. No, there's so it's stolen cars, yes, and entering autos using either stolen or rented vehicles by third parties.
Okay.
If I can interrupt for a second, did I fail to hear the behavioral, or sorry, the incentive date that we discussed?
Yes, and Mr. Cladis came to me and asked about a sentence date that we'd recommend, behavioral incentive date, which for this case would be no violations, technical or reoffending or special conditions after 8 years from the running of the sentence, from the start of the sentence, whenever it's imposed.
Okay. All right. Ms. Tucson, do you have any adult criminal history for Quintavious Jackson? All right. Mr. Cladis?
Thank you, Your Honor. So just to start with, Mr. Jackson was 18 at the time. He was the second youngest of all the defendants who were his friends and family members.
Who was the youngest?
I believe possibly Vincent Wade was the youngest.
Okay.
I forget what the difference with the age difference is, but my client was among the youngest of the defendants. He is very remorseful for his participation in these crimes. He regrets it deeply. He's had a lot of time to think about it in jail. While he's been there, as he said, he's gotten his GED. He's also completed several other programs at the jail, including the reentry program, a drug rehabilitation program to deal with the marijuana use he was struggling with, and another program called Thinking for a Change, which, as I understand it, essentially helps teach the inmates how to make better decisions, better life decisions. He is, as I said, very remorseful and would like to move on with his life. We are asking the court to sentence him as a first offender. Given his age, given the decades he hopefully has ahead of him, his life will be better if he is not going through it all as a convicted felon. I'm going to just briefly make a hopefully not too specious comparison. When I was a little bit younger than Mr. Jackson, I myself got into some trouble, not remotely as serious as the 2018 case, very similar to the 2020 case. I was a juvenile. I got juvenile treatment in Illinois. I was able to put it behind me, and I'm a lawyer, and it led to some uncomfortable questions when I became a lawyer, but they let it go. I was able to turn things around. I was on a little bit of a bad path. Again, Mr. Jackson's cases are more serious, but he's also spent a lot more time in custody than I ever did, and in a much harsher place. And during that time, he's made the most of it in terms of trying to turn things around, to better himself so that when he is released, he can get on with a normal life. His mother is here, and his family members are here. They've been here constantly. As far as I'm relatively new to the case. They are here to support him now, and they will be when he's released.
Of course, they were around to support him before, and he ended up living in this house with a bunch of guns and heroin and marijuana and these other folks. So I'm all for Mr. Jackson charting a new course, and it sounds like he's made some efforts while in custody. What makes you comfortable, if you know, Mr. Gladys, that when Mr. Jackson gets out, he will be in a different environment than he found himself in and a product of that resulted in these two cases? Plus, it sounds like a bunch of related, your line of work when you were a juvenile, breaking into cars.
I think the biggest thing is just the time that he has spent in the jail. It's not, he wasn't sentenced to a jail term. He's there pending trial just to make sure that he shows up for court, but it has been a punishment. And I think with the benefit of hindsight, knowing now what it's like to spend that much time in a place like that, I think he will be making different decisions in the future.
Okay. Mr. Jackson, anything you want to add about your situation, what you hope to do in the future, or why you think that things will be different when you get out?
I have an older brother in Florida. He supposed to be my mentor when I get out, type of mentor to me.
Where was he back in 2018?
He wasn't around then. He was around, but he went in Atlanta.
Okay. And would he be moving up here or?
Yes.
Okay. When you went to jail, how far had you gone in high school?
11th grade.
Okay. And did you do the whole GED, or you just did enough so that sort of the 12th grade that you missed, you took care of?
Really, the GED teacher made me take all the tests, 9th, 10th, 11th, 12th grade tests to see where I was, to catch up on the work.
But ultimately, wherever it was you started, you finished it and got your GED.
Yes.
Okay. What's your plan for when you get out? Where will you be living?
With my mom.
Okay. Do you have kids?
No.
Do you have any questions about anything that we've been talking about?
No, sir.
All right. Well, Mr. Jackson, I find there's a factual basis for your plea. I finally know why the police hit that house. It was actually because of you. Everyone else has you to thank for the police showing up that day because they had a warrant for your arrest and they found all sorts of stuff in that house besides you, which led to this big old indictment. I also find that your plea is knowing and voluntary. Voluntary means that you've decided to enter these pleas because you've decided, after listening to your lawyer and maybe your family members, that it's the right way forward for you. Is that correct?
Yes, sir.
Okay, and a knowing plea just means you've understood everything and you don't have any other questions. And you've already told me that you don't have any other questions. I'm sentencing you under the Probation Options Management Act. And what that means, Mr. Jackson, is that when you're on probation, which you will be for a while, if you have a technical violation, like you miss a meeting, or I'm not saying this is you, but if you tested positive for drugs once, you're in probation will work through that. They may get you some counseling, but you don't have to come back and see me. If you get arrested again, breaking into a car, anything, and get arrested with drugs on you, that comes back to me and we would work through what the consequences of that possible probation violation is, okay?
Yes.
So first offender to me is the tough question here. It sounds like all the things that you were wanted for occurred in this kind of summer of 2018. And then you've been out of commission. You've been locked up for almost 2 years now. So no new cases, which is good, and was actually separates you out from a lot of folks who've been in jail that long because they've been picking up new cases because they get in fights, they get found with something, and you've managed not to do that. Are you a trustee?
No, I was an orderly once though.
Okay. Why did you stop doing that?
I really just, they had found out that I had got shot and they didn't want me to drop no trays and nothing like that.
When did you get shot?
2019 summer.
Before you got locked up?
Yes.
Okay.
Your Honor, all those 21 CP cases, that was July and August of 2020, not 8.
Okay. So Mr. Jackson bonded out after these two cases, or at least the 2018, and then this new stuff came up. Okay. All right. Did they catch who shot you? Do you know who shot you?
No.
How do you not know?
It was a car, a drive-by.
Oh, it was just a drive-by. Were you with a bunch of people or it was just you?
I with my mom. My mom and my grandmama was in getting their nails done, and I was just sitting in the car.
Okay. I'm glad you're all right. Where'd you get hit?
On my neck.
That's not a great spot to get shot.
I know I was partially paralyzed.
I'm glad you've recovered, but because of that, they just didn't want you being an orderly.
Yeah, because I still be having problems with my legs sometimes because I'm supposed to be getting Botox injections.
Okay. All right. So, Mr. Jackson, first offender is primarily an opportunity. It would mean that you would not be a convicted felon while you're under this sentence. It can be a long sentence, but you would not be a convicted felon while you're under it, which would help if you're trying to find a job or go back to school, whatever you're going to do. That's the opportunity part. It's a risk because it's going to be a long sentence. And if you get in trouble again while you're on that long sentence, not only do you have whatever got you in trouble, if that happens, but you'd have to come back here. And if I found that you had violated your probation in a meaningful way, you got arrested again, I'm making this up, but you stole another car. I can pretty much guarantee you I would take away your first offender status, and without a trial, because you've already pled guilty to all this, I could resentence you up to the maximum. It wouldn't be the maximum if what you did was steal a car, but it would be, you know what, that thing that was something to do 3, now it's something to do 6, or whatever it would be. You go back into custody and you'll get credit for the time you've already done, but you wouldn't have done 6. And so you'd be back in jail again because as a first offender, you got in trouble again. So you need to be pretty comfortable that the way you're going to live your life and the people you're going to be spending time with and the places you're going to be living aren't going to pull you back into the way you were running in 2018 and in 2020. Because if you're going to struggle staying away from those people and those places, first offender is a bad idea because it bites you real hard if you mess up. Now, if you're convinced, and you know better than anyone in this room, I'm not going back to jail. I did not like it there, and I will do what it takes. If that means that I got to go to school and be a choir boy and clean toilets or whatever it is, that's what I'm going to do. So I don't have to go back there. Then first offender makes a lot of sense because you don't have that baggage of a felony conviction where an employer is like, I don't need to hire Quintavious Jackson. This guy doesn't have a felony. I'm going to look at his application instead. So it's got an upside, but it's got a big messy downside if it doesn't go well. Have you thought about how first offender works and more importantly, how you might work as a first offender?
Yes.
And you think it's something that is smart for you to do?
Yes.
Why is that?
Because I want to go back to college.
Where do you want to go to college?
Probably Savannah State.
Why Savannah State?
Because I got a little cousin that go there.
A little cousin. Okay. And what would you study at Savannah State?
Probably computer science.
Okay. Well, Mr. Jackson, I want to give you a chance because you lost a bunch of years of your life as a young man. I'm not blaming anyone. I'm blaming you. You're in jail because of stuff you did, but you lost a couple of years of your life. And it'd be great if you could reclaim those and be starting a little bit behind folks age-wise, but hit college and see what you can do. Maybe it's 2 years of college, but get an associate's degree and get a job and make your folks not despondent anymore. They worry about you. They come to court all the time. They've been here for your brother's plea. They've been here for your sister's case being resolved, and now yours. And you owe it to them, at least, if not just to yourself, to try something different out. Again, I don't know why you were running the way you were running with all these folks for a few years. It's not my job to fix it, but I'd love to prevent it from happening again. But that's mostly on your shoulders. I will sentence you as a first offender in these 2 cases. I will consolidate them for purposes of sentencing. So it'll be 2 different dispositions, but it will be listed as first offender. And here's how I'm going to sentence you on 18 SC 162228 on counts. Get this indictment up here. 2 through 6, which are the participation in street gang cases. I am sentencing you to 10 years to serve 3 years on those with the balance probated. Count 1 is dismissed. Count 8 is dismissed. Count 9 is 10 to serve 3. So those are all running concurrently with each other. And then counts 10 through 13, those are all gun charges. They have to run consecutive to count 2, and they have to be 5 years. I will run those concurrently with each other, consecutive to count 2, and I will suspend those. And then count 15 and 16, which are the misdemeanors. Those will be 12 months to serve. Those will run concurrently with count 2. So the overall sentence is 15 years to serve 3 years, followed by 7 years on probation, and then 5 years suspended. So it's a total of 15 to serve 3. 3 in custody. You'll get credit for all the time you've done. Then you're going to have 7 years of probation. And then after that, you'll be on a suspended sentence for 5 years. In 20 SC 177222, Your sentences to count 1 is 3 years to serve. Your sentences to count 2 is 12 months to serve. That case will run concurrently with the 18 SC case. So overall, you're going to serve 3 years, of which you've served a whole bunch. These are all parolable offenses. You may get paroled real soon, but the most you'd serve would be up to 3 years. So you know the math of how long you've been in. You won't serve more than total of 3 years. Then you'll be on probation for 7 years and then a suspended sentence for 5. That is less probation than was negotiated. And I do that because there's really no point, I think, in year 8, 9, 10, 11, 12, 13 of probation, other than there's so much more of the world that can come tumbling down on your shoulders if you get your probation revoked. But because you're a first offender, it doesn't matter what I sentence you to now. I get to resentence you as if you were never sentenced at all. So I don't, normally, if someone has 10 years probation, the most someone could do is revoke 10 years. And if you've already done 3 of that probation, the most they could revoke is 7 years. But with you as a first offender, I get to look back at all these. I could revoke, is a big number. I mean, 100 years. And I would resentence you. I could resentence you 100 years in jail. That's very unlikely, unless if you got in trouble again, it was you and guns and something like that. But just know that I don't think you need 7 years of probation to prove to me and your family, and most of all to you, that you're a college student, that you're working, whatever it is. But most of all, you're not doing this. If that's not how it plays out, and we are doing business together again because you got arrested again, I don't need to worry about how much probation I gave you. I just go back to these indictments and figure out how high do I need to pile it because you were wrong, you misled us, and you're not ready to be back out in circulation. That'll be depressing if it happens. I hope it doesn't happen. I wish you the best, but that's how I'm structuring this. Couple things. Were there special conditions of probation you wanted to see, Mr. Hiles?
Yes, no contact with no gang members. That's statutorily required.
Okay.
No weapons or replicas thereof. And that is because often on social media posts with weapons, it's the defenses. Oh, it's just a replica, but it's much easier to just say no replicas. And then that would be it. Normally I would be asking no contact with
Co-defendants, which you did with Mr. Chambers, but I don't want to keep this Mr. Jackson from the other Mr. Jackson or his sister.
I agree. So that's
Okay.
why I'm not asking for it.
Got it. Okay. Stay away from Ricky Wolf. So it's a good plan. So special condition number 1, no contact with Mr. Wolf. That's with an E. Special condition number 2, no guns. Already it would be a crime for you to have an actual gun that could fire a bullet. But no replicas of guns either. If there's a toy gun in the house, got to get out of the house. No firearms or replicas of firearms around you while you are on probation. And then statutorily, you can have no contact with known gang members. It's not meant to be a trick. If some guy walks up to you and flashes a sign and they take a picture of it, that's not you associating with a gang member. But if your Instagram page just has picture after picture of you with guys who you know and law enforcement knows are gang members, that's the kind of thing that's going to get you back in front of me. And we'll be asking, well, you said things were going to be different. You were going to be with different people and in different places. And here we are. It's the 28 Unos. We don't want that to happen. I mean, hopefully you don't want that to happen because they'll just repeat this cycle. Do you have any questions about anything I've described?
No, sir.
Okay. Mr. Cladis, any questions about anything?
No, Your Honor.
Mr. Hiles?
No, Your Honor.
All right. Do you authorize me, Mr. Jackson, to electronically sign your 2 indictments indicating that you've entered guilty pleas in both those?
Yes.
Mr. Cladis, may I sign for you?
Yes, Your Honor.
And Mr. Hiles?
Yes, Your Honor.
I think we're done. Do you need to get any information, Ms. Tucson, from Mr. Jackson, or because he's going to be spending some more time in, you don't need it? Okay, you'll go see him? Okay, all right. That's it. Thank you. Good luck, Mr. Jackson.
Thank you. Thank you, Your Honor.
Yeah, so we need to talk because I have to get on a Zoom call in 5 minutes to talk about getting more C3 lawyers, which is good. The county's going to bring some on. So I got to scoot, but we have a few things we need to do. Are you guys all set? You're just waiting to talk to Mr. Cladis? Okay. All right. So our afternoon calendar is at 1:30.
All right, they're still waiting on me from a 9:30 calendar in front of us, so I'm gonna head there now.
Go.
If I'm not here, that is where I will be.
Okay, we got plenty to cover. We need to figure out what's happening with Mr. Hardiman, but Ms. Charles is off and running on that. I know we need to do the 413. We will do that as part of the 1:30 calendar. It's a bunch of statuses, so we will have time to do it. So I'm sorry you two have been sitting around. You probably want to get ready for trial. It just hasn't unfolded that way. So be at ease until 1:30, and let's just push through the status calendar and then do the 413 discussion. Is that all right?
Yes, Judge, and I've communicated an updated offer to defense counsel on this case, so.
On the Holt case?
Yes, Judge.
Oh, okay.
And so we'll continue that conversation, and be here at 1:30.
Excellent. Was there anyone else I left out? No, Hardiman we talked about. That's it. That's the calendar. Well, that's this afternoon. Yeah. No, Hardiman is someone who is on the trial calendar. So, all right. So we'll see folks at 1:30.
Yes, Judge.
Thanks.
I have phones and computers. So.
John, do you remember what courtroom Judge Cano was it?
She's on the 5th floor. So go, yeah, I think it's 5F. It's 5th floor.
It's not a phone number. You can talk.
Oh, she's coming down here? Okay.
Because she's bringing me more laptop. I'm going to 5. What are you going to do?
Let me ask.
That one
Lacey.
yours? Yeah. Mine, yeah. I don't think so.
They all look the same. This is mine.
Which one do you?
This one.
Yeah, this one's.
Yes.
Okay.
I was like, all these phones look alike.
I know it's not mine because I was like on the way to work and remember I left mine.
Oh,
All my pets I did wasn't.
isn't that the worst?
Well,
I'm surprised you came then, because me, the whole day without it. I mean,
I'm not. Look, I was here. I worked here
Oh, here goes. Sorry, I picked it was on this too. Here, I thought it was mine. Because we have the same, look. No, we have exactly the same.
No, yeah. No, thank you.
Are you good? Hey, nice.
Also, John, I haven't formally met you, but
Hey,
here.
Hey,
Nice to meet you.
How you doing?
Good. I mean, it's supposed to be the new K, so we'll see what that goes.
All right.
So if it's tomorrow, I should leave my notes, just like a very short bond hearing. But yeah, I saw there was a level, so. is that good? Yeah, I'm assuming it'll be tomorrow, I don't think it'll take long, so, but yeah, I don't know why.
Okay,
So, yeah.
okay.
Okay, yes.
We really can't take the one down.
Huh?
Can you take this one down? One that took plea?
Yes.
So,
Okay, all, and just, and not change the. Okay, let's go ahead. Okay. Okay. Got it, okay. Yeah, just wanted to look into the.
I said 1:30?
Yes.
All right. Call us on the 27th, call us in recess until 1:30. And call us both on the 27th. Court's in recess until 13:30, and call both of us on the 27th.
That's a 29, 13 on here. Yeah, court will be in recess until 13:30. And both units, 13:29, 13:11, 27, and
I already locked it.
oh, that was very bad.
All right, I'm gonna be in my office to be.
Yeah, I'm gonna leave my weapon in there, since I'm gonna be checking on them.
Okay.
Just gonna use bathroom and wash my hands. How you feel?
You guys know next time. Do you need a card?
No?
No, you don't. You don't need it.
Oh.
No, you should need a card over there. So you just gonna stay in the courtroom?
I'm gonna stay right there, and then every 20 minutes, 25 hours.
Okay. All right.
Yeah. No, it's open, right?
Yes.
We're playing for the back, you know, you got more.
But there are people here already.
So they still.
What do you mean, the people this morning?
No, I'm saying like, you have any driving that's from the public.
Oh, I mean, court's gonna start in a few minutes, so.
Oh.
Mario, did they bring Sean Boyd over? Or was it that, or was it just like a attorney's type status today?
I don't know.
No.
Hey,
How's it going?
Going.
Did, do you know if the inmates were brought over for this status calendar, or is it?
Don't know. Good question. Do you have people in custody?
I'm told that there are people here.
Okay. My one person in custody is, I think, is living in from DOC. So. Oh, yeah, it looks like they're all brought over.
Cool.
Please.
What up?
Do you know if
Long day. How about you?
usually,
I'm sure he has. Well, I'm not sure yet at this point.
you don't call.
Oh,
Yeah, but I didn't.
I didn't see him.
It's just as, that's probably the worst part about being in my unit. It's like almost every single case of mine is a co-defendant case. And they just cannot make it attorneys by no fault. It's usually not the attorney's fault.
Asian travelers, yeah.
Maybe Sullivan.
Thank you.
Roll call, Waldo.
I don't have all those things. Don't worry about that, take care of yourself, and
You might know it's one of them. I'm just wondering.
Curry, number 8.
Okay.
That's number 8.
Got it. Thanks. All right. Well, let's get going. We have a status conference calendar. The purpose for most of the cases on here is to confirm that the case is ready for trial. Today would be the last day to have a plea where the defendant could withdraw his plea. No questions asked if it didn't work out to his liking. Otherwise, we can move these cases to a trial calendar and figure out what's going to happen. There may be a couple of exceptions on this list, but let's see. Position 1 is Anthony Carter. Hey, look at that. It's like, I don't see Mr. Melnick here. Do you want him? Do you want a minute? Are you ready to, Mr. Carter, everyone should be here. So if you want Mr. Carter to come, he should come out because he should hear what we're talking about. Do you want to talk with him first?
I do want to talk to him. I got a plea offer from the state yesterday.
Of course you did, on the eve of the status conference calendar that was published weeks ago. All right. Please talk with Mr. Carter. Ms. Boyd is next. Is Ms. Boyd here? Yes. Could we bring Ms. Boyd out? Ms. Wood, I'm gonna have you slide one row back if you don't mind. Do we have an interpreter coming for number 4? Okay. All right, this is the status conference for LaShondra Boyd. Hello, Ms. Boyd.
How you doing, McBurney?
I'm doing all right. Mr. Cladis, have you and Ms. Boyd had a chance to discuss the changes in your circumstances?
Yes, we have, Your Honor.
All right. So Ms. Boyd, what normally we'd be talking about right now is, has the state handed over all the discovery? I know they have. Your case is old. And so then I would turn to Mr. Cladis, who was somewhat new to your case, as you've received yet another lawyer, to ask Mr. Cladis if he is prepared to go to trial on your case, because that's what needs to happen. But you know now what I know, which is that Mr. Cladis is transitioning to a different job, and we need to get you a different lawyer. And that different lawyer is going to need to get to know you and your case before he or she can say, you know what, Ms. Boyd, we need to try to work this out, or I'm ready for trial, or whatever it's going to be. So I wish I had better news for you, but you are stuck in what seems like a perpetual cycle of, I see you every couple months. You've got a new lawyer. That lawyer says, could I have a little more time? I need to get up to speed on Ms. Boyd's case. For the last probably about year, the state has said, we're ready to go. Mr. Hiles's predecessor routinely said, this is a very triable case for the state, and the state is extra ready. I assume that's still the case.
I don't know what extra ready means, but we're ready.
Good. But we can't go anywhere without a lawyer who can take Ms. Boyd's case to trial. And I don't think that's Mr. Cladis's role right now. So I don't like being the bearer of bad tidings, but I know Mr. Cladis told you, so hopefully it's not a surprise, but you need to hear it from me as well. And it's good that we connect every once in a while so you know no one has forgotten about you. And it's not the state that is the reason why we can't move your case forward. It is this cycling through of lawyers that unfortunately has been going on in the office where Mr. Cladis is working right now. Do you have any questions about any of that? No? Okay. So Mr. Cladis will be letting me know as soon as he knows about a replacement, and then I'll be letting that person know that you are job 1 or 2 on my list. Mr. Cladis has a bunch of cases here. Very few of them are as old as yours with someone who's been in jail as long as you've been in jail. So this will remain a priority. All right?
Yeah.
All right. Thanks for coming by. So I trust you will be extra ready next time since you weren't this time.
Oh, I'm extra ready, Judge. I need your definition of extra.
It wasn't mine. Your predecessor said that.
I'll inquire.
Yeah. Antonio Sanders. So did Mr. Granham's he just disappeared?
Your Honor, Sean Hoover for Mr. Sanders. I just got into Mr. Sanders' case and I did a substitution of counsel for him.
Holy smokes. Let me see who this is.
I didn't know anybody was.
So play spotlight. There he is. Mr. Hoover, how are you?
Doing well, Judge. How are you?
I'm a little intimidated by that kickboxing punching thing in the background. But you're virtual, so I guess I'm safe for today. Mr. Hoover, it's nice to meet you. Tell me what your title or position is. Are you with GPDC as a C3 lawyer? Are you just sort of sent from heaven for this one case, or what's happening?
No, Director Ali has created a new position. Basically, I will be handling all gang and RICO cases moving forward.
So Mr. Sanders is charged with theft by receiving stolen property.
Yes.
Maybe there's a secret gang connection to it?
There's not.
I am on this calendar.
Oh, he's got more than one case on the calendar.
Co-defendants with Leandre Pittman. It's the gang and murder.
Oh, yes. Okay. It's more complicated than I was thinking. Perfect, Mr. Hoover, let's work this stolen car case out. But we can't because there is the more recent indictment. Okay. So Mr. Hoover, I think this is the first time you and I are interacting. I am mindful of the fact that one more question. So new position through GPDC, you are handling all of the gang RICO cases in the United States, in Georgia, in Fulton County, just my courtroom.
My office will be handling all of them in Georgia. Yeah.
So do you have 700 cases or 800 cases?
Not yet. We're working on putting a staff together to handle everything. But
okay.
Predominantly, I know since Fulton has a backlog, they wanted me to handle the Fulton cases first. So you will be seeing me a lot throughout these cases.
I like the sound of that. Okay. So we're going to get Mr. Sanders out here. Have you had a chance to meet him yet, or this will be your first?
No, I haven't been able to meet him. The problem is I went to the jail this morning. They said he went to the DOC. We finally found out he's in Douglasville, and Douglasville won't put him on Zoom so he can even be here. So he's not at Wright Street. He shouldn't be at your courthouse. He's at the Douglasville jail right now. And I just found this out.
Okay, well, let's find out. We may pull a rabbit out of a hat here. Do you all have an Antonio Sanders here? No, his family is shaking their head. We're not going to find him here.
Yeah.
It's okay if you don't. It would mean that Mr. Hoover has done his homework. Okay, I trust he's in a no bond status with us.
That's my understanding as well.
Okay, he is. Mr. Heil says yes. All right, so you've learned, Mr. Hoover, that Mr. Sanders is in the Douglas County Jail or the Douglasville City Jail?
No, he's in the Douglas County Jail.
Okay. So we need to get him here. Would it help? It sounds like it would help you in interacting with him if we got him to Rice Street, our county jail, out of the Douglas County Jail.
I mean, I was gonna head out there anyway at some point this week, so.
Okay. I mean, it's not like it's Texas, it's Douglas County, but so you can get there. From us to there. So he was in our county jail 14 days ago, 2 weeks ago, he got moved to Douglas County. I'm not quite sure why that happened.
I'm not either, actually.
Okay, we'll research it, but there's nothing that can happen with this case right now because of that. Do you have discovery from Mr. Granum's, or does Mr. Hiles need to, probably for the fourth time, drop an evidence.com link?
I actually just got the discovery from Mr. Granum's yesterday evening, so I haven't gone through it yet, but I do have it.
Okay. Well, why don't we do this? We will work on getting Mr. Sanders, well, figuring out where he is and why, and if he's going to be stable in one location. And if that location is Douglas County, we may leave him there. If he is headed to DOC custody, that's more complicated because, as you know, he could be anywhere in Georgia.
Yes.
Ultimately, we need him back here, not just so you can meet with him, but so we can move his two cases along. So we'll work with you on that. Does Ms. Nelson have your contact info? She's shaking her head no.
Oh, I emailed her earlier. That's how I got the Zoom link. So everything should be on that email, but I can do it again.
If you emailed her, she'll find it because you got here. So she will look for that, and we'll keep you in the loop. So you are not taking all of Mr. Granum's cases, just the ones that have gang charges.
That's correct.
Okay. That's better than no cases. But it will not be all his cases. All right. Well, good luck with your job. Mr. Hiles, anything you need to share with Mr. Hoover?
We probably need to meet and go over it. This is just to explain it. Maybe you're really good at interpreting cell phone records, but I can give you all the keys and stuff with that.
Is it pretty cell phone intensive?
Very,
Okay.
a lot of digital discovery, a lot of social media records, but lots of, and then also there's it's called Burla, which is a computer system that's inside of cars that we did a dump on, where your client's cell phone was attached to the victim's phone. And reading that is, it's weird at first.
Okay.
So, I got a couple of cheat sheets for you.
Good. I think you'll find, Mr. Hoover, that in general, I'm not speaking for all of them, but in general, the gang prosecutors here are very helpful in helping the defense attorneys process the discovery. It's not in their interest to just give you a mountain of stuff and say, see what you think. I don't know anything about this case, but it may be that all the digital evidence makes life look really bad for the co-defendant, and that would be a reason for your client to want to work something out. It may be the reverse, but I suspect you'll find that Mr. Hiles will lead you right to what he thinks are the particularly compelling parts of the digital discovery, so that you more quickly can get up to speed and thus sooner get together with Mr. Sanders to say, hey, you better have a good story for this because it's going to be hard to defend against it. Or, hey, look at this. It shows you were in France when this happened. Let's go forward with that alibi. I assume it doesn't show he was in France. Not so much. Okay. Did you find Mr. Hoover's contact information? Great. We're linked. So Mr. Hoover, we will reset this for probably what I will call an inquiry. Status usually means it's been on some calendars, and it really is, hey, anything else before we put this on a trial calendar? And that's where we were with Mr. Granum's, because he had it for a while. But we need to reset a little bit so that you're given a fair amount of time to connect with the client, wherever he may be, and to wrap your arms around the discovery. Does that work for you?
Sounds good, Judge. Thank you.
Okay, you're welcome. Nice meeting you. Was that your only case on this calendar?
Yes, sir. I believe it is.
Best of luck with your new job.
All right. Thank you, sir. May I be excused?
Yes, sir.
Thank you.
Okay, we're waiting on an interpreter. Okay, and I don't see Mr. Mann. Okay, Mr. Melnick, you haven't had a chance to talk to Mr. Carter yet?
No, I've got another case on the calendar too.
Okay, well, let's press it. We may be able to get through some of this and then when I'm doing 413 here and you could get back and see him. How about Mr. Pittman? That's your client, Mr. Cladis. You have connected with him? Great. Let's bring Mr. Pittman out, please.
That's the co-defendant, Mr. Chambers.
It is. I can tell because he takes up an entire page. Your cases take up entire pages of calendars. Ms. Charles is I can get 3, 4 cases on one page. The trees are falling.
Killing the planet, one indictment at a time.
Uh-oh. Sure. Okay.
Your Honor, may I ask if the court might know when Mr. Pittman's last bond hearing was? I couldn't see anything in Odyssey that indicated that there's been one.
That can be your parting gift to him? I don't have any bond hearing. Was it re-indicted?
No.
It was just an indictment in August, about a year ago. There's an indictment. So I don't know what happened on the CP side of things, but since the indictment of there has been no activity other than you getting approval to take evidence out to the jail. Haven't been a lot of on the docket work from Mr. Pittman wrote a letter in June. He wants his discovery. Oh, he's not here?
No, before.
Oh,
He was asking when last time.
okay.
I was just saying that's what it was. Having a seat for you. Thank you.
No problem. Everything okay? Good. Hello, Mr. Pittman. How are you?
How are you doing this?
I'm doing all right. Mr. Pittman, today we were going to talk about whether your case was ready to go to trial. But I learned recently, as I know you've learned, that Mr. Cladis is going to pursue a different opportunity rather than serving as a criminal defense attorney. So we need to get you a new lawyer who can review the discovery first for him or herself and then with you, and be in a position to help you decide, is this a case that ought to go to trial? Is it something you should try to work out or what? So I don't think it's fair to me to ask Mr. Cladis today, when will this case be ready for trial? Because he won't be the lawyer who would take it to trial if that's where it goes. Hopefully me telling you that is not news. It's not a happy message, but I think you've already heard it. You've been in jail for a while now. I was just looking at the docket. You're coming up on a 1-year anniversary if you haven't had it already here in Fulton, although my staff was telling me you may have been in custody in Clayton before you came here. But either way, it's too long to be sitting in jail without a trial or some other resolution to your case. So I remain committed to helping find a lawyer who can stick with you and stick with the case so we can sort out what's going to happen with it. Do you have any questions about that? Other than when? Okay. Mr. Cladis, you remain Mr. Pittman's lawyer until you withdraw. So if there are things that you want to do between now and then, reach out to Ms. Nelson and obviously Mr. Hiles, and we'll address those.
Yes, thank you, Your Honor.
Okay. All right. Mr. Pittman, when I know who will be replacing Mr. Cladis, we'll get you back here so that we can have a conversation, you and I and that lawyer, about how much time that person needs to be ready to move forward with your case. Okay. All right. Thank you. Yeah, she walked in. All right, let us do the Salmorons next. Who's handling that for the state?
Good afternoon, Judge. That'll be my case.
Welcome. So one is on bond and should be here. I'm not seeing Felix Salmoron. Anything you want to do in connection with Mr. Felix Salmoron?
Judge, I did see that request for continuance was filed by Mr. Mann, I believe, yesterday. However, given that Mr. Salmoron is not here, the state will request a bench warrant and bond forfeiture this time.
Okay, we'll do that. Let me look. When you're ready, if we could have Ruben Salmoron out. And if we could have our interpreter come on up, please. Mr. Cladis, you just let the interpreter know where she should sit vis-a-vis your client.
Okay.
Felix. You filed a leave of absence. You're here, though. Your leave is for after today?
It's for after today, Judge.
Okay.
Hola, señor, yo soy la intérprete. Gracias. Ay, gracias.
All right.
Muy bien.
Are you Ruben Salmaron?
Es Rubén Cano. That is correct, Your Honor.
Great. Mr. Cladis, have you shared with Mr. Salmaron your employment situation?
I have, Your Honor.
La situación de que usted va a fungir como el abogado de él. Sí.
Mr. Salmaron, you understand that Mr. Cladis is going to take another job soon?
Fungir como su abogado, él va a tomar otro trabajo. ¿Entendía esto?
Sí, ya me había comentado.
Yes, he had already told me something about it.
That means we need to get you a new lawyer.
Le tenemos que conseguir un nuevo abogado. Yes, thank you.
You're welcome.
De nada.
As soon as we get that lawyer,
Nosotros podamos obtener ese abogado.
I'll bring you back here
Lo voy a traer aquí.
so we can talk with that lawyer about how quickly that lawyer can be ready.
Tan rápido puede ese abogado estar listo para representarlo. Very well, thank you.
Do you have any questions about that?
¿Tiene usted alguna pregunta al respecto de eso?
Entiendo que son términos y son tiempos que se tienen que pasar aquí en el sentido de que en cuánto tiempo me tendría yo el abogado, o en cuánto tiempo me llamarían. Es cuestión de tiempo, pero no sé, algo aproximado.
Well, I know that those are the terms and that time is going to pass before I get an attorney. But I want to know, do you know how long or approximately how long before I know how much time I need to wait?
That's a great question. Mr. Cladis will need to help you with that. I don't know how his office is going to handle that transition.
Yo no sé cómo su oficina de él va a manejar esa transición.
Entonces tendré que comunicarme con él. Conmigo.
All right. So do I have to contact him or he's going to contact me?
He will contact you.
Él lo va a contactar a usted.
And once I know that there's a new lawyer, we'll bring you back here.
Si hay un nuevo abogado, lo vamos a traer a usted de vuelta aquí. Okay. Thank you very much. You're very kind.
Well, you're very welcome. And I'm sorry that we're having another transition like this.
Okay. Hubo una transición así otra vez. Yes, that's fine. That's fine.
Mr. Shapiro, is the state ready to go forward with this case?
La fiscalía está lista para
Are there discovery issues you're aware of and outstanding things you haven't been able to get?
Not that I'm aware of. The only possible matter is we need to file a more particularized child hearsay notice where there was a case management order that was entered before I was on the case. But we should be able to have that filed, I think, by the end of the week.
Okay.
Que me gustaría obtener
Nothing
para proceder en el caso,
being placed on a trial calendar.
pero no hay nada
Okay.
más que esté pendiente con respecto a el litigio que se irá a juicio.
All right. We're all done. We'll see you soon, Mr. Salmaron.
Nos vemos pronto, señor Sanara.
Muy amable, señor. Gracias. Dios los bendiga.
You're very kind. Yes, and all three of you or four of you, God bless you.
You too.
Usted también.
Gracias.
Thank you.
All right. He's good to go. Deputy Remy, thank you.
See you at the jail.
Lo veo en la cárcel.
So Ms. Nelson will be in touch with you about the bench warrant. I don't know how that flows, but for Felix, we'll handle that.
We'll get Ms. Nelson to order judge to the following forfeiture.
Okay.
And does my own position, General Manager?
You may.
Thank you.
May the interpreter be excused, Your Honor?
Yes, ma'am. Thank you for being here.
Your Honor, I apologize for interrupting court. So for Mr. Felix, would that be a pretrial bench warrant since he's out on the signature bond?
I don't know. Is that what it would be?
Yes, well, let me make that announcement. That would be a pretrial bench warrant for
Excellent.
Mr. Felix.
Great. Does that mean Ms. Nelson will be coordinating with you? I don't, these bench warrants appear, I sign them and they have their desired effect eventually. But will that,
She would probably be communicating with someone through the pretrial supervision unit.
all right, we'll figure it out. Thank you. That gets us to our guest from Phillips State Prison, Mr. Curry. Mr. Curry, can you hear me?
Yes, sir.
Great. You've been very patient. I'm gonna make you big on the screen there. Ms. Wood, do you have Mr. Curry's case?
Yes, Judge, he's mine.
All right. And Mr. Whitenauer, your case? I got a bunch of DA's names on it, so I don't know.
For Curry, Judge?
Number 8.
Right, no, Judge, that will be handled by, yeah, it'll be Miss Charles, this person right here.
Well, good. She's here too. All right. Well, let me start with Ms. Wood. And Mr. Curry, all we're doing right now is sorting out whether we can move your case to trial. What are you in the Department of Corrections for? Is it a case from Fulton County?
It is, Judge.
It is.
It's a revocation from Judge Kraus.
Oh, okay.
Judge, if we could come back to this one, I have an offer that I would like to convey to him. So after the call, if I could just do a breakout session, I'll get on Zoom.
Sure.
See if we can resolve this today.
All right. Do you have other cases on here or do you want to?
I have one more, Mr. Heinzman.
Okay. So, Mr. Curry, sit tight. Ms. Wood is going to talk to you privately, and it may be that your case can be resolved today. She got an offer that she wants to share with you so that you and she can talk about whether that's something that makes sense for you, okay?
Yes, sir.
All right, so sit tight. Mr. Gladys, these are all your cases. All right, DeAndre Smith. Oh, he's back. I don't know where he went. Did he just run out of the courtroom?
I can check the hallway, Judge.
That's all right. How about, is Mr. Heinzman here? He is here. Okay. Why don't we wait for Mr. Gladys and that way we can talk about them together. You filed a motion that we need to hear, but we'll do that. I don't think that's gonna. All right, so let's hold off for Mr. Gladys to come back. He's got Jerry Peck. Who's got Jerry Peck now from?
Judge, I'm handling position 11. Mr. Brown, 88 Brown will be handling 12 and 13, but I think ultimately you would be stepping in for those two.
Okay. I gotta have Mr. Gladys here, but we need to bring Mr. Peck out. Just be ready.
I'm sure he will want to be heard, Judge, yes.
All right. How about Andre Ruddock? That's Mr. Gladys. How about Mac Ransom?
That's my case.
Do you need to, well, but we can't, we need him out here. Are we able to get someone out? Do you know?
Yeah.
Do you need to talk to him first or can he come out? Oh, you wanted to talk? Well, how about this? You needed to talk to your clients. If they can get you back there, talk to your clients while we try to find Mr. And if you see Mr. Gladys back there, bring him out with you. There he is. All right. Well, if I could have one out while he's back there, that'd be great. If you don't have enough people, then let's let Mr. Melnick talk to his two folks and I'll talk to Mr. Gladys. So Mr. Gladys, when things open up, so Ms. Wood, who do you have left? Why don't you go talk to Mr. Curry? Who did I skip of yours? Oh, right. So why don't you go talk to Mr. Curry? When I see you on, then I'll drop him into a breakout room with you. So we're going to bring Jerry Peck out in a minute. How's your relationship with him?
I've met with Mr. Peck. I think it's.
Has he embraced you as his lawyer?
I mean, I think our relationship is professional and as well as good as it can be under the circumstances.
Okay. I'll be more to the point. He has expressed to me in the past that he and only he will represent himself. This was before he met you. So what's your understanding of where he is now on that?
That is not my understanding of where
Okay.
he is being represented.
Are these cases, maybe we could do a carve out and you could keep them after you go to the DA's office?
I mean, I can take it up with everybody involved and see what they say.
I think it would matter most to Mr. Peck. If he's okay with it, that would work out, but I don't think that's what will happen. Okay.
Your Honor, I think we've handled all my cases on the calendar this afternoon. May I be excused, please?
As long as the folks remaining will cover for you. If you're wrong, that's fine. I think you're right.
Yeah. I haven't asked them, but I'm sure they will.
Your Honor.
Yes, sir.
Position 14.
Hold on one second. Let me just see if Ms. Wood, she's joined. Let me just get these folks in the breakout room. So Mr. Curry, I'm going to put you in this breakout room now. When you're in there, it's private. What you and Ms. Wood have to say, no one else can hear or see or anything like that. And then we'll pull you out of the breakout room when Ms. Wood comes back in here. She's in a private room right now, okay?
Yes, sir.
Excellent. They're gone. You were telling me about position 14.
Yes, I believe Mr. Ruddick may be in custody in Washington State.
That's far from here. Okay. He isn't here. So we'll do, assuming Ms. Charles wants to, a bench warrant. It's resolvable if he's not here because he's stuck in custody in Washington. That may be a reason to revoke his bond that he got on this case. But how did you learn about Washington?
I was attempting to contact him and I spoke with someone who is a family member of his. They didn't have a lot of information. And I have not spoken to Mr. Ruddick. I have not been able to contact him.
Okay.
Clarify that. No, you should, because.
Didn't see.
How's looking for Reddit?
That's good.
You can look in Washington? Wow. We'll do a bench warrant. Ma'am, what case are you here for?
Mr. Hardiman, but he was this morning and then it was talked about.
It's still supposed to be talked about today. We have not forgotten about him. Mr. Melnick, are you ready to have your defendants come on out?
Yes.
Great. We're ready for Anthony Carter, please. Thank you.
Very authoritative.
Judge, I know we're not on this case right now, but on Mr. Ransom's case, I had filed a motion to reduce his bond. And that case is just going to be on for status. With Carter, I think we might have a plea.
Okay, well, he's coming out,
yeah.
so I guess we'll find out. All right, 1 second. Okay, this is the status conference for Anthony Carter. Hello, Mr. Carter. I'm doing okay. We are here to figure out if this case is ready to go to trial. Your case a while ago had been put on hold at your lawyer's request because we were working through COVID and starting to have trials, but what those trials were going to look like weren't so clear. And Mr. Melnick wisely thought, let's not make Mr. Carter be the guinea pig in case jurors can't hear well or masks make people nervous or who knows what. But we are past that now. We've had dozens and dozens of jury trials. And so your case is back. And today I need to figure out, after talking with your lawyer and you and the prosecutor, what we're going to do. Ms. Charles, is the state ready for Mr. Carter's case to go to a trial calendar?
We will be under, I believe, Mr. Miller can have reached an agreement where we bring back the final number, but the agreement.
I think we have a negotiated plea, Judge.
Okay. Is that news to you, Mr. Carter, or you think you're ready to take a plea in your case? Yeah, you're ready?
Yes, sir.
Okay. Well, why don't you and Mr. Melnick come on up to the podium?
Judge, I have not been over any Boykin rights with him as yet. Do you want me to do that first, or are we just going to do it on the record?
We'll do it on the record. I'll just make sure Ms. Charles is her usual thorough self on this. So, Ms. Rivers, this will be a plea to position 1 on our status conference.
Okay, ready.
Sorry, Judge, there was one small point I just had to clear up with Mr. Charles.
No problem. This is a fluid process.
And just so you know, the plea, Mr. Carter is tendering the plea under Alford versus North Carolina.
All right. We'll cover that as well. Mr. Carter, in a moment, Ms. Charles is going to put you under oath. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. It is just as important that if you have questions because something that's said doesn't make sense or is different from what you and Mr. Melnick talked about, that you let me or Mr. Melnick know so that we can clear that up. Will you do that?
Yes, sir.
Great. When you're ready, Ms. Charles.
You, sir, affirm the testimony you shall give in my conference, court shall be true, the whole truth, and nothing but the truth.
I can't hear
Yes.
you.
Just move the mic. Thank you. I start over. Mr. Carter, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And lower your hand. You may. Please state your true, correct, and legal name.
Anthony Bernard Carter.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
38. Graduated.
Graduated high school, college?
High school.
High school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with the following offenses?
Yes, ma'am.
In indictment 19 SC 173705, 1 count of aggravated assault, 1 count of armed robbery, possession of firearm during the commission of a felony.
Yes, ma'am.
Your Honor, we'll be null processing the possession of a firearm during by a convicted felon.
Okay, because Mr. Carter is not a convicted felon, or this is just what was negotiated?
Now, when we looked into his history, I think one of the original charges was the first offender. And when he was revoked in probation, that first offender was not revoked.
Okay.
That would have to go.
Yeah, that's correct.
So the case out of Douglas County, that is the predicate felony, was a felony plea, but it was a felony first offender plea.
That's my
Okay.
understanding, Judge. Yes.
That's how we'll proceed.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Could you speak up, please?
Yes, ma'am. I wanted to plea. I wanted to plea on the alpha plea.
Yeah, that's right.
It is. Yeah.
And we're going to make that for the record.
We'll cover it, but Mr. Melnick said up front, Judge, this is an offered plea. And so when you're done answering all of Ms. Charles's questions, I'll have a few for you. And at that time, we'll talk about offered. Maybe even before then, Mr. Melnick may be explaining why he thinks offered makes sense. I have to agree to that. I typically do. But if the facts are you're caught on 1,000 surveillance cameras putting a gun in Mr. Bowens' face and taking his stuff, I'm going to need to understand why it's an offered plea. My guess is it's not that clear, which is why it's going to be an offered plea. But I'll wait to hear from everyone. I promise we'll cover that. Okay.
Have you reviewed the waiver of rights with your attorney?
Yes, ma'am.
Have you had enough time to speak for your attorney, Mr. Melnick, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Counsel, do you waive formal reading of this indictment?
We will.
Counsel, do you waive any and all defects in the indictment?
I'm not aware of any defects, so if there are any defects, they're waived.
Ms. Carter, were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, ma'am.
I'm not aware of any.
I didn't know about any warrants when I was arrested. I was coming from work. I used to do security for over 5 years. So when I was getting off work and I picked up a friend of mine and we was coming from MLK.
So I'm sorry, Judge.
That's okay.
What she meant is, are there any other outstanding warrants related to this actual incident itself? Or
Oh,
to
no,
anything
no, ma'am. Not that I
related?
know of. I don't know of.
And has your attorney advised you of the minimum and maximum sentence for each charge?
Yes, ma'am.
Pleading? Okay. For the record, aggravated assault, looking at 1 to 20 years. Armed robbery, 10 to 20 years. Possession of a firearm during the conviction of a felony, 5 years maximum. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence that is a deviation from the mandatory minimum of 15 years to serve 6 years?
Remember we talked about 10 serve 6? Is that how?
That was mine. I have 15 serve 6.
We had just talked about it right now.
Anyway, we have the short break.
Let me just talk to you.
Sure. Sidebar, just you two.
Yes, please.
Don't go in the jury room.
So they came down to 6, but they're going to keep the period of probation the same. Is that okay with you? Okay, all right. Judge, we've got that resolved.
Okay, let's take it from the top though, by which I don't mean start all over. But Ms. Charles, you were in the process of explaining to Mr. Carter what the state's recommendation is. And if you just start from the top on that.
The state's recommendation would be 15 years to serve 6 years, balance related, no contact with the victim, and stay away from the incident location.
You understand that?
Mm-hmm.
Yes.
Yes.
So that would be triggering that subsection E. You're invoking that so that I have the authority to go below the 10-year mandatory minimum. Okay.
However, part of the state does not have to accept this recommendation. The court may sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
You understand that?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing of other convictions in this jurisdiction, as well as in other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Do you understand that there may be adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be from a conviction after a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony that may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you have gone to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
So this is where, Judge, we would say this is a plea under Alford versus North Carolina. He's not actually admitting that he committed this offense.
Okay.
And are you pleading guilty pursuant to North Carolina v. Alford because you have decided that this is in your best interest to do so?
Yes, ma'am.
You got to speak up a little louder. I heard you say yes. Is that correct?
Yes.
Okay.
Now you are aware that if you do not admit guilt, this is a guilty plea, as if you were convicted by a jury at trial.
Yes, ma'am.
How do you plead to the charges in indictment 19 SC 173705?
Guilty on the offer.
And is this guilty plea freely and voluntarily given with full knowledge of the charges?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, the state is aware of 3 prior convictions for Mr. Carter. They all relate to possession offenses, drug-related offenses, the most recent being in 2018 out of Douglas County. And have this case proceeded to trial, the state would have expected to show out December 2nd, 2019, officers were flagged down by a pedestrian on the street sidewalk of 3657 Martin Luther King Jr. Drive. Mr. Bowens, the victim, stated to Officer Katib that he had been robbed at gunpoint. He had walked out of the grocery store, which was located at 3665 Martin Luther King Drive, and was proceeding to enter his vehicle. As he walked towards his vehicle, there was a car parked to the parallel to his vehicle, and there was a gentleman wearing black pants, gray sweater, white shoes, leaned up against the vehicle. As Mr. Bowens walked past, the male pulled out the firearm, pointed it at him and said, "Give it up." Mr. Bowens put up a small fight based on what we were able to see from the surveillance video of the convenience store. However, ultimately, Mr. Bowens handed over $50, a wallet containing $50, his ID, and a bank card. The male in the video was seen proceeding down Martin Luther King Jr. Drive towards Bolton Road. Officers subsequently put out a bolo based on the image that they were able to get from the surveillance video, and also put out an alert for Crime Stoppers. A few days later, officers received a tip from Crime Stoppers identifying the person in the bolo as the defendant, Mr. Anthony Carter, and officers were told potentially that he lived in an address near Bolton Road. Officers were then able to do some searching within the system and go to the address last known to Mr. Carter based on what was in his previous GCIC. And the picture was of Mr. Carter was then shown to Mr. Bowens, who then identified him in the photo lineup as the person who had robbed him. Your Honor, Mr. Bowens is, was spoken to before. He was terrorized, having the gun pointed at him. However, he's since moved on and put this behind him. Look at the video from start to finish, from the encounter with the defendant to Mr. Bowens. It lasted maybe about 25 seconds. It was very brief. And so because Mr. Carter is willing to take responsibility, we ask that you follow our recommendation of 15-6 and sentence him accordingly.
As far as you know, this was stranger on stranger.
It was stranger and stranger.
But Mr. Bowens, when shown the photo lineup, selected Mr. Carter out of it.
The person in the lineup, the person in the video, if you look at side by side, they matched the
I think the video is kind of hard to see.
Okay, well, it'll be your turn in a minute, and it's an offered plea. All right, let me ask Ms. Jackson, do you have additional criminal history information? Sounds like 3 adult convictions, one of them first offender, all for drugs.
No, Your Honor, I just have that first offender from 2018 out of Douglas County for possession of cocaine. The others were not listed in the GCIC.
Okay. And nothing from other states?
No, Your Honor.
Okay, thank you. I think we've lost Ms. Tucson. Okay, your turn, Mr. Melnick.
Thank you, Judge. So Mr. Carter is 38 years of age. Once he's released from prison, he's going to be living with his mother in South Carolina. So it's very unlikely that he'll ever run into Mr. Bowens ever again. He is offering this plea under Alford versus North Carolina. Judge, so as I said, the video at the store is very difficult to make out. So the only real evidence is the photographic lineup. It's a case that I think could go either way, candidly, at trial. Mr. Carter does not have any significant criminal history. So I think this is a fair resolution. He does deny that he's the person that did this, but he also understands the potential downside that he could be looking at 20 years. If he were to be convicted, he doesn't want to take that risk. So he's willing to tender this plea for the court.
Okay. Mr. Carter, how long have you been in custody?
Like 31 months.
Okay. You moving to South Carolina may make sense. You just need to understand that it can't be an immediate thing after you're released. You will have a period of probation on your case, and that can be transferred to other states, happens all the time, but it's a process. So when you're released, and it's a little ways down the road, but just be mindful, you can't go straight to mom's house.
Like, I don't mean to cut you off or anything, but actually I had moved here. Like, I was on my own. I had my own place, 2 cars. I lost my place, my job, 2 cars, or whatever, due to the situation. The only thing that I did ask, I wrote you back in January, December. I don't know if you read it or if you ever got the letter, but I was only thing I was asking, because I'm on my own and I'm grown, I was really asking for some type of assistance of a program or some type way that I can basically get back on track with a job, a place to stay being that I lost everything that I had during the pandemic of being locked up. And, you know, like, I'm knowing what I'm facing being to this situation. I don't want to go down a road where, you know, like I may never be able to get out again. Because since I've been in Fulton County, I see a lot of people, you know, they have charges and certain things, and they think that at the end of the day, it's a game. And then you get in front of the judge and, hey, man, they get a life sentence or this and that. And it's over with. They wish they could took whatever they, you know, like was offering. But it's just at that point where I just was asking for help, though. Like,
Judge? Hello, hello. Hello.
I'm still here, Miss Rivers. I don't know what happened with the system. It seemed like they froze.
Yes, I sent him a text. Let's see if he. Okay, I can hear now. Oh.
You're back on. Yeah, you're on. They can hear you.
Huh? No, they ain't on yet.
Hmm? You didn't tell that. You know. What is that? What kind of staff meeting would you have? You know what? Kind of, they need to be looking at mine. Ain't nothing on my job description that says about all this court stuff. And doing counseling releases, GCIC. And doing all this attorney stuff. Yeah, well, they didn't go back to them doing that. What? They don't understand. Ask and pass and pass. The campaign officer go get certified. Because when Linda comes back, she ain't gonna know the whole thing again. It took a minute just to get that. No, she had to go on. After that, she gonna make her retest. And then she's gonna this one. And I'm trying to do my research, man, you do that for 2 years. I used to be GCIC. I didn't have a full GCIC. Well, you're not secure enough back here. No. Okay, I'm hoping they'll finish this up. I hadn't done mine yet. I do it the minute I come back from the meeting. While it's fresh in my mind. Yeah, I try to, but I need to for a while. I'll come out, just walking past her, no, nothing. Like, it was a whole thing. But they're all being drawn, right? Because it's, I do in 3 years.
Don't leave. Let me just make sure it's working. Ms. Rivers, can you hear us now?
Yes, I can.
Excellent. All right. Thank you, sir. Somehow the network dropped the podium. We were in mid-plea. We brought Mr. Curry back. We're going to handle his matter in a minute. We need Mr. Carter back out here, please. Ms. Rivers, can you let us know where we were in the process? Wherever you want to be.
Podium spot, Judge.
The last thing that I had, the defendant was speaking. He said, I just was asking for help though, like, and then you dropped off.
Okay, thank you for flagging that. We spent a fair amount of time on that. I'll summarize that Mr. Carter is anxious to have a transition out of custody while he does have the opportunity to go live with his mother. He's 38 and he doesn't necessarily want to be there. Not that mom's is a bad place to go. And so I will certainly recommend that the Department of Corrections consider you for any number of transitional programs so that you're released, not just with $5 in your pocket on the street, but something that helps you bridge that gap. All right, Ms. Charles, You had completed what you were wanting to cover, so we're back to you, Mr. Melnick.
Your Honor, I'm sorry, before we go forward, I just want to add the two other felonies were out of Richland, South Carolina in 2001 and 2005 for possession.
Okay, that's why they weren't showing up on the GCIC, South Carolina. Okay, so you were done.
I'm done.
All right, Mr. Carter, do you have any questions or concerns about any of the stuff we've been talking about, other than what you've already shared and which I've definitely followed? You're good?
Yes, sir.
So about that Alford plea, you have a right to tender a plea that we sometimes call it a best interest plea. That, look, I don't know that what happened is exactly what the state said happened, but it's in my best interest, meaning Mr. Carter's best interest, to take this plea for all the reasons you described. You roll some big old dice and the jury believes Mr. Bowens, maybe Mr. Bowens stands up in court and says, that's the guy who did it. Jury convicts you, and all of a sudden that offer of 6 years is gone and you were wishing it was back. And so I've heard you say to me today that you would prefer to go forward with this plea, and that after you've had a good long chance to talk with Mr. Melnick, you think it's in your best interest to take this plea, even though you're not saying that word guilty. Is that correct?
Yes, sir.
All right. I can accept the Alford plea. I do find that there's a factual basis for the plea, by which I mean, if this did go to trial and the state was able to present the evidence it thinks it has, Mr. Bowens comes in here and IDs you, or he ID'd you from the photo lineup, a jury could find you guilty. I don't know what they would do, but it's that uncertainty that makes you nervous, and I get that. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about, and if you didn't, I watched you do it. You bumped Mr. Melnick and you guys conferred. Do you feel that at this point, Mr. Carter, you've understood all your rights that you have as a criminal defendant and that you're waiving many of them by entering this plea?
Yes, sir.
Voluntary just means no one's forcing you to enter the plea and you're moving forward with it on your own free will. Is that true also?
Yes, sir.
Okay, then I'm accepting your plea, Mr. Carter. I will accept the state's invitation and sentence you pursuant to 1710 6.1E, which is a numerical way of saying I can go below that 10-year mandatory minimum that armed robbery has. I think this case fits that profile. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Carter, is that while you're on probation, whether you're in Georgia or South Carolina, if you have a small or technical violation, you and probation will work that out. But if it's something bigger, you get arrested again, that comes back to me, and I'll sort out what ought to happen if the state can prove the violation. I will sentence you, Mr. Carter, on count 1, that's the armed robbery count, to a term of 10 years to serve 6 years with the balance on probation. You'll get credit for all the time you've been in. So those 31 months, those already go up against the 6 years you'll need to serve. Your sentence on count 2, the aggravated assault, will also be 10 years to serve 6 years, balance probated. Finally, count 3 has to run consecutive, has to be 5 years. I'll probate that. So that gets you to the 15 to serve 6 that your lawyer negotiated for you. Special condition of your probation number 1, stay away from, is there a convenience store? It's
sort of a plaza, so the 3600 block of Martin Luther King Drive.
Okay.
So 3657 and 3665, that entire.
We'll just stay away from that end of MLK Drive. Away from the 3600 block, and no contact with Mr. Bowens. That should be easy. Sounds like he's a stranger to you. If for whatever reason you end up on the same cruise ship with him, you got to go to the other end of the cruise ship so you guys aren't in the same space. Probably shouldn't even be on the cruise ship with him. I will recommend to the Department of Corrections that they get you into whatever transitional programming they can. I can only recommend to the Department of Corrections. I'm not their boss, but they'll listen at least, and then you'll have more influence than I do. If you are there and you're doing what you need to do, maybe saying, can I take these classes and staying out of trouble? They're going to want to help you in that way. If you get there and you're a pain in the rear and you're shoving the security guards there, they're not going to be interested in doing anything like that. So you'll control your destiny to a certain extent. I think the last thing I've got is that normally, Mr. Carter, I say normally, years ago, we would pass around the indictment and you'd sign it indicating your offered plea. Do you authorize me to electronically sign it on your behalf?
Yes, sir.
Mr. Melnick?
Yes, sir.
And Ms. Charles?
Yes, Your Honor.
All right, Ms. Charles, anything else in Mr. Carter's case?
No, Your Honor.
Mr. Melnick? Mr. Carter, best of luck with everything. I'll get that sentence signed today or tomorrow and you'll be on your way.
I appreciate it.
All right, take care.
All right.
So why don't we do Mr. Ransom, since you're standing right there?
Judge, will you hear the bond motion today?
Are you ready to talk about bond?
Your Honor, that was just, I would need a little bit more notice.
Pardon me?
No, Your Honor.
Okay.
Can you check? I don't have a calendar right.
What is-
I was
was it
on the calendar, but
I did.
Previously on status conference, it was reset. You had an emergency and couldn't be here. It just says reset. That doesn't mean we won't talk about bond today, but let's just have it happen in short order. Today, we'll talk about trial readiness. And then I'll make plain that we'll get Mr. Ransom back here before then. We don't need to wait for the trial calendar to have a bond hearing. After we do Mr. Ransom, let's do Mr. Curry so we can get Phillips State out of here.
You all right? You all right?
All right, can you bend the microphone towards you all, please, Mr. Melnick? Great. This is position 15 on our status calendar, State versus Mac Ransom. Mr. Ransom, how you doing today?
Good, sir. Good afternoon. How you doing, Jerry McBurney?
I'm doing okay. Good afternoon to you.
Good to see
Mr.
you.
Ransom, I'm going to find out today whether the state's ready to get your case to trial, find out from Mr. Melnick whether he's ready. We were supposed to have this conversation at the end of May, but Mr. Melnick had a family emergency and couldn't be here. Let us know that. We had to reset it. Today's that reset date. Ms. Charles, has all discovery, as best you know, been provided to the defense?
Yes, Your Honor, but Mr. Melnick did alert me of some difficulty in opening some of the videos and asked me to redisclose. I'm in the process that has given me his passport. I'm in the process of now uploading that to his drive.
Are these videos surveillance videos or body cam videos or something different?
The 911 call and the body cams.
Okay, got it. Mr. Melnick, assuming you can open those files, it's not that you never received them, they just weren't playable. Assuming you can open them, any reason we couldn't move Mr. Ransom's case to a trial calendar?
No, Judge, we're ready to move it to trial calendar.
Okay, it doesn't sound like those would yield any suppression motions. If they do, and you're surprised by them, let us know. Maybe there's a Jackson Deno thing we need to work through, but that we could do on the eve of trial. I don't think we need to slow the case down for that. So we'll do that. Mr. Ransom, Mr. Melnick has been asking about bond on your behalf.
Yes, sir.
The state isn't in position to argue bond today. It wasn't on the calendar for bond. That's not Mr. Melnick's fault. But what I'm gonna do two things. One, I'm gonna move your case to a trial calendar. So late summer, early fall, this will be ready to go to trial. That doesn't mean you have to have a trial. You and Mr. Melnick may still work out some kind of resolution to the case. But if it's not resolved, then I'll expect Mr. Melnick to say he's ready to go. And I'll expect Ms. Charles or her successor to say state's ready to go, and we'll do that trial. One way or the other, we need to get closure for you. You've been sitting in jail for a while. Before that day, we'll get you back here either in person or you might appear virtually, depending on what date we can get, so that Mr. Melnick can argue bond for you. And I'll listen to that. I'll listen to what the state has to say. And does Mr. Ransom have no bond or he has a high bond?
He has a high bond, Judge.
Okay, so Mr. Melnick is going to be asking me to lower that bond. Ms. Charles or her colleague will argue, keep it the same or go ahead and lower it. I'll decide whatever I decide. Regardless of that, we'll still get that trial date in as well. Okay?
Yes.
Any questions about any of that?
No.
Okay. Mr. Melnick will be seeing you, especially after he can see those videos. There may be something he wants to share with you because it may influence what you and he are going to do with the case. Ms. Charles, anything else in Mr. Ransom's case? All right. Thank you, Mr. Ransom. We'll see you soon for bond and then after that for trial.
You don't know how soon, Jerry McBurney?
Well, the bond would be in the next few weeks. Trial, like I said, would be more end of summer because we've already published trial calendars through the end of September. So it would be October. I guess that gets us into fall. It would be fall when you'd be on a trial calendar. Bond will be before that. Okay,
Thank you, Judge.
you bet. All right, Mr. Curry, we're going to talk about your situation now. I am going to spotlight you. There you go. You're big on our screen. This is position 8 on our status calendar. Be back here tomorrow. Yes. Okay, thanks. All right, Ms. Wood, are you ready to go forward with Mr. Curry's case?
Yes, Judge.
Okay, Ms. Charles? All right. Is this a negotiated plea?
Yes, Judge.
Okay, to all the counts?
No, Your Honor, all the counts except for the aggravated battery, there's still no crossing.
My
Aggravated
calendar,
assault, I'm
okay,
sorry.
got it. All right, so Ms. Rivers, we've got a plea to count 8, to case position 8 on our calendar. Are you where you're going to be, Ms. Charles?
Yes,
You can be wherever you want as long as the microphone is
it's on.
near you. Okay, then let's get on the record. This is 21 SC 178911, State versus Curry. Mr. Curry, you have a right to be here in court with me and with your lawyer, but you can waive that right if you are willing to move forward from where you are, knowing that if you need to speak privately with Ms. Wood, we can do just what we did before, get you in a breakout room so you can have a private conversation. Are you willing to proceed with you at Phillips State and the rest of us here in Fulton County?
Yes, sir.
Okay, we'll do that. Ms. Charles is going to put you under oath in just a moment. Once you're under oath, please answer her questions and mine truthfully and completely. And let me know if you've got any questions of your own. If you can't hear what's being said or you just don't understand what people are talking about, let me know and we'll work through it, okay?
Yes, sir.
All right, Ms. Charles.
Thank you, Your Honor. Mr. Curry, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Ma'am.
Please state your true, correct, and legal name.
Quintavious Curry.
Can you please spell that?
Quintavious.
How old are you?
Curry.
Go ahead.
Last name Curry, Curry.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
20. Right now, I'm currently enrolled in charter school and at the grade level 10 going on 11.
When you say enrolled in charter school, is that something you can do at Phillips State or you were doing it till you got locked up?
That's what I'm doing right now while I'm in Phillips State.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with the following offenses in indictment 21 SC 178911? Fleeing and attempting to elude a law enforcement officer, theft by receiving stolen property, interference with a government property, obstruction of a law enforcement officer, and reckless driving.
Yes, ma'am.
Do you understand that you have the right to plead either guilty and not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you reviewed the waiver of rights form with your attorney?
Ma'am.
Have you reviewed the waiver of rights form with your attorney?
Mr.
Yes,
Curry,
ma'am.
those are the questions we went over in the back.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Woods, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Mr. Curry, do you recall being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
We do not.
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to today?
Yes, ma'am.
Or the record of felony fleeing and attempting to elude 1 to 5 years, theft by receiving 1 to 20 years, interference with government property 1 to 5 years, obstruction of a law enforcement officer misdemeanor maximum 12 months, and misdemeanor reckless driving maximum 12 months.
Yes, ma'am.
Do you understand that this is a negotiated plea, which means that the state will recommend to the court a sentence of 8 years to serve 2 years, balance on probation? And I believe we had requested a special condition to get his GED, but it sounds like he's already doing well.
He is
So it
working
would
on
just
that.
be 8 years to serve 2 years, which will run concurrent to the time he's serving at the Phillips State Prison. However, the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively, which means one after the other.
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Mr. Curry, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
And how do you plead to the charges in indictment 21 SC 178911?
Ma'am.
How do you plead to the charges in indictment number 21 SC 178911?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of all of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, the state is aware of 2 adult felony convictions for Mr. Curry, most recent being the 2019 Fulton County.
And what were those charges in 2019?
Hijacking of a motor vehicle.
Okay. I assume that got reduced. Is that the Judge Carnesale case that is the revocation? What doesn't mean, even if that should be 10 years.
I believe may have been reduced on negotiations. I can have a look.
Do you have a case number?
Yes, Your Honor.
I'll look it up.
Pulling up.
Or you can look it up.
Yes, it's 19 SC 170777. And the other number, if you'd like that as well.
So that was a first offender plea about 1 year before this case happened. And
second degree hijacking.
Gang charges, tend to serve 18 months. Okay. All right. Anything else?
Yes, Your Honor. Had this case proceeded to trial, the state would have expected to show that on December 14th, Officer Innes was in the area of Georgia 166 and Main Street on patrol. And while on patrol, he received an alert of a vehicle ahead of him, a 2019 Lexus, which had been reported stolen a few days prior out of Hayville.
This is a state trooper. This is Trooper Ennis.
Yes, Your Honor. And the officer proceeded to follow the vehicle and activate his emergency lights. Officer Ennis attempted to box in the car. At the same time, Officer Ennis was trying to sort of close in on the vehicle to stop it from reversing. Mr. Curry was able to sort of hit the car, Trooper Ennis's car as he was reversing out, turn, and then fled the area at a high rate of speed down Main Street with no headlights, heading onto Georgia 166 eastbound. Then Mr. Curry tried to exit for Sylvan Road, lost control of the vehicle, traveled across a concrete median and struck the telephone pole and concrete wall. He was then taken into custody as the vehicle came to arrest there.
Okay.
And so.
And this is all, I don't know where 166 is. What city would
This is
this?
here in Atlanta.
It's in Atlanta?
Yes, Your Honor.
Because this Main Street
It says
said to me.
we have an address of 2641 Main Street, Atlanta,
Okay.
in the area of Georgia 166,
Okay.
which is behind the Texaco.
Okay. Got it. Ms. Jackson, do you have any additional criminal history information for Mr. Curry?
No, Your Honor, just those first offender sentences. I apologize.
Okay, thank you. Ms. Wood?
Thank you, Judge. One moment, Judge. Judge, Mr. Curry is 20 years old. He is a lifelong Atlanta resident. He was living with his grandmother, his mother, and his 2 siblings prior to this arrest. He does plan on returning to that home once he's released. As he's already stated, he has a 10th grade education. He's currently working on his GED while in DOC custody now. He's also indicated to me that he's taking some other classes while he's at Phillips State Prison. So I know he's eager to really turn it around once he gets out, Judge. And He previously worked at Zaxby's before his arrest. He is also working on some certifications while in prison. Judge, he's actually been in custody continuously since December the 15th of 2020. So that's 623 days. On this case, we would just ask for credit for time served, and they accept the state's recommendation.
All right. Mr. Curry, where was this in Atlanta? What's it near?
Like Lakewood train station, Lakewood Fort Recreation train station.
Okay. Were you injured?
Yes, but it wasn't like, it was like a real K injured, but it wasn't severe.
They didn't need to extract you from the vehicle and get you to surgery or anything?
No, sir.
Okay. And you are in now because I think it was Judge Krause revoked you. What was the basis for the revocation?
She violated me on all the other charges, the intent to reckless driving, thereby receiving.
Oh, so you were revoked for this conduct?
Yes, sir. Yes.
Got it.
3 years, 6 months.
New arrest. Oh yeah, this case. Okay. She took care of business. So instead of saying 3 years, 6 months, it's 2 years because you just want it to fit within the range?
Fit within the range of his 3 years.
Okay. All right. Okay. Mr. Curry, do you have any questions?
No, sir.
All right. Well, I find there's a factual basis for your plea. I'm glad no one got hurt. It sounds like you got shook up a little bit, but the trooper is okay and you didn't crash into some pedestrian just walking by. I also find that your plea is knowing and voluntary. Knowing means you've understood what we've been talking about. You told me you don't have any questions. And voluntary means that you've decided this is the right way for you to move forward and no one forced you to do that. Is that correct?
Yes, sir.
Okay. And your plan when you complete the custodial part of your sentence is to go back to mom's house?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which you will be for a while, if you have a minor violation, you and probation will work through that. But if it is more significant, you get arrested again, you're in a stolen car, anything like that, that'll come back to me and we'll work through what should happen. I will sentence you, count one is being dismissed. Is count three the 1 to 10? I don't know that if you went through, I did a bad job of paying attention, what the ranges are for all these.
Let me go back in your.
Sorry to throw you off. I just don't want to state a sentence for one of these counts that's done work.
Absolutely. Done. Pulling it up, Your Honor, because it was I renumbered it in my little soliloquy, so I wanted to make sure it matches the.
Don't worry about if you can just tell me the name of the charge.
Oh, okay. I'm sorry. Yes, so the theft by receiving carried the wider range of 1 to 20. The fleeing and eluding was 1 to 5. I believe interference is 1 to 5, and then 12 months on the misdemeanors.
Got it. Thank you. Okay. So I'm sentencing you, got to get your indictment up here. Count one is dismissed. Count two is 2 years to serve. Count three is 8 years to serve 2. Count 4 is 2 years to serve. 5 and 6 are 12 months to serve each. All those run concurrently with each other. So it's a total sentence of 8 years to serve 2 years. And you will get credit from the date of your arrest, which was either December 14th or 15th of 2020. You will, I'm setting as a special condition of your probation to get your GED I know you're working on that, but if you get released before you get it, you'll need to get it while you are on probation. Anything else, Ms. Charles?
No, Your Honor.
Ms. Wood?
No, Your Honor.
Okay. Mr. Curry, do you authorize me to sign your indictment indicating your guilty plea?
Yes, sir.
Ms. Wood
Yes, Judge.
and Ms. Charles?
Yes, sir.
All right. Then you are all set. You will need to report to probation when you're released. I guess you're on probation. You will remain on probation, but you're going to want to connect them to this case. You're on probation for that case with Judge Krause. You'll also have some probation on this case, okay?
Yes, sir.
All right. That's it. You are free to leave the room you've been stuck in for a while. Thank you.
All right.
Thank you, Philip State. Oh, that was, appreciate your help.
Thank you, Your Honor.
You're welcome. Okay. Let's get Mr. Smith out here, please. And Mr. Heinzman, you can come on up as well. Mr. Heinzman, why don't you and Ms. Wood be at the podium? And then Mr. Smith can be in a chair with Mr. Cladis. After that, let's get an update on Mr. Hardiman, and then we'll do Mr. Holt, and we're saving Mr. Peck for last. Yep. Okay, let's get on the record for the status conference in 21 SC 179330. We've got DeAndre Smith, who is here in court with his lawyer, Mr. Cladis. We've got Mr. Heinzman, who is here with his lawyer, Ms. Wood. And we've got Ms. Charles as the prosecutor. Ms. Charles, has discovery been provided to both defendants?
Yes, Your Honor.
Anything you're aware of that is missing?
Your Honor, missing in the sense that in the course of preparing this case for trial, I discovered some information, Mr. Heinzman's social media that I have referred to our gang unit to verify whether Mr. Heinzman is documented, which will change a portion of the posture of this case, but it's not confirmed as yet. It's just something we were tipped off to.
Is this something that would affect his status of being on bond, or this is something you already had in discovery back when bond was decided?
If new charges are brought, without speak to Ms. Wood about, it may, but at this point, if it doesn't come back, what we are seeing, things will stay as they are.
Okay. So what you're describing is basically new material for the state. It's not
social
that
media.
you just found under your chair in your office a disc that had something from Mr. Heinzman's Instagram back when this incident supposedly occurred.
It was not available before. It was something I just started looking
All right, this just in. Mr. Cladis, have you and Mr. Smith discussed your employment situation?
Yes, Your Honor.
So, Mr. Smith, you understand Mr. Cladis is transitioning out of his job as a defense attorney to go work with the district attorney's office.
Yes.
It means he can't stay as your lawyer. He'll be on the other side. He won't be in courtrooms necessarily so much, but he won't be able to keep your case. We need to get you a new lawyer. New doesn't mean new as a lawyer, it just means new to you. But that person needs to get to know you as well as the case file. So Mr. Kladdis is going to help with that, and I'm going to work with his office to make sure we get someone as soon as we can. And then we need to have this conversation again, because really what I wanted to ask Mr. Kladdis is, are you ready for trial? And he may well be ready for trial, but he can't represent you at trial because he will soon be developing a conflict that would make it kind of complicated for him to represent you. And we need to get a lawyer who can stay with your case. All right? Does that make sense?
Yes.
Any questions about that?
With the lawyer situation?
Pardon me?
With the lawyer situation?
Yeah.
You know how soon can it be?
As soon as possible. I don't know how soon. Mr. Kladdis is with his office for a few more weeks, and then they're going to need to get someone to take over his caseload. As soon as I know who that person is, we'll get you back here for this conversation again, so I can find out from that lawyer, how much time do you need to be ready to go on Mr. Smith's case? Okay? All right, Ms. Wood, apart from the revelation that their state may be chewing on something that is more current and no less available to you than it was to them, are you ready for Mr. Heinzman's case to move forward to trial?
Yes, Judge, I would ask that we be added to a motions calendar for the motion to suppress that I just filed, but otherwise we'd be ready.
Any reason why that was just filed? Was it discovery you just got, or?
Judge, if you recall, we reset it from the last status conference because the additional discovery that was returned over was like 131 items, and it was very heavy on video surveillance. So it took me a while to get through that, Judge.
Okay, so we will schedule, this is the motion to suppress what I think was a show up identification?
Yes, Judge.
Okay, do you happen to know, Ms. Charles, if there was a show up identification of Mr. Smith as well, or only Mr. Heinzman? Okay, so the alleged victim said those are the guys who were involved in the carjacking. Okay, all right. We will set it down. We may tap the brakes a little bit if I get any warm fuzzies that the new Mr. Kladdis will be here soon, because that person could at least argue the same motion, so we don't need to do it. It's gonna be the same witnesses and everything.
Yes, Judge.
Okay. Mr. Kladdis, I don't know how you've been allocating your time given your job change. Were you thinking about filing a motion similar to Ms. Woods about suppressing the identification?
Yes, I've already discussed it with Mr. Smith.
Okay, so that's something you would counsel your successor to do and to pursue that. So we might want to wait and have that hearing one time with both lawyers and both defendants here.
Yes, Your Honor.
Okay. So, Mr. Heinzman, I don't know what the state's talking about exactly about you and social media and gangs. I don't want you to say anything about it right now, but I do want you to know that your ability to remain on bond hinges on you staying out of things that will get you in trouble. So I'm confident that Ms. Charles is going to pursue this. She's going to share it with your lawyer. There are no ambushes here. But if the state concludes that there are reasons to re-indict this case and add charges, you may not stay out on bond. You may be in the same situation as Mr. Smith, awaiting the final disposition of your charges. Okay?
Yes, sir.
All right. Ms. Charles, anything else in this case?
No, Your Honor.
All right. Thank you, everyone. Mr. Smith, we'll get you back here as soon as we've got that lawyer lined up.
Do you hear that vibrating? He's coming to that option. Do you hear that vibrating? No, because it's ringing.
Might be my phone.
Yeah, I'll be fine.
I'm not okay until I get another time.
Yeah, yeah.
We need to hear from Ms. Wood. What is the plan with Mr. Hardiman?
He's not a negotiated plea, Judge. I would just like to sign him up
Okay.
if possible.
So you need to do that. We need to do Holtz. Do you have enough people that she could be back with a client and we could have someone out here or not? No? Okay.
Do we to wait for Holtz thing to be done, Judge?
I'm just trying to manage everyone's time. It's 3:30. So why don't we do Holt? And then we'll see what we can do with the Hardiman situation.
Thank you, Judge.
You're welcome.
Are you hearing that vibrating sound?
Sort of. It sounds like, yeah, that it's coming from the ceiling. Could be something going on up on the 9th floor in that sheriff's office. All right, Ms. Rivers, are you ready?
Yes, I'm ready.
Okay, we are turning to Angelo Holtz, who is on our trial calendar. It's 18 SC 162134. Good afternoon, Mr. Holt.
Good afternoon, Judge.
How are you?
Good, and yourself?
I'm hungry. I didn't get a lunch break today, but that's not your problem. I'm not in a bad mood. I'm not hangry. I'm just hungry. Mr. Holt, we are going to work through a notice that the state filed about a month ago seeking to introduce what's called other acts evidence in your trial, which we will start on Thursday. We'll be picking a jury on Thursday, day after tomorrow. The state noticed 3 transactions, 3 alleged rapes, one from 05, one from 08, and one from 2017. Mr. Whitenauer, who's one of the prosecutors associated with your case, told me that actually now the state's thinking about only going forward with 2. I'm going to let him talk to me about that. Then I will hear from Ms. Feely today about her concerns and her reasons why I shouldn't let this other evidence in. And then I'll let you know, at least preliminarily, what my plan is, because trial's right around the corner. I don't mean to leave anyone hanging. I wasn't aware of this notice because of some transitions in the prosecutor's side. Normally they file it, but they also send it to my staff. So we know, coming up on a trial calendar, let's deal with this further in advance. And we should have earlier in August dealt with this, but here we are. So Mr. Whitenauer, tell me please what the state's plan is, which 2 you want to go forward with and why.
Yes, thank you. Good afternoon, Judge. I did file this notice and brief seeking to introduce some 413 evidence on July 27, 2022. I did provide a copy to defense counsel, but again, I neglected to provide one to your honor. And so I do apologize for that. I do have copies for the court should you.
I've got them.
Yes, Judge. So as I did announce earlier, the state does not intend to go forward on all 3. It is seeking to introduce the 2005 rape, which is transaction 1 out of DeKalb County, the 2008 rape, transaction 2 out of Clayton County. But it at this time would advise the court in defense that it does not intend to go forward on the 3rd transaction, the 2017 rape,
also out of Clayton County for two reasons. One, that case, we understand, involved the use of a gun by the defendant. And so that's distinguishable from these other cases, the one pending here before Your Honor, and the 2005 and 2008 rape, and that those did not involve firearm. But more importantly, the victim in that case is deceased. So we won't be able to go forward on that.
She is deceased because she got shot or for reasons unrelated to the alleged rape in 2017 in Clayton County. She's dead.
So the facts I have on that rape, no, the weapon was not discharged and she was not shot. I do not know the cause of her death at this time.
Okay, but she's deceased.
That is my understanding. Yes, Judge.
Okay.
So Judge, we did file this notice on July 27th, 2022. I'd note that Your Honor published this trial calendar on August 2nd of 2022, and that it's set for today for trial. So it's well in advance of the 10-day advance notice requirement of 24-4-413. And I'll start with that statute because that's under which we are moving today. Subsection A reads that in a criminal proceeding in which the accused is accused of an offense of sexual assault, evidence of the accused commission of another offense of sexual assault shall be admissible and may be considered for its bearing on any matter to which it is relevant. Subsection B has the at least 10 days language. And then subsection D1 talks about what sort of behavior can be considered by the court for 413, listing OCGA 1661, which is rape. And that is what we believe would be proven by a preponderance of the evidence with respect to transactions 1 and 2. Your Honor, before I talk about those transactions, I would like to provide Your Honor a little bit of information about the case in this court because it's the state's position that the facts in this case are similar to those in those other transactions. The victim in this case is Nowetta, that's Nowetta Davis. And on or about June 23rd of 2018, she met up with the defendant, Angelo Holtz, in this case. They had met virtually on a dating app that she identified as Quest Chat, and that eventually their communications got to the point that the defendant offered to pick her up at her apartment. And he did so, and then took her to Taco Bell and then back to his apartment, his explanation being that he needed a woman's touch to choose some window dressings at his apartment. It was at this point that a first sexual encounter occurred, that the defendant asked for a hug, and that will be important later as I talk about these other transactions, laid her on the bed and asked her to have sex. Miss Davis advised that she did not want to have sex, that she was on her period. Nonetheless, the defendant pulled her pants down, said he did not care about her being on her period, and then proceeded to penetrate her vaginally, ultimately ejaculating inside of her, not wearing a condom. The two of them stayed together into that evening and went to the Family Dollar and then the laundromat and then returned to the defendant's residence. At that time, there's a second sexual encounter in which, and I know before they get back, while they were in the car leaving the laundromat, the defendant was asking Miss Davis for oral sex, and she advised that she didn't want to do that she wanted to go home. And the defendant advised that that he just wanted to drop off his clothes and that he'd take her home, but they didn't go home. They went back to his place, and that's where a second sexual encounter occurred, in which the defendant beckoned Miss Davis into his bedroom, told her to take off her clothes, and she did, but again told him that she was really bleeding. Nonetheless, the sexual act did occur, Miss Davis performing oral sex on the defendant, and then we get to a final third sexual encounter. At this time, the defendant indicated he wanted to have sex again, and told Ms. Davis to turn around on her hands and knees. And the defendant actually maneuvered her body around and then penetrated her from behind. At which time the victim told the defendant she didn't want to do it no more. Nonetheless, the sexual acts continued, the defendant laying the victim on the bed and penetrating her from the back. The victim telling the defendant, "I need you to stop. I want to go to the bathroom." In subsequent interviews, the victim advised that the reason that she participated in some of the sexual activity is that she wanted to get home. Quote, "He told me if I didn't do anything with him, I wouldn't be able to get home. That's the only reason I felt like he wanted me to do that. I just wanted to do anything just to get home because I was too far away from home." Your Honor, she did ultimately present to Wellstar Hospital, where a rape kit or sexual assault kit was obtained, and that was provided to the GBI. Buccal swabs of the defendant were also obtained, and his DNA was identified in that sexual assault kit of the victim, Ms. Davis. Your Honor, I'll now turn to the other two cases from 2005 and 2008. I'll start with them chronologically. First, in 2005, out of DeKalb, the victim is Crystal Snoddy. That's Krystal Snoddy, Snoddy. Your Honor, in that case, we anticipate that the evidence will be that on or about September 17th of 2005, the DeKalb County Police Department responded to Northside Hospital and spoke with the victim, Ms. Snoddy. She advised that she was on a dinner date with a black male that she knew as D'Angelo, or D'Angelo, that they met through a dating app, similar to the facts in the instant case, that they began to talk over the phone for about a month, and that on September 17th, the defendant called her and said that he was going to rent a vehicle so that he could pick her up and take her to dinner. That the suspect arrived around 5:45 and began to kiss her forcefully while they sat on the sofa. It's the state's position that his advances are similar in all these cases, that they begin as a hug or as a kiss or as a request to sit closer, and then it takes on a more forceful and non-consensual nature. In this 2005 rape case, the victim, Ms. Snoddy, was wearing a dress with only her underwear and bra underneath, that the defendant maneuvered her legs up and open such that she was slid down from the back of the sofa where they were seated, and then he got between her thighs and forced his penis into her vagina, pushing her underwear to the side. Again, he did not wear a condom. While this was occurring, the victim, Ms. Snoddy, told the defendant, "You're being aggressive, you need to stop." Shortly thereafter, there was a knock at the door, and it was only then that the defendant stopped. The victim, Ms. Snoddy, answered the door, and it was one of her neighbors. While she's speaking with that neighbor, the defendant got up from the couch and exited the apartment. Ms. Snoddy then told that neighbor what happened and then called her friend Lisa Bennett. And that friend, Ms. Bennett, told her she needed to go to the hospital and not clean up her change. Ms. Bennett transported Ms. Snoddy to the hospital and called police. And while at the hospital, Ms. Snoddy reported that she had been injured internally by the defendant and that she did not consent to the sex. A sexual assault kit was obtained, and in 2018, the GBI received buccal swabs of the defendant. Those were tested, and his DNA was present in the sexual assault kit of the victim on the vaginal, cervical, and rectal swabs. In full candor with the court, it is my understanding that that DeKalb County case involving Ms. Snoddy has been dead docketed. I don't know why. Of course, it's not required that a case be indicted or presently pending before a court or that there be a conviction. But I do note that for this court. The next transaction is out of Clayton County in 2008. The state anticipates that in that case, the defendant, Leona Lightburn, Lightburn, would testify that on or about February 23rd of 2008, that Clayton County Police Department, police officers responded to Ms. Lightburn's residence. She stated that she had met the defendant through a man by the name of Roger Stewart, who was identified as a pastor of Open Doors Deliverance Ministries. Ms. Lightburn advised that she was introduced to Mr. Stewart, who knew she was looking for work. Ms. Lightburn stated that she interviewed with the defendant at Stewart's church in Jonesboro, and that interview was 3 days before the rape, that is on February 20th, 2008. On February 22nd, 2008, she heard from the defendant, who invited her to dinner at his residence. Ms. Lightburn agreed to that dinner for Friday night, but canceled and rescheduled for Saturday. The defendant offered to pay for a taxi to transport her from her residence to the incident location, that being his residence. Once she arrived, she stated that she was in the living room with the defendant, sitting on a couch and watching a movie. Again, in similar fashion to the case here and in Ms. Snoddy's case, the defendant starts with an innocent attempt to get closer and to make physical contact with Ms. Lightburn by asking if he could kiss her, and she refused. Ms. Lightburn advised that the defendant didn't stop there and continued to attempt to make that physical contact by starting to rub and touch on her shoulder. She responded, "What are you doing?" The defendant did not answer. And the next thing she knows is that the defendant is grabbing her and flipping her on her back. Again, actions that are similar to some of these other cases in which he physically manipulates the victims into a position that he desires before he then rapes them. The defendant lifted up Ms. Lightburn's dress, ripped off her underwear, and penetrated her vagina with his penis. Ms. Lightburn told the subject to stop several times, advising that he was hurting her. The defendant told Ms. Lightburn he was not going to put his penis entirely into her vagina, but he continued to rape her vaginally until the point of ejaculation, at which point he rested his head on her breasts. So again, similar to the case before this court and the first transaction, here he is raping the victim vaginally and ejaculating and not wearing a condom. Ms. Lightburn, while laying there under him, tried to push the defendant off of her, but he continued to lay, eventually getting off of her. At that point, Ms. Lightburn went to the bathroom to wash up. There was no toilet paper, so she wiped her vagina with a towel. After doing so, she placed that towel back onto a rack and left the bathroom. It was then that the defendant informed Ms. Lightburn that he did not have any money to pay for a taxi ride back to her residence. But Ms. Lightburn did find a way home, and when she got there, she removed her dress and underwear and placed those items into a plastic bag. She contacted police. They asked her if she'd be willing to be transported to the hospital for a sexual assault kit. She agreed, and while there, a sexual assault kit was obtained. Buccal swabs of the defendant were also obtained after a search warrant, and no surprise, his DNA was found on the vaginal swab of the victim, Ms. Lightburn. Your Honor, those are the facts that we anticipate would come out with these two transactions out of DeKalb and Clayton County. Your Honor, as 413 states very clearly, evidence of other sexual acts shall be admitted for any purpose, and the state would be seeking to admit these other sexual acts, these rapes, for the purpose of propensity, that this defendant rapes women after alluring them either to his house or by making entry into the victim's house, starting with a presumably innocent attempt to make physical contact, a hug, a kiss, a rub, and despite whatever protest there might be, then proceeds to manipulate the victim into a position such that he can then rape that victim. Your Honor, I would note that this rule 413 creates a presumption in favor of the defendant's other sexual offenses and sex crimes prosecutions. And of course, this is different than 404B analysis. And I would like to cite to the court a couple of cases to address the fact that these other transactions are somewhat dated. We have one from 2005 and one from 2008. But I would point the courts to a couple of cases. One is Hill v. State. I have a copy for your honor if you'd like. I provided a copy to the defense counsel. This is a 1987 case.
Also old.
Also old. It's 183 Georgia Court of Appeals 404. In this case, the defendant was convicted of rape. There on appeal, the defendant was arguing that the admission of a prior offense that was 11 years prior to the offense in this case was too long of a time. But the court, and I want to make sure that I cite to this court the right page and the right location. It's on page 3 of the opinion I've provided to you.
You can keep going.
Yes, Judge. That it is one, the court wrote that that 11-year lapse would not itself render evidence of the prior offense inadmissible. It is one of the more important factors in considering admissibility. Once it crosses that threshold, it thereafter affects the weight and credibility of the testimony. That case goes on to cite several other cases, including Cooper v. State. It's also an old case. It's from 1985, 173 Georgia Court of Appeals 254. This case, Judge, deals with a child molestation conviction. Defendant was convicted of 2 counts of incest for his engaging in sexual intercourse with 2 of his granddaughters. He argued that the trial court erred by allowing 2 of his adult daughters to testify that the defendant had sexual intercourse with them when they were young girls living at home. The court noted that although almost 19 years had elapsed between the independent crimes and the offenses which the appellant was charged, they found that that lapse in time between the prior occurrences and the offenses charged goes to the weight and credibility of such testimony, not its admissibility. 2 more, Judge.
Anything from either 11th Circuit or, I mean, I guess we could have had cases, it's been almost 10 years since the evidence code changed, and something could be admitted under 413 that was 15 years ago. Anything, or is that what you haven't found it, or that's what you're about to hand me?
No, I've not found that, Judge.
Okay.
I'll tell you that in looking at Lexis today and earlier in the week, looking at 413, the statute, there really is identified by Lexis the one case, Hill v. State, that I provided, Your Honor, with the 11-year passage of time. So I'm not aware of another. I don't. There may be another, given that it's been, like you say, 10 years. But I do provide these cases to the court in support of the state's argument that these cases, the DeKalb 2005, the Clayton 2008 rape cases, although they are somewhat removed from the offense that we're here for in this instant case, it's not the only thing that this court should consider. And certainly, we would encourage this court to consider the similarity of these offenses, that this defendant, the way he arranges these encounters with the victims, the way he attempts to initiate that physical contact, the fact that he then goes on to manipulate the victim's body in a certain way to commit the offense, that he does not wear a condom, that he does ejaculate, and certainly, oftentimes we'll get questions about, can we prove up this case? Can we prove that it was in fact him? Well, I think we have some pretty good evidence here in these other 2 cases, the GBI DNA evidence from the sexual assault kits. So, Your Honor, we are asking that this court, in line with the statute 413, admit these 2 other acts. I've provided the defense with the police reports for both of those, and we would ask that you grant the state's motion to admit these 413 acts.
So another factor is 403, and that's prejudice. And one way prejudice is measured is whether proving up the other act would sort of consume the trial, become so much of a sideshow that the jurors are confused. Wait a minute, is Mr. Holt on trial for the situation with Ms. Davis, or is it with Ms. Lightburn, or with Ms. Snoddy? What witnesses do you envision the state calling to prove up the two other transactions? Now, you don't need to name names, but I'm assuming Ms. Snoddy and Ms. Lightburn, but you've mentioned DNA. They can't testify to the DNA match. Is there separate witness? Will there be separate witnesses for that as well?
Yes, Judge. So we would have to call witnesses from the GBI, the forensic biologist, to testify to those testings and results. And certainly, I think at a minimum, we would be calling the victims, Miss Lightburn and Miss Snoddy, the GBI forensic biologist. I don't know that we would even need to call the officers, because they would be providing hearsay testimony about what was reported to them. Perhaps we might call Miss Bennett, who we've spoken with, as an outcry witness. But frankly, at a maximum, I would see 3 witnesses for each of those transactions. And Your Honor, I think, could instruct the jury that you're to consider that as 413 evidence, that it's not part of the state's case in chief.
Okay. And do you envision there being significantly more witnesses as to Ms. Davis's situation?
Yes, Judge, because Ms. Davis is yes, because Ms. Davis has some mental health issues, some mental health disorders that have been diagnosed, as well as some learning disabilities that have been diagnosed. And I would anticipate that the state may call beyond her, beyond her friend. We would also be calling not just the SANE nurse, Miss Beatrice Mraz, who went to Wellstar to do the SANE, but also would probably call the attending physician and the psychiatrist, because I think it would be important for the jury to understand why this particular witness, Ms. Davis, has some difficulty in maybe telling them about what happened. It's clear to me from reviewing her written statement that she does not share the mind of an adult. And so I do think that some of those witnesses would be important in order to help the jury understand her appearance and presence on the witness stand and how she communicates some of her experiences. So yes, I would be calling more witnesses than those for these 2 transactions.
Okay.
That's all that I have for the court, unless the court has further questions.
No, that was a very thorough overview of what I would hope to hear from the state. So you would make Ms. Lightburn and Ms. Snoddy available if we needed to make a record of what their testimony would be prior to their testimony before the jury, if that's what I decide we need to do as a gatekeeping function.
Understood. Yes, Judge, we would.
Okay. All right. Thank you. Ms. Feely.
Thank you, Your Honor. As the court has already pointed out, 413 co-section is very prosecution friendly. However, it's still does require.
It is just, it's the law. It's what the law says.
It does still require the balancing of 403. And one of the factors that has already been pointed out is the age of the alleged prior offenses and how that affects the probative value. So the state brought a case where there was an 11-year-old offense, I believe. I would cite to the court, and again, this is federal, U.S. versus Lawson, 112, Fed 3rd, 600. It was a 20-year-old case that was out. So here we have a 14-year-old and a 17-year-old allegation. And so it's certainly the probative value of something 17 years ago that was led to accusations. We just think that the prejudicial effect of that is far outweighs the probative value on both.
Do we measure, though, between the date of the alleged transaction and now, or the date of the alleged transaction and this allegation? because it's almost a 4-year swing. So this case supposedly happened, the case in chief, June 2018. So that's 4 years ago. That shaves 4 years off the two numbers you just gave. I don't know what Lawson says, but it would seem like if we're assessing how probative is it about Mr. Holt's conduct in June of 2018, then we're measuring with that as our endpoint. And how far back are we going? We're going back 10 years, and then we're going back 13 years. Still a long time, but not 17.
So we would stand by that as just too far apart in time.
Okay. Lawson is 112, F3rd 600. What circuit is that from?
That's Second Circuit from 1997.
Okay.
And to go to the state's argument that it goes to the weight and not the admissibility of the age, I think the problem with that is the exact reason that the court is the gatekeeper, because juries do tend to put a lot of weight in 413 evidence when they hear it, regardless of what the actual probative value is or should be. So we are urging the court to keep both of these out, as the prejudicial effect far outweighs the probative value.
Okay. I think you have seized on what the issue is. I think if these two other acts had occurred allegedly in 2017, like the one that the state can't go forward with, I don't know that you'd have a whole lot to argue. Assuming the state could prove it up. Obviously, there's that threshold, but assuming the state could prove it up and it is a lower burden of proof with the other acts, then I don't know that you'd have a lot to work with given 413's nature. But I will look at Lawson. I've read Hill now, and I will let folks know. You should assume for your preparations, Ms. Feely, and for your witness preparation, Mr. Whitenauer / Ms. Charles / Mr. Brown, that they are coming in, given the case law that indicates that it really is a rule of inclusion. But I will jump on this issue of age. And if I have a change of heart, I'll get an email to everyone so you know. And I'll get an order in. I need to do that. But assume, based on what I've heard and having read Hill, that these two other acts will come in, perhaps subject to getting a little bit from Ms. Snoddy and Ms. Lightburn outside the presence of the jury. Although, given the DNA, it sounds like all three, the case in chief and the two other acts, if they come in, are going to be much more focused on consent or lack thereof. It's not going to be identity or was Mr. Holt having physical contact, intimate physical contact with any of those three ladies based on the DNA. Okay. Ms. Feely, anything else you want on my radar as we head towards Thursday?
Yeah, sure. One thing you already kind of touched on, and that is allowing us to examine the two 413 witnesses outside the presence of the jury. Obviously, the state just proceeded by proffer. And if their testimony is ultimately going to be something that would have changed the analysis, we would ask to be able to readdress it and get more information about what we should have argued if it's not as similar, for instance, as what the proffer was. So we would appreciate the opportunity to do that outside the presence of the jury.
Okay, I'll be keeping that in mind. I don't know that I need to make a finding of particular similarity. It may be that the degrees of similarity that Mr. Whitenauer identified help lessen the concern about the age because the probative value goes up because they're more similar, but it is certainly not a hallmark of 413 litigation that they need to be similar. It could be, they don't need to be similar sexual. In fact, they don't even need to be the same sexual assault. It could have been something that involved different parts of the body, et cetera, and it could still come in under 413. But I understand your interest.
Yes, Your Honor. And because of that, we would ask that the state not be allowed, I don't know if they plan to, but to mention the 413s in their opening, because we, again, are going to be hearing that testimony outside the presence of the jury to determine whether there is differences that could have affected the analysis in the 413 hearing. And if the court is inclined to allow it, we would ask for a limiting instruction, because without one, there would be hearing about this evidence without any context, when there ultimately, I imagine, will be a limiting instruction.
So two things, you bring up two different questions. One is food for thought about Mr. Whitenauer's request that Friday not be trial. Friday could be partly when these two people come in and we give both sides a chance to examine them on the record, but outside the presence of the jury, if we're not going to have the jurors come back on Friday. Don't know. Two, you should think about what a limiting instruction would say for 413 evidence. Because 413 allows it to be admitted for any purpose. I've had that request before, and I mean, the correct legal instruction would be you can consider evidence of whatever happened to Ms. Snoddy and whatever you find happened to Ms. Lightburn for any reason you want, which isn't limited. So I don't know that limiting instructions actually apply to 413 or 414. I'm not saying no. I don't want to have judicial error. I mean, set aside, I may have erred by letting it in, but assuming I didn't err by letting it in, if I let it in, if I ought to give a limiting instruction, I will at the outset of the trial, maybe before any witnesses who are testifying about Ms. Snoddy's situation or Ms. Lightburn's, but I don't know what that limiting instruction would say. You don't need to sort that out now. Let's keep discussing it, but just know that I haven't found a good proper limiting instruction when you're in 413 land.
Yes, sure. And the final thing that just to flag for the court is both the state and I filed motions, one motion each yesterday that I think kind of complement each other. Theirs involved rape shield and character evidence of their complaining witness, and mine involved excluding the complaining witness's mental health history.
Okay. I think I had seen the rape shield. I hadn't seen yours, but we'll need to work through those. Okay. All right. And you'll have clothes for Mr. Holt?
We do, yes.
Great. Mr. Whitenauer, anything else in Mr. Holt's case?
No, Your Honor, but just so that I make sure that I understand, Will, Your Honor is going to send an email confirming the court's position on 413, or we're to assume that if we don't receive an email that
I'm provisionally admitting both transaction 1, Ms. Snoddy's situation, and transaction 2, Ms. Lightburn's. I need to do more research on the impact of the age, the remoteness of the other acts. I've got a sense of what the case law says. I mean, I've also read what you all shared. But I'll let you know if I change my thoughts on that. So to me, the variable is, what are we doing about having Ms. Snoddy or Ms. Lightburn testify outside the presence of the jury? But that's a scheduling matter as opposed to, is it in or is it out? If they ended up testifying on Friday outside the presence of the jury, then I could make a more definitive ruling about you meeting your burden of proof, which I think you can based on what you've described, especially with the DNA evidence. But that would address the concern about, can you talk about it in opening or not?
Understood. Thank you.
All right. So, Mr. Holt, we will see you Thursday morning. You'll get dressed out into whatever clothes you have provided or the public defender's office has provided you. We'll spend the first hour here, and then we go to another courtroom for jury selection. Okay?
Yes, sir.
All right.
Okay.
Your Honor.
Yes.
Keeps out there cases. Mr. Wilson is a homicide that's on for tomorrow.
Yeah.
Those are his co-defendants. They have not been indicted yet. They were both just arrested.
Okay. All right. You want me to sign it and you'll file it?
Yes.
Okay.
Wait a minute.
You need to meet with Mr. Hardiman.
I just need him to sign this, Judge.
Yeah, so I think what we'll do, if it's all right, if she could go back there and Mr. Peck could just be at the door, if that works for you all, he doesn't need to come in the courtroom, then we can check that box.
Can I go back there?
So we have Wilson. Is Wilson indicted for murder or something else?
He's indicted for murder, participation in gang activity.
And then these two will be added to it?
Yes.
Oh, I had to, okay, I'm remembering these people. I had to sign some stuff from investigators.
JP Miller.
Yeah. Okay, all right. Is it gonna grow beyond these guys? Is this gonna become some 80 defendant case?
I don't think so, mainly based off the.
Oh, that's right. Is Scott Smith? Okay, all right.
Thank you.
Ms. Rivers, you're welcome. Ms. Rivers, you do not need to take this down. Hey, Mr. Peck,
Hello,
how are you?
I'm okay. How are you today, sir?
You should be impatient. It's been a long time.
It's been a very long time.
So you and Mr. Cladis have talked about his employment situation?
Yes.
You understand that he is transitioning away from the conflict defender's office.
I understand that.
So he will have a replacement. When you and I last spoke, you had expressed a desire to handle your matters yourself. It was a different conflict defender at the time. And if I'm remembering correctly, you and he hadn't really connected well. So Mr. Webb. And so at least that's why I may be misremembering. It's a chance for us to clear it up. That's why I wanted us to talk.
Yeah, thank you. Definitely not very right.
Okay.
What I told you is that I was not an attorney and I did not want to go pro se.
Okay.
That I did want to have an attorney to represent me. You gave me Michael something. And I never heard from him since that day he got released in the court.
Okay, so a couple of things. I don't give you folks. You get the conflict defender. There's a reason, I don't remember what it is, but the public defender's office has conflicted off your case. And so there is a separate office of experienced lawyers like Mr. Cladis who handle cases when there's a conflict where the public defender's office can't represent someone who qualifies for an appointed lawyer. And so that's why you had Mr. Webb. And before that, you had, blanking on her name. And there's no one here still who would have worked with her. But as a female.
Mary Beth.
Yes, Mary Beth, great memory. So Mary Beth was your lawyer. She left that office. And then it was Mr. Webb. So I didn't pick him. He got assigned to this courtroom. And that was your lawyer. And it doesn't surprise me that he did not come to visit you. That was a problem he was having. And he's not with that office anymore. Mr. Cladis replaced him, Mr. Webb, and has been doing a great job of meeting with clients. He's got many, but he's been meeting with clients as best he can, has been taking care of that. Unfortunately for you and for me, he is transitioning out of that job. And so the conflict defender's office will be replacing him, not me, but that office will be replacing Mr. Cladis with a different lawyer. That lawyer needs to get to know you and your cases so that you and that lawyer can figure out what's going to happen. Are you working the cases out? Is it going to be a trial? If it's going to be a trial, the state needs to decide, you got 3 cases, which one the state wants to do first. So that's where we are. I just wanted to give you the courtesy of bringing you over here. I know Mr. Cladis already broke the bad news, but I wanted to confirm it that he is transitioning off and his office needs to get a new person in place so that you'll have a lawyer, because I'm now hearing you more clearly. It wasn't that you want a no lawyer. It was maybe just you and Mr. Webb. That wasn't going real well.
No, it hadn't gone well for anyone in that office, but every attorney that's been in that office, they have not come to see me. They have not given me any counsel. They have not put in any of my motions. Last time I was here, you told me only an attorney could put in a motion. Mary Beth said on Zoom, the first day I met you, that she was putting in a motion for a fast and speedy trial and a bond hearing. My summary showed that those motions had been put in, but I was not brought to court on those motions. Okay, so I've been sitting here all of this time without a bond hearing, never had one. And, far as my fast and speedy trial.
Clearly, you have not gotten that.
No, I have not got that.
Yeah.
I have totally been violated of my constitutional rights. on it.
Well, I don't know about that part, but what we need to do, and it may be Mr. Cladis can assist with that. It may be before he transitions off, he can get you a bond hearing. He can talk with my staff about that. And that may be the right next step. Then we need to meet, you and I both need to meet Mr. Cladis's replacement so we can figure out beyond bond hearings, when can we get that trial? Obviously isn't going to be speedy because you've been in jail for a long time now, but it better be soon. But that lawyer needs to get to know your cases and needs to get to know you so that you all have a good working relationship. You agree?
Well, what I want to do is I want to get to my family. I'm 58 years old. I done spent 3 birthdays in here. I haven't been in front of you to handle none of my business that I should have been handled a long time ago. None of the lawyers have really did anything. He told me in June he was handled. I got a letter from the court saying, and.
Well, we don't need to go through. I didn't mean to keep you out here too long. That's why I had you right by the door.
Last time I talked to you, you said that we was gonna have a longer conversation. The first conversation was very short.
Well, it's not gonna be a long one today because I gotta take this guy. This guy wants to work his cases out. So he's coming out to work his cases out. The main message to you is that we need to get Mr. Cladis's replacement here so that you and that lawyer can figure out if you can work well together. And if you can, let's get you those trials. But while Mr. Cladis is still here, maybe we can get you that bond hearing.
But it's one thing I just want to ask you, and I have to look at the paper in order to ask you.
Okay.
Because I've been sitting here so long, I done got brain tired, and that's not good, you know, so I can't really think. But I want to know if my case could be dead, doctor, because they have not been ready to prosecute me, and they have had me so long. I would like to have my case dead, doctor, so I can spend some time with my family.
Okay. I appreciate you wanting to be with your family. I want to be with my family. The state has been ready. This is not a situation where the prosecutors have said, oh, we're not ready with Mr. Peck. We're not ready with Mr. Peck. It hasn't been the state that hasn't been ready, but your lawyer may want to file a motion on your behalf about a violation of your right to a constitutional speedy. It's different from the speedy trial demand, but it's related. And that's a discussion for you to have with that lawyer when the replacement for Mr. Cladis arrives, okay?
Yeah, I definitely want a motion with my lawyer. If this case is gonna prolong longer, to dismiss this indictment and acquit the defendant for violation of the defendant's right to a speedy trial under the United States Constitution.
That's the right approach. If someone thinks that's the right motion, that would be exactly how it would be worded.
Well,
So
this is my right.
it is.
I'm the one who's locked up, and I really do think, Your Honor, that that is the best motion for my life. Because I could be sitting here another year. I could be sitting here another 2 years.
Well, I don't intend to let that happen.
Okay, well, far as I know, what he discussed with me, it's so much paperwork, it's very confusing. So it's gonna be hard for whatever attorney come in and take this case to understand what's going on.
Well, the way that the prosecutor can help is by letting that new lawyer know this is the case we want to go to trial on, because you got 3. And if the state's going to go forward on 1, your lawyer doesn't really need to worry so much about the other 2 up front. They can focus on the one that's going to go to trial. Okay. But you and Mr. Cladis should talk. It may be that he can get 1 or more of these motions that you've been talking about in place before he goes. All right.
Yes, Your Honor, I just want this to move on, and I don't want it to prolong. I don't want this to be 6 more months before I see you again.
Okay. Well, let's make a commitment to each other that it will be less than 6 months before I see you again. Okay.
It'll be less than 3.
I will see. It really depends on we can get that new lawyer in there. I can't make them fall out of the sky.
Yeah, because I really would like to get this moving, because me just sitting here, and I don't even have a full discovery.
All right. Well, we'll work on that. Okay. Thank you.
Thank you.
Your Honor, that concludes my business. May I be excused. Thank you.
Yes, sir. Thanks for being here.
Let me ask while we're on.
You may.
And I'll make it heard.
All right.
Thank you.
I'm relieving in the ninth hour.
Oh, what? What's up with that? Last I checked, we start at 9 and roll calls at like 8, 6, whatever it is. The special people. Oh, but they were coming up here all the time. Oh, I didn't have my phone with me. Did they have more than one witness? Just that one guy? But that was over early. Where you been since then? Long lunch? Oh, all right. We got one more plea. I'll be right back.
I know they came with it. And then attorney. You'll see if he could do one thing. That's what he didn't tell me. And what's the other two? Yeah, he could. It's invalid. Yeah. Stephanie. And that's what put ourselves on hold, you know, with the fair, all of that stuff. We really didn't get started till about maybe 10 to 30. Well, you know, it's good. But the thing is, it was on, most of them was on the status. We started at 1:30. So this is the 1:30 number. Yeah, we finished with the 9 o'clock. We just had one over. So he's still back there. That's the one she talked to. So he's been back there since 9 o'clock. Oh, Thursday? Okay, well, hopefully it's you, not me.
I go on vacation Friday.
Oh, well, you know, they. All right, we got that one. Mhm.
Might be you.
All right.
Hey. Ms. Jackson, are you still there?
I'm still here, Your Honor.
Hey, I don't want to keep you late. Is that we are hopefully going to take a plea on some cases that were on our trial calendar from this morning. I don't know if you've got that calendar, but if there was criminal history information you could share with me now, I'll just jot it down, and then unless Ms. Wood disagrees with it, I'll just rely on that. That way you can be on your way.
I did not receive that calendar this morning. I only have your status conference calendar, Your Honor.
If you had an indictment number, could you look? I don't know what you do to run all your magic stuff.
Normally someone run the records previously. Is it someone that you want me to see if we have a history on?
If it's not, do you know the situation, Ms. Charles?
History, just to verify what we're trying. If we give you the date of birth, would that help?
I don't know. Would you need to actually like print some stuff out, or do you have a computer in front of you where you would be able, if we gave you his information, you could look it up?
I have a laptop. Sometimes we already have their history in the system. I'm not sure who this may be.
Okay. Well, what info do you need about him so you can try to look him up?
Okay. I need his name and his case number and date of birth, please.
All right. His first name is Johnny, Johny. Last name is Hardiman, Hard as in Delta, EMAN. And he's got 3 cases. Can I just give you one of them, or you want all 3?
Go ahead and give me one of them, please.
21 SC 179 555.
Okay, let me see. Let me go ahead and see what I can find out right now, Young.
All right, we've got a date of birth if that helps.
Okay, the date of birth, please.
04/14/2000.
That was April the 14th, 2000.
Yes, ma'am.
Thank you.
Welcome.
Podium, please. Stop right here. Why do you want to?
Put him at the podium, please. Judge, we made it halfway through the plea and really told me that no one wants to enter our plea.
Okay.
So I just want the court to know that.
Okay, well, let's just get a few things on the record. There's no forced pleas here. Ms. Rivers, are you able to take a few things down?
Yes, I am.
Great. We've got Mr. Hardiman here in court. We'll just key this to the indictment that the state said they want to go to trial on, 21 SC 179 555. Ms. Charles, let's get on the record. I think you told us this morning, but we'll get on the record here today. If Mr. Hardiman were interested in resolving his cases today through a plea, what is it that the state would be recommending in contemplation of resolving all these cases plus the unindicted one, which, as I understand it, is less serious than most of these?
Your Honor, the state will be recommending 30 to serve 20 years, balance probated.
Okay, and again, I think you told me this morning, the 20 would be pursuant to an armed robbery count, so they'd be non-parolable.
Yes, Your Honor.
30 serve 20, balance probated. If Mr. Hardiman went to trial and were found guilty of the case ending in 555, what do you envision a recommendation being? I'm not holding you to that, but, well, I'm not going to ask it that way. As I understand it, Mr. Hardiman's exposure across his cases would be 2 life sentences plus another 20-something years. You agree with that?
Yes, Your Honor.
Okay. All right. So there's a swing, 20 years versus consecutive life sentences followed by 20 years if you went to trial and if, the bigger if, you were found guilty in each of the 3 cases. Mr. Hardiman, do you understand what the state's recommendation would be? 20 years to serve followed by 10 years on probation.
Yes, sir.
I'm going to let you say all the stuff you want to say. I just want to make sure you understand what the state's offer is.
Yes, sir. I understand that, Your Honor.
Okay. Now you understand you get credit for all the time you've been in. So 20 is a big number. It's a little less than that because you'll get credit for the time you did. Understand that?
Yes, sir.
Okay. Tell me what your question is.
I just wanted to know, will I be eligible for parole? Like, when would I be eligible to try to go up for parole, Your Honor?
So armed robbery and carjacking are crimes where the legislature, people who write the laws, have said no parole. So you would not be eligible for parole if you are found guilty, well, for the part of your sentence that is armed robbery or carjacking, you're not parole eligible. So let me give you a different example. Let's say that you went to trial and the jury found you guilty of all the counts. I might sentence you to 20 years for the armed robbery, followed by, I'm making this up, 5 years for this gun charge. Those 5 years are parolable. The armed robbery years, whether I give you 10, that's the lowest you could get. We talked about that this morning, that there's not a probation option here, and there's not a, hey, how about time served? With armed robbery, 10 is the floor, and every day of those 10 years is non-parolable. It's not something I can do one way or the other. Next question.
Yes, sir, Your Honor. Is it possible that I can just take the 20, do mandatory 10 here right now and just get out your way instead of wasting your time, Your Honor?
So what you don't do is negotiate with me. What I understand the state was going to be recommending is 30 to serve 20. I don't know if Ms. Wood, you were in a position to make your own recommendation, or if the way you got the state down to 20 in the face of multiple armed robberies and carjackings was that you would be required to make that same recommendation.
That's the 30 to 20 is where the state is, and we were going to put it up non-negotiated.
Okay, so you would be able to recommend 10 years to serve?
Yes.
Okay, so then the answer is yes, Mr. Hardiman. Ms. Wood is going to be able to recommend what you just said, this 20 to do 10, whatever those numbers are. She can recommend that. I'll decide what happens based on what I hear from you and the prosecutor and Ms. Wood about these cases. I don't know you real well. I still won't know you all that well after we have our conversation. But if you choose to go forward with the plea, then Ms. Wood is free to recommend that floor, that 10-year floor, which it sounds like she intends to do, and explain why she thinks that's a reasonable sentence, because 10 years is a long time. Did that answer your question?
Yes, sir.
So knowing that Ms. Wood can make the recommendation you want her to make as your lawyer, and knowing what the state's going to recommend, do you want to go forward with the plea, or do you want us to move this to trial?
I want to go forward, Your Honor.
Say that again?
I want to go forward, Your Honor.
Okay, then let's do that. Why don't we not worry about the paperwork right now, because we've got Mr. Hardiman right here. We've got everyone we need to have this conversation. And why don't we continue on with the record? I got 3 cases in front of me that are yours. My understanding is that you're interested in entering a plea to all 3. You've asked your lawyer, he can have the mask off while we're talking, so that the court reporter can hear him, but thank you for flagging that, Deputy Remy. Mr. Hardiman, my understanding is that you are expecting your lawyer to recommend 20 to do 10, and you understand that the state's going to be recommending 30 to do 20, and I need to figure out what I think the right answer is based on everything I hear. Is that correct?
Yes, sir, Your Honor.
Okay. Ms. Charles is going to put you under oath in just a moment. Once you're under oath, you need to answer her questions truthfully and completely. If you have questions of your own because you don't understand what someone said or something's going differently than you thought it was going to go, will you let Ms. Wood or me know that you've got a question?
Yes, sir, Your Honor.
Okay. Then Ms. Charles, when you're ready, let's do that. And Ms. Jackson, if at any point you get that criminal history and you want to let us know, that's great.
I have it now, Your Honor.
Okay, we're going to do things slightly out of order, just so Ms. Jackson can go. I asked her to look at Mr. Hardiman's criminal history.
All right. The defendant has 5 cycles. The defendant's last arrest was April the 7th, 2020 for hijacking a motor vehicle, and that was in Fulton County. The defendant does appear to have an open case pending for armed robbery, hijacking a motor vehicle, and aggravated assault and possession of a firearm during commission of a felony. That case number is 20-SC-174741. The defendant only has 1 misdemeanor conviction listed in the GCIC. That was in 2019 for fleeing or attempting to elude an officer. Nothing in addition, Your Honor.
All right, thank you so much, Ms. Jackson. Appreciate you being here today.
Thank you. Have a great one, everyone.
You too. All right, so my understanding is Mr. Hardiman has a misdemeanor conviction and then the cases we're working through. Great, when you're ready, Ms. Charles.
Mr. Hardiman, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Please state your true, correct, and legal name.
Johnny Paul Hardiman.
Mr. Hardiman, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
22, and I made it through 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with the following offenses?
Yes, ma'am.
In indictment 20 SC 174741, 1 count of hijacking in the first degree, armed robbery, aggravated assault, and possession of a firearm during the commission of a felony. In indictment 21 SC 179555, 1 count of hijacking in the first degree, armed robbery, aggravated assault, and possession of a firearm during the commission of a felony. And in indictment 21 SC 178901, 1 count of aggravated assault, 2 counts of possession of drugs and/or weapons by an inmate, and possession of a weapon or a knife during the commission of a felony. Do you understand that you're being charged with these offenses?
Yes, ma'am.
Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Woods, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss your cases with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictments?
So waived.
Do you waive any and all defects in the indictments?
So waived for purposes of this hearing.
Mr. Hardiman, do you recall being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, ma'am.
And has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to today?
Yes, ma'am.
For the record, in indictment 20 SC 174741, hijacking in the first degree, 10 to 20 years. Armed robbery, 10 to 20 years. Aggravated assault, 1 to 20 years. And possession of a firearm, maximum 5 years, which could be suspended up.
So we're clear on the record with armed robbery, at least, I don't know if it's true for carjacking. Armed robbery is 10 to 20 or life. Just so you know, I'm not saying I'm going to give you a life sentence, but that is a possible sentence, a legal sentence for armed robbery. That's why I was telling you, if you went to trial, a possible sentence could be life for either of the cases with armed robbery.
Thank you, Your Honor. In 21 SC 179555, hijacking in the first degree, 10 to 20 years. Armed robbery, 10 to 20 years or life. Aggravated assault, 1 to 20 years. Possession of a firearm during the commission of a felony, 5 years. In 21 SC 178901, aggravated assault, 1 to 20 years. Possession of a weapon or drugs by an inmate, 1 to 5 years. Possession of drugs or weapons by an inmate, 1 to 5 years. And possession of a weapon or a knife by an inmate during the commission of a felony, 5 years. Do you understand, Mr. Hardiman, that if your guilty plea is a blind plea or non-negotiated plea, as we're doing today, the state will recommend a sentence to the court? And earlier, the state recommended a sentence of 30 years to do 20 years as a recommendation to the court. Have you discussed this offer with your attorney?
Yes, ma'am.
Do you understand that the court may impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum on each charge?
Yes, ma'am.
Do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once sentence has been announced?
Yes, ma'am.
Do you understand that this guilty plea will be permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a US citizen, Mr. Hardiman?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of up to 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a plea of guilty because you are in fact guilty?
Yes, ma'am.
Mr. Hardiman, how do you plead to the charges in indictment number 20 SC 174741?
Guilty.
How do you plead to the charges in indictment 21 SC 179555?
I'm guilty.
How do you plead to the charges in indictment 21 SC 178901?
I'm guilty.
Is this guilty plea freely and voluntarily given with full knowledge of all of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, as we confirm earlier, Mr. Hardiman has no adult criminal history, but an extensive juvenile history reflecting much of the same crimes he's being charged with today.
Okay.
And had the case gone to trial, the state would have expected to show that on New Year's Day, January 1st, 2020, officers were dispatched to 210 Pryor Street in Atlanta, Georgia. In response to an auto theft call, the victim, Mr. Kyle Dixon, stated that he was getting ready to leave the party. And as he was leaving the party, he dropped his ID on the sidewalk. As he bent to pick up his ID, 2 males approached him, pointed a gun at him, jumped into his car and took off. He said the driver, the person who entered the driver's side of his 2019 Nissan Sentra appeared to be someone he had seen at that party earlier. They were leaving a party, and it was someone he knew locally or casually who goes by the name of Menace. Menace is spelled MENAXE. He then proceeded to give officers the tag of the vehicle. Officers ran the tag, and 8 days later, the vehicle was located at an address 5546 Stony Brook Court, Mableton, Georgia. Officers spoke to the vehicle owner, Ms. Tara White, who advised that she knew the person whose home where the car was, somebody she knows who goes by the name of Uno. Officers subsequently contacted Mr. Dixon again to talk to him about giving a statement and to fleshing out his earlier statement he gave on the sidewalk the night of the incident. And at this point, Mr. Dixon gave a different statement to officers. He then said he had actually known Menace for some time, and he'd known him for friends. He'd seen him at the party, and while at the party, the person he knows as Menace showed him a gun and asked him if he wanted to go out on the town with him to ostensibly hit a lick or commit a robbery. Mr. Dixon said he didn't want to do that. At that point, the person, Hardiman, the person he knows as Menace, put the gun to his side, ordered him outside, get into the car. And when he got to the car, Mr. Dixon said he didn't want to leave with Mr. Hardiman, so he fled. Mr. Dixon said at the time the officers were in the open on the day of the incident. There were partygoers miling around, and so he gave the story he gave because he didn't want to seem like a snitch. But the second account is accurately what happened. He's had the keys to his vehicle taken from him at gunpoint. He also provided officers with a YouTube link which linked to Mr. Hardiman's profile, which is slime, SLINE.menace, MENAXE, which is a video, and Mr. Hardiman is clearly on video, based on the photo in the video, as well as a Facebook profile which matched the same handle of Slime Menace. Officers put together a 6-pack. Mr. Dixon was then able to pick up from the 6-pack photo ID the person he knows locally as Menace, and who was Johnny Hardiman.
And then Mr. Hardiman got a bond.
Yes. At the time, officers also were pinpointed they knew Mr. Hardiman from his juvenile history, and he was a student at the Atlanta High School, the same student, get into much of the same stuff. In the case 21 SC 179555 on December 5th, 2020, officers responded to 2805 Macon Drive Southeast in Atlanta, Georgia, where the victim, Joseph Allen Jr., was at the scene. He said he had known somebody by the name locally of Menace who does videos, posts on Instagram and posts to YouTube. He said he had previously shot videos with the person he knows as Mr. Hardiman or Menace and Mr. Hardiman's friends. On that day, they had met to shoot B-rolls for an upcoming music video. At the end of shooting the video, Mr. Allen approached Mr. Hardiman about payment for a previous shoot that he had done with Mr. Hardiman and his friends. At this point, Mr. Allen states Mr. Hardiman takes out a gun, branches it at him, and says to him, "Shut your pee ass up, give me the keys." Proceeds to take Mr. Allen's phone, some cash, was a dollar bill, and the keys to his 2012 Dodge Charger. They also demand that Mr. Allen take his clothes off and lay on the floor of the building. However, Mr. Allen was able to run out of the building, run down the street, knocked on various doors. Ultimately, Good Samaritan, Ms. Deborah Thompson, opened the door and she helped him call 911, who then responded to the scene, and also Mr. Allen's dad, who responded to the scene. And Mr. Allen was also able to point officers to the Instagram profile known as Slime Menace, as well as the YouTube videos, which go back to Mr. Johnny Hardiman. Officers also had Mr. Allen come in on December 15, 2021, and do a photo lineup, and he also made a note on the ID that this is the person who pointed the gun at him and stole his vehicle and personal belongings. In 21 SC 178901, while an inmate in the Fulton County Jail, officers responded to 7 North Zone 600 because they heard yelling from a cell number 608. Officers noticed an inmate named Koski Hagen standing in the doorway holding his arm, which was bloody. Officers stated he immediately requested for the cell to be opened, and inmate Hagen fell out of cell number 608. Inmate Hagen stated that he had just been stabbed repeatedly by inmate Johnny Hardiman in cell 608 because Mr. Hardiman requested that Mr. Hagen leave his cell, but he didn't exit quickly enough. And so he was stabbed in the arm multiple times. He had to be rushed to medical. 14 to 15 times he was stabbed by a knife, or colloquially known as shank, in the cell. And all of these was captured on the body camera as far as the wounds to Mr. Hagen. And so, Your Honor, Mr. Hardiman's, the cases that he's been charged with reflect a pattern of behavior that is troubling. It's a pattern of behavior that involves violence, unnecessary violence, and almost a reckless indifference to the safety of others. And we believe that our recommendation of 13-20 accurately reflects the severity of all of his charges. And we ask that you follow the state's recommendation. And we'd like to add a special condition here that while he's in custody, that he would get his GED.
Okay. Is there restitution that is owed to Mr. Dixon or Mr. Allen for their vehicles?
No, not in this case.
All right. Thank you so much. Ms. Wood.
Thank you, Judge. Before I get into it, I do want to let the court know this is my last client that is a holdover from Mr. Franklin. And so I believe that is part of the misunderstandings or miscommunications that we've had. Mr. Franklin had a very different perspective of this case than these cases that I have, Judge.
Was Mr. Hardiman one of the cases that Mr. Franklin asked to be put on hold during the pandemic or not?
I believe Mr. Hardiman had gotten out on bonds.
Okay.
Yes.
Before he would have I know he tapped the brakes on a few of them, and we actually put them on judicial hold at his request. This was not one of them.
Not one of them.
Okay.
So for the 20 SC 174741 case, Judge, it appears that in this case, there were another person involved. Mr. Hardiman was the only one to be arrested. Our office reached out to Mr. Dixon, and while his story to us, again, fluctuated, it's my perspective that the state would likely be able to garner a conviction if this case went to trial. So I did just want to share that with the court. 21 SC 179555. Again, multiple males listed involved. Mr. Hardiman is the only one to be arrested. We also spoke to the complaining witness in that case, and again, pretty sure that the state would be able to secure a conviction, judge, based off of his statements. I do want to point out there were no injuries reported by Mr. Dixon or Mr. Allen in either of those armed robbery cases.
No discharge of the weapon, and it doesn't sound like there was a pistol whipping or anything. There was a gun pointed at him, but that was the extent of the force that was used.
Correct, Judge. No physical injuries, albeit emotional injuries,
Sure.
Judge. And then for the 21 SC 178901, while there was an injury there, the gentleman did not require treatment from Grady. They were able to suture that up at the jail. And I do want to point out that incident happened on June the 22nd of 2021, and there are no jail incidents in Odyssey since November of 2021. So since then, Mr. Hardiman has learned to stay on, his own path while in custody, Judge.
Is that because he's been in isolation or he has been in general population?
I've been in general population.
Yes, I've been seeing him on regular floors, Judge.
Okay.
He's 22 years old. He is a lifelong Atlanta resident. As he has stated, he has a 10th grade education, and I am hopeful he will complete his GED while in custody. He has one son, Judge. I know he has some family members that are watching in support on YouTube. Judge, he has served 646 days total on this case. So for the record, he did 74 days from April the 7th, 2020 to June 19th, 2020. And then from February 5th, 2021 to the present day, he's done 572 days. Judge, we are asking the court to consider a sentence of 20 years to serve the first 10 with balance probated. We have no issue with staying away from incident locations, staying away from the victims. I'm hopeful that Mr. Hardiman will be able to enroll in some programs and get some certifications while he is in the custody of the DOC, Judge.
Okay. Mr. Hardiman, where is home? You have family here. If you were getting out tomorrow, would you go to a lady friend's house, your mom's house, your brother's house?
I actually do have family here, Your Honor, but my family have moved around since I've been incarcerated, so I can't keep up with their addresses.
Okay. And I didn't mean a specific address, but are they in the Atlanta area or are they in Gainesville now? Are they in Texas?
They're in the Atlanta area.
Okay. All right. Anything you want to add?
No, sir, Your Honor.
Okay. Well, Mr. Hardiman, I find there's a factual basis for your pleas in all three cases. I also find that your pleas are knowing and voluntary. Voluntary means that I know this is not a moment what you're particularly excited about, but you are here entering these guilty pleas because you've decided, after clearly thinking about it real hard and having some serious back and forth, Ms. Wood, that this is the right way forward for you to enter pleas rather than go to trial. Is that correct?
Yes, sir, Your Honor.
And then it's a knowing plea in that you don't have any questions left about all the things we've been talking about.
No, sir, Your Honor.
Okay, then I'll accept your pleas. I am sentencing you pursuant to the Probation Options Management Act. All that means is that when you're on probation, and you will someday be on probation, if you have minor violations, they call them technical violations, you and probation will work through that. You don't have to come see me. But if it's more serious, you get arrested again, anything like any of these cases, that comes back to me, and then we'll work through whatever the consequences should be. My hope is that when you get out, you are done running with the crews you were running with, and you'll be doing something different, but I don't control that. You do. All right, Mr. Hardiman, I am going to work through these cases in numerical order. So in 20 SC 174741, first, based on my understanding of the factual basis, I believe the aggravated assault merges into the armed robbery. I was doing a little research while you all were talking with me, and they don't merge as a matter of law, They do merge as a matter of fact if the aggravated assault is the force that was used to allow the objects to be taken, the car, the phone, whatever it is. And as I understood it, Ms. Charles, the pointing of the gun, really in both of the carjacking / armed robbery, which is the aggravated assault, was also the means by which Mr. Hardiman acquired the property. So it's not that he shot someone and then later on took their stuff, where there'd be a separate aggravated assault. Okay, all right. So let me get the right count numbers in front of me. And also, as a matter of law, carjacking never merges with armed robbery, but aggravated assault can. So in 20 SC 174741, your sentence as to count one is just want to make sure I do the math right. Is 20 to do 15 with the balance probated. Count two is 20 to do 15, balance probated. Those run concurrently with each other. Count three merges, and count four is 5 years. It has to be consecutive to count one, and I'm probating that. So the total sentence in 20 SC 174741 is 25 years to serve 15 years with credit for all the time that you've served. In 21 SC 178901, your sentence as to count one is 15 years to serve, and counts 2 and 3 are both 5 years to serve, and they'll run concurrently with count one. And the sentence in the case I just mentioned, 901, which is the assault in jail, will run concurrently at the same time with 741, which was the carjacking of Mr. Dixon, the Sentra, which gets us to the final case in terms of indictment numbers, 21 SC 179555. And there, count one is hijacking rather than armed robbery. That'll be 20 to serve 15. Count two, armed robbery, 20 to serve 15. Count three merges into count two. And count four is 5 years consecutive to count one. 1 and 2 are concurrent. Count four is 5 years consecutive probated. So again, a sentence of 25 to serve 15, balance probated, and that'll run concurrently, Mr. Hardiman, with your other two sentences. So I split the difference. You are getting 15 years to serve, credit for the time you have served, followed by 10 years probation. And the only special condition of probation I'll impose is that you get your GED, but I would hope and expect that you would take care of that while you're in custody. But if you don't, when you get out, that'll be a project for you to get involved with. Ms. Charles, anything else in Mr. Hardiman's cases?
No, Your Honor.
Ms. Wood?
No, Your Honor.
All right. Mr. Hardiman, any questions? All right. Thank you, everyone.
Thank you, Judge.
Thank you.
Ms. Wood, thank you for your focus on this one.
Judge,
Yes.
did they electronically?
All right. One last question, Mr. Hardiman. I don't have your indictments to sign. I've been signing them electronically for the lawyers and the defendant. Do you authorize me, Mr. Hardiman, to sign your indictments electronically? Okay, Ms. Wood?
Yes, Judge.
And Ms. Charles?
Yes, Your Honor.
All right. Thank you, Ms. Rivers.
Okay, Judge.